Hello?
We can hear you. The judge will be able to hear you shortly.
Okay. Okay.
All right, ladies and gentlemen, I have 9 o'clock. We're going to call the dockets. I'll ask for announcements from the attorneys. Any litigant who doesn't have an attorney or whose attorney doesn't answer, make sure I know that you're present. LaSalle County, in the interest of Megan and Ryan Rodriguez, children. I'll recall.
Yes, sir. Michael, President Rodriguez.
All right, and who is your attorney?
Cristina Flores.
And have you heard from Ms. Flores?
Good morning, Your
Oh.
Honor. I'm sorry, I was on mute.
Okay,
I apologize. Good morning. Cristina Flores for Mr. Rodriguez.
okay, and you're the respondent, are you the movant?
Respondent. Both, Your Honor. This Miss Rodriguez had filed a motion to modify, and I don't know if she's present today.
No one's answering.
Okay. Well, then we'll ask to go forward. Or we can wait a few minutes to see if she logs in. We were here last. She asked for time to retain an attorney. I've not been contacted by an attorney, and so we'd like to proceed this afternoon.
Now, the docket shows Shannon Holobar. Is that a previous representation?
Yes, yes, because this divorce occurred back in 2017. She filed a modification of child support with the Attorney General. We filed a counter motion to modify and a petition, original petition for enforcement.
Okay, all right. How long to hear that?
I'm sorry?
How long to hear that?
It depends if she's present and with her, or if, I don't know if an attorney's going to appear for the first time today, because I've not received an answer.
Okay, if no one appears, how long to hear it?
I'd say about 15 minutes, 10 minutes tops.
Okay, and her name is?
I'm sorry, Your Honor, it's Patricia Tenery, Patricia Ann Tenery.
T-E-N.
There is an answer on file, and it was done by Mr. Grady Roberts.
And when was that done?
It was filed on February the 8th.
This week, okay.
Yes, sir.
All right, I'll mark you conferring for right now, and ma'am, I'll ask you to check with Mr. Roberts' office in Pearsall. Okay, Frio County case, Alley Financial versus Juan and Diana Morales.
Here, Your Honor, for Ally Financial Incorporated.
Okay,
Yeah, we're ready to proceed.
are Mr. and Ms. Aranda here? Okay, have they filed an answer?
Not that we're aware of, no, Your Honor.
All right, I'll mark you number one. The matter of the marriage of Julie and Juan Garcia.
Present.
All right, and are you ready to go forward with your divorce, ma'am?
Yes.
Okay, I will mark you A. You'll be the first pro se case, that self-represented case I call. I take those up after the uncontested matters with attorneys.
Thank you.
Wilson County, Wagner versus Mendiola. Where do we stand?
Chaz Mendiola is present, Your Honor.
I saw Mr. Ita sign in.
Yes, sir. I was just unmuting myself. Present, Your Honor.
So where do we stand?
We're going to converse shortly, but I'm ready to go.
All right, so that's for a trial on the merits.
Yes, sir.
And how long to hear that?
Actually, we've been trying to communicate for, the only time I ever talked to Mr. Hitt is in the break room.
All right, Mr.
Mendiola,
Mendiola, you'll have an opportunity in just a moment to speak.
Oh, I'm sorry,
Breakout
sir.
room. But how long is this going
Yes,
to
sir.
try if we have a trial today?
right,
An
thank you.
hour.
All right, I'll mark you 60 minutes and conferring.
Yes, sir.
Atascosa County, in the interest of Virgil Roberson, a child.
Good morning, Your Honor. Megan Harkins and Neva Carrillo here for the respondent. I don't see opposing counsel on. Judge, it's their motion, so we'll check in with her. It's Rasheen Mazahari, so we'll check in with her, Judge.
All right, thank you. San Miguel versus Peeler. How long?
Good morning, Your Honor. I would expect this to take about 2 hours. We have 2 motions on the docket today. That's total for both.
Okay. Is that a universal opinion?
Your Honor, Mark Guthrie, good morning, Kiewit Mining Group. I agree.
All right.
These are both motions on statute of limitations, Your Honor, that were filed by the other parties.
Okay, so 120 minutes. And I downloaded the motions.
Thank you.
Tranquilino Morales versus Gloria Talamantes et al.
Good morning, Your Honor. Roberto Maldonado for Tranquilino Morales Jr. This is a motion for default judgment against 3 of 5 parties. David Wilkerson represents the other 2 parties, but they are not before the court today. And David indicated by text this morning that he would not be attending, but today's motion has nothing to do with his clients. I would imagine about 10 minutes.
Okay. Karnes County, Apperson versus EOG. I think you announced about an hour and a half yesterday. Is that still a good announcement?
Your Honor, defendants are ready. That's a good announcement.
Plaintiffs are ready, Your Honor.
All right, mark you for an hour and a half. All right. Segura versus Lupe Ortiz et al.
Plaintiff is ready, Your Honor. We need about 5 to 10 minutes.
Title items ready too. That should be it.
All right, I'll mark 10 minutes. Anyone else told to be here today, your case was not called? No? Okay, good. All right. Let me release the Apperson attorneys until 1 p.m. because I think the Mendiola case is going to take longer than an hour if we wind up trying that.
Thank you, Your Honor.
Thank you, Your Honor. Do we return?
Wait, I'm sorry. Y'all announced an hour and a half the other side, and let me release Peelers until 1 p.m. The Peeler versus in San Miguel case, because they announced 2 hours, y'all announced an hour and a half. I think that's probably pretty close. So I'll ask y'all to hang out for a bit, and we'll see if we have to try the Mendiola right now, and I'll do the other short things in the docket.
Thank you, Your Honor.
Okay. Ms. Flores, were you able to contact Grady Roberts' office?
Yes, Your Honor, I just spoke with him. He said he's in court before Judge Ellison, filed a motion for continuance, and we've agreed we're going to confer on this matter. So if we can get a brief reset date, hopefully we can work this out.
Okay, who is online from the coordinator's office?
It's myself, Judge. How about February 25th?
That works for me, Your Honor.
Okay. All right, if you will just send me a message in chat with the cause number, name, and that date, you are released.
Thank you, Your Honor. Will do.
You'd also notify Mr. Roberts since he's not here right now.
Will do. Thank you.
Thank you, ma'am.
Thank you, sir.
Thank you, Judge. Bye.
Thank you.
All right. So let me sign into Frio County so I can look at their documents.
Travis. Is this the answering service? We're in court right now. We're supposed to be in a breakout room.
Or there may be other people that need to. Okay. All right, so give me just a moment to look at the files in this case, and I'll be right back.
Mr. Hita and Travis Mendiola, I'm gonna put y'all in a breakout room. Number 1, okay?
Yes, ma'am.
Thank you.
All right, Frio County, Alley Financial versus Aranda. I've pulled the district clerk's records. There's no answer on file. Both returns of service are in the proper format, and they've been on file for more than 10 days. Go ahead, Ms. Phillips.
Yes, Your Honor, this case stems from a vehicle retail installment contract. The account was opened, or the contract was signed on September 3rd, 2015. The last payment on the account was July 17th, 2016, and the account was closed October 20th, 2016 with a closing balance of $17,000, $292.59. Those are the damages that we're asking for today, along with court costs. You should have on file the affidavit that we have from Ally Bank, along with the deficiency statement from the sale of the vehicle. And yeah,
Okay, what would that be filed under?
excuse me.
What would that be filed under?
It is under, I think there was a motion for default judgment filed February 28th, 2019.
Okay. All right, let me look just for a moment.
Okay.
Your Honor, it's dated March the 4th, 2019 for the district clerk's
Okay.
LGS record.
Okay.
Okay, and this was set on a dismissal docket, but it looks like that didn't happen because COVID intervened and the Supreme Court told us to stop doing DWAPs. All right, so let me look at the motion. And do you have your military service affidavits?
Yes, yes, sir. They should be in with the motion.
Okay. Well, it doesn't want to show it to me. Here it comes.
Okay.
All right, without objection, I will admit all of the affidavits attached to the motion for default judgment. I'll take judicial notice of the entire contents of the clerk's file. Good, ma'am.
Okay.
Go ahead.
Oh, I'm sorry, Your Honor. This is I was just covering. I usually
Okay.
do justice of the peace court, so I'm not sure.
Okay. Do you have a proposed order?
Yes, sir. It's with the motion for default judgment. It should be attached to it, the last page of the
All right.
motion.
And do you have a copy of that with you?
I can send one to the court if
If you could just post it to me in chat, just in PDF format.
okay. I'm on my cell phone. My work computer does not have video
Okay.
capabilities.
All right, then that's fine. Go ahead and just please e-file your proposed order, because there's one more thing I want. I don't know how old these people are, but your military service affidavit is about 10 days short of being 2 years old.
Okay.
So I want a more current military service affidavit. So assuming that doesn't come back from Department of Defense that says they're in the military service,
Okay.
I'll grant the default judgment.
Okay. All right. I will let the office know. Thank you, Your Honor.
All right, you're excused. Good luck.
Mhm.
Okay, let me go ahead and do the Garcia divorce while I have Frio County pulled up. All right, calling 22-00065 in the matter of the marriage of Garcia.
I'm here.
Do you swear or affirm that in the case now on trial, the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And you're married to Juan Garcia?
Yes.
Where is he?
Not present.
All right. The copy of the proposed divorce decree that is filed with the clerk is not signed by Mr. Garcia.
Correct. He refused to sign it.
Okay. All right, ma'am. He did sign a waiver of citation. Okay. There's two different types of waiver of citation that a person can sign. One of them says, I waive citation, I waive everything, judge, you do whatever you want to do. I don't want to hear any more about this. The other one says, I waive making the plaintiff go out and hire the sheriff to serve a copy of the papers on me, but nothing else.
Okay.
So if he is not present and agreeing to the divorce decree, or present and we have a trial, or he signs off on the divorce decree, if one of those three things doesn't happen, then I can't proceed because he specifically stated in the waiver that he signed that he was not waiving his right to have notice of a trial or his right to be present. So what you're going to need to do is get with the coordinator's office, get a date down the road that you can be available, and give him notice, certified mail, return receipt requested at whatever address he put in his waiver of citation.
Okay. Or if I could get him to sign the.
Well,
the
he didn't
final-
actually put a mailing address in there.
Okay, but
Well,
if I can.
whatever address
get-
you have.
If I can get him to sign the final decree, that works as well?
Yes, or just to show up and say he's ready to proceed. Either way. Before we do that, I need to ask you a couple other questions to make sure we don't have something else that comes up.
Okay.
One, how long have the two of you been married?
21 years.
All right. And how many children have been born to you since the date of that marriage?
3.
Okay. And is Juan Garcia also the father of all of them?
Yes.
Okay. And are you expecting a child right now?
No.
Okay. All right. The next thing I need to talk to you about is community property. The law in Texas presumes that every single thing a married person owns is community property.
Okay.
So it's not a matter of whose name is on a piece of property. It's not a matter of whether you and Juan Garcia have a dispute over who's going to get a piece of property. If the divorce decree doesn't either say it is community property and here's how it's being split up, or say this is not community property, that's why it's not being split up, and here's who gets it. If that doesn't happen, then the law presumes that I, the judge, forgot to divide part of your community property. And it also presumes that you and your ex-husband would own it together. So automobiles, retirement, cattle, house, land, anything that's valuable enough that there might be a lawsuit over it someday in the future, you need to make sure that it's spelled out in the divorce decree who gets it. Okay?
Okay.
All right, I'll put reset on request and I wish you good luck, ma'am. I'm going to be on here a long time today. So if you are able to get him to either sign off on it or to show up, you can sign back in and I'll be available for quite a while today. If not, just to get with the coordinator's office and send him whatever address you have for him, a notice, a certified mail return receipt requested, telling him when he's supposed to be in court on Zoom.
Okay, thank you.
Yes, ma'am. Good luck. Okay, let me get out of Frio County and sign into Atascosa County. right. And Ms. Carrillo, did you have an announcement in your case?
Your Honor, Megan is the one that's taking over on this case.
Oh,
Is the
okay.
lead.
All right, Ms.
And
Harkins?
Judge, yes, Judge, I left Ms. Mazahari a message and I sent her an email and I have not heard back, but I do see a
I'm
square
here.
that looks like, oh, yes, hello.
Hello.
Okay, great.
Okay. All right. And do you need to confer? Do you have an announcement?
Judge, we'll confer for a few minutes. If we can't narrow or settle, we probably need 2.5 hours. But I would like to confer.
All right. Go ahead and confer. I've already got a number of hours set, and you would be at the end of the day because everybody else has announced less than that. So go ahead.
Yes, Your Honor, and this is temporary orders, so we anticipated that it would be shorter, but we'll confer since we're last.
Yes, and we do have a local rule that limits temporary orders to 1 hour, but I'll let you confirm.
Thank you, Judge.
I'm going to sign you out of breakout room 2.
Thank you.
All right, Mr. Maldonado, who are you trying to take a default judgment against?
Against 3 of 5 defendants in a trespass to title suit, Your Honor.
Okay, and which 3?
It is going to be Elvia Chapa, Diana Hernandez, and Jesse Leal.
Let me. All right, here's Jesse Leal citation. Return. Okay. All right, Ms. Benavides, I just posted, I get an error message whenever I try to look at Atascosa County documents. So let me go back and I see there is a Jesse Leal return of citation.
Did you need for me to look that up, Judge?
Well,
Oh, you know what? It might be. Let me see if our
this happened earlier this week also.
it might not be connecting to our network. Hold on just a second. Let me check real quick.
Okay, I see affidavits of service. I see amended affidavits of service. Is that on the people you're trying to take defaults against?
Yes, Your Honor.
No, I'm still getting an error message. Okay. All right, so what I'm going to ask Mr. Maldonado, if you can, do you have copies of all of your returns of citation on these people?
Yes, Your Honor.
Okay, if you could post PDFs of those to me in chat, I'll look at them. I always want to see the returns. You'd be surprised how often if you don't have a professional process server, that they're not correct.
And we did, but we certainly will, Your Honor.
All right, I appreciate that. Just post them to me in chat and I will look at them and get back with you.
Thank you, Judge.
All right, so let me sign out of Atascosa and go look at Karnes County. Actually, hold on just a minute. Okay, I can look at them now. Hold on.
Judge, I'll be right back.
Go ahead. All right, Mr. Maldonado.
Yes, Your Honor.
Okay. All right, I see there's an amended return on Elvira. I have not looked at the initial one.
Okay.
Do you know what the difference is before I pull them up?
Yes. There was a clerical error on the date by the process server that he needed to correct.
Okay. All right. The order that was signed for substituted service said that it had to be served by affixing a copy on the alternative service to the door or gate, or it had some options. And it said also by sending a copy to that address, first class mail.
I believe that's correct, Your Honor.
Okay. Your amended affidavit of service, I don't see where it says that it was sent first class mail. And it also doesn't say who it was sent, who it was served on. It just says it gives the address. And that doesn't comply with Rule 107. And you know how the Court of Appeals is. I'm not criticizing it, but if there's any discrepancy at all from the strict reading of the Code of Civil Procedure, they're going to throw it out. So you need to, if it was served by first class mail, you need another amendment to say that, and you certainly need an amendment to show that who it was served on, because it's
I'm happy to do that, Your Honor. Can we get this case reset to your next available docket?
okay. I'll let you get with the coordinator's office, and you might need to check with your process server to see if that was sent by mail. And I think it has to be on file for 10 days. So just get with the coordinator's office. And
We'll be happy to do that. May I be excused for today, Your Honor?
yes, sir. Have a good day.
Thank you, Your Honor. Goodbye.
All right, now let us go and go to Karn's. Right, and Mr. Rao, Ms. Kopecki, or who are you trying to take a default against?
Good morning, Judge. It's against Lupe Ortiz and or the unknown heirs, successors, and assigns of Lupe Ortiz.
And I'm the ad litem for Lupe Ortiz.
Okay, so is this a default then, or?
It is, Your Honor.
I've been unable to locate him, and there's some conflicting information about whether he's alive or not, but have found his only heir, and I believe she was served individually, and has that been resolved, Ms. Kopecki?
It has. She signed a deed conveying her interest in the property to our client, so we're non-suiting the claims against her.
Okay, so Mr. Ruiz has not been declared dead, but he was homeless. He's 87. His daughter had not heard from him in a while, so.
Okay. Okay, and what is the nature of this lawsuit?
It's a trespass to try title suit.
Let me look at your petition. All right, go ahead, ma'am.
We're here this morning. We're asking for a default judgment against Lupe Ortiz and or the unknown heirs, successors, and assigns of Lupe Ortiz, who were served with process by citation by publication on June 11th, June 18th, June 25th, and July 2nd of 2020. The publisher's affidavit was filed with this court on July 8th of 2020, and as of today, the defendants have not filed an answer or otherwise appeared. The return of service has been on file for more than 10 days, not including the date of filing or today's date. And with that, I will turn it over to Mr. Rao.
Mr. Rao?
Judge, I was appointed as ad litem in this case. I did some internet research. I also talked to Ms. Segura, I believe is correct, who had an interest in the property before. It turned out she was Mr. Ortiz's daughter. She is the only daughter. She said she had not had contact with Mr. Ortiz in, I believe it was over five years, may have been over 10, but certainly over 5. He was homeless the last she knew. He, again, would be quite advanced in age if he's still alive. She had suspicions that he was not. But again, she was his only heir. He was not married at the time. He only had the one child that she knew of. And she has, I suggested to Ms. Kopecki they serve her out of an abundance of caution or have her sign off on a deed. They did both, I believe. And so she has signed off on a deed. Based on that, based on the facts of the case, which is basically, it looks like that his interest was supposed to have been conveyed when his wife's interest, his ex-wife's interest was, and it for whatever reason was not, it was lost at a tax sale. I believe his interests have been fully protected, but I have not been able to locate him or determine even his whether he's alive or not.
Okay, and the Seguras are, they and their predecessors entitled, if any, they've held title for more than 10 years, had possession for more than 10 years in their color of deed, all those things?
Oh, yes, yes, sir.
Okay, all right, so is this a default or is this on the merits?
I think we could call it either one, Judge.
All right.
I don't know.
Without objection, I'll take judicial notice, the entire contents of the court's file and of all the affidavits filed therein and admit them into evidence. Okay, do you have your proposed judgment?
I do, Judge. I just put in the chat.
Statement of evidence, I'll admit that into. All right, give me a chance to download all of these and I'll sign them. Right, if you want to send your affidavit from Mr. Sahura directly to the clerk's office, I will post these documents. Okay. So does that dispose of everyone, or are there still other defendants?
That takes care of it. If you sign the non-suit,
I did.
then that is it, Your Honor.
All right, I'll put down final judgment. Okay, you're excused. Have a good day.
Thank you, Judge.
Okay, we'll come back at 10 after and get started on the Epperson case.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Mr. Ita, do you have an announcement? See here?
Judge, he posted that him and Mr. Mendiola were in agreement to reset the case to allow his client and wife to be present. And then I sent him a chat back saying, how much time are you requesting? But it looked like he had left the meeting. So I'm not sure exactly when he wants it reset for.
I'm here, Your Honor.
And where is Mr. Ita? Do we know?
I don't know. He said that he wanted to reset it for another day, but you know, I was trying to get a jury docket setting, so I don't know.
All right, sir. Okay. Do you understand we're not having jury trials at the moment because of COVID, and that there's going to be a huge backlog of criminal cases? So I don't know if there's been a jury demand filed. I don't know if it's been waived. I don't know if jury fees been paid. But you understand, sir, that it's going to be a very long wait for a jury in all likelihood.
Yeah, I would just like to, because I feel like I could better explain
Okay,
myself.
and I'm just letting you know that, Mr. Mendiola. Okay. Set it on a jury docket, and if there's a motion to move it because it should be jury, then I'll take that up at that time. Ms. Riley, I'm going to ask you to set that on a Friday with nothing else for at least half a day, because the next time this is set, it's going to be tried or it's going to be moved to the jury docket.
Okay, I'll check your calendar and get that set.
All right.
Thank you, Your Honor.
All right.
Okay.
Yes, sir.
Okay, thank you, sir. Have a great day.
You too. All right, Apperson.
Thank you.
Is it just the evidentiary objections, or is there other things?
Just the evidence, Your Honor.
All right, give me a moment. All right. Take up the first motion for summary judgment evidence first or second?
Your Honor, I think we can take it all together. So basically, there were 4 rounds of evidence from the plaintiffs. The first one used a different numbering convention, but with one exception being a Greg Robertson declaration, the actual substantive attachments are identical. And so I think what would be the best use of court time is to just take up the second round of objections, and then I could cross-reference the numbers back to the first one as we submit an order or something like that. With just the way it developed, the second one captures everything except for one exhibit out of the first one.
Okay, any objection to that?
Your Honor, I'm happy to proceed however the court would like.
Go ahead, sir.
Thank you, Your Honor. The first one is at our page 2. And this is just the objection to the recitation in the plaintiff's papers of relying on, quote, the pleadings on file and, quote, other papers on file in the record of the case as part of their summary judgment evidence. Under Rule 166AC, that's not proper evidence, just to start with. Under 166AD, they have a specificity obligation to direct us to what that would even mean. And in the case that we've cited there, the Laidlaw Waste versus City of Wilmer case, Texas Supreme Court opinion from 1995, 904 Southwest 2nd, 656, pleadings are not evidence. And as you go through all of the plaintiff's papers, they also never purport to cite back to any motion or pleading or anything of that nature that would even be evidence. So we would ask that reference to reliance on other pleadings, motions, and papers on file in the case be sustained and that be stricken.
Mr. Kilday?
Your Honor, we'd like to stand on that statement. In the course of the case where you have a global no evidence motion for summary judgment, sometimes there's a lack of transparency about exactly what's being alleged. And this came up just yesterday in connection with the I'll call it a disingenuous gotcha argument that came up in connection with the no evidence motion, that somehow because there's no specific evidence of the production costs relating to EOG's prolific production in the last few years, which the defendants have said in open court generated tens of millions. I even heard $80 million worth of royalty payments to the defendants. And now the defendants are alleging that somehow there's a need for proof of EOG's expenses associated with those royalties. So we do wish to rely upon the judicial admissions and statements of the defendants in their pleadings and in open court in order to support issues such as that, which were never squarely raised in any of the motions, but came up after all responses were in. It's never been an issue in this case that EOG's prolific production the last several years has not been in paying quantities. I think Mr. Trust would certainly stipulate that it has been in paying quantities, and it's clear that it is in paying quantities. So we do wish to rely upon the various statements by the defendants in support of our response to the no evidence motion. And we didn't have the opportunity to point to specific references such as that because that issue was never raised until the last couple of days.
May I briefly be heard on behalf of EOG since EOG was invoked there, Your Honor?
Yes, sir.
I'll just decline any invitation to stipulate in an open hearing as patently inappropriate. And we do not have the burden of proof on any of these things. These are plaintiff's burden of proof. And plaintiff either meets that burden or plaintiff does not.
I believe the way the jury instructions are written on paying quantities, it's actually the burden of proof on the party wishing to show a lack of production in paying quantities. But nevertheless, what I'm saying is there have been statements in this court and in pleadings, but certainly in this court in connection with the hearings about the voluminous production from EOG in recent years. That was never a point that was squarely raised, that there was a lack of production in paying quantities by EOG. And so we think that this objection should be overruled.
Swimmer.
I mean, it's just black letter law in Texas that pleadings, motions, papers in the case are not evidence, and they certainly have directed the court. We would stand on the Texas Supreme Court's holding in Wilmer and 166 AD and ask it be stricken.
Your next objection?
This goes to the Brandt deposition testimony, and we've filed voluminous objections, but basically it all can be aggregated into 3 groups. And so I'll just take it that way if it pleases the court.
And this is on page 3? You're just going straight ahead or are you jumping around?
I'm jumping around to just try to make good use of the court's time and get to the most important stuff first. This is going to start at page 13. And they used Exhibit 4 deposition excerpts of Mr. Brandt. And then those objections to every single question run through page 31. And then Exhibit 10 is also the deposition of Mr. Brandt. They, for some reason, put it in 2 different places. The objections to the Exhibit 10 testimony of Mr. Brandt start at page 38 and run through page 41. The 3 categories of testimony that are an issue there fall into 1, Mr. Brandt opining without designation as an expert on production and paying quantities. 2, opining without being designated as an expert as to reasonable diligence to restore operations or to conduct operations. And 3, testimony about royalty payments between the years 1983 and 2014. If it pleases the court, could I take up the production and paying quantities groups of testimony first?
Yes, sir.
I have a short PowerPoint presentation that I think will help us get through this.
Go ahead.
Thank you, Your Honor. I'm not going to belabor it, but here I'm showing you at page 364 from Mr. Brandt's testimony, where he said he never performed any kind of analysis of revenue against expense associated with the Snitz-Rydell well, that he never went in and actually looked at what were the costs. And with respect to the actual test that's laid out by the Texas Supreme Court in cases like Clifton versus Coons and Ladix, he never considered what a quote reasonable period of time was and had no opinion about that one way or the other. And so it's obviously production and paying quantities. The law of the state of Texas and certainly in Karnes County is that if you're going to have testimony of that nature, it needs to be qualified expert testimony. I don't need to belabor what goes into analyzing recurring costs. I don't need to go into what is required to analyze the revenue. And once it's not profitable, going into analyzing whether a reasonably prudent operator would continue to operate for a profit or not. In addition to just the global objection that he's not designated or qualified under 702, there's individual question with respect to each one of these questions. There were form objections, and the form objections were premised on things like it being compound, it being vague as to time, the questions being leading, the question calling for speculation out of the witness, and the question not laying a predicate with a foundational showing of knowledge, 602, personal knowledge of the witness to testify about it. It's also self-serving. It would also be hearsay in that, to the extent you're talking about costs or anything else, he'd be relying upon records that would be outside of what's before the court here. And so I have a group, and just so that we have it in the record and I can follow up with a written paper, but the objections to the production and paying quantities testimony out of Mr. Brandt is pages 52 to 55, 56 to 58, 75, page 80, page 90 to page 91.
And is that his deposition?
Yes, Your Honor.
Okay, because I don't have that many pages in this motion. All right, go ahead.
Yeah, I apologize, Your Honor. The page references are just for the record here. These are the groups of testimony that pertain to the production and paying quantities testimony that we've objected to in writing for the reasons we've stated. Page 106 of his deposition, page 111 through 115 of his deposition, page 330 to page 331 of his deposition. I'm happy to pull any one of those up as an exemplar. And actually, if we could get that, I'm going to publish exhibits 4 and exhibits 10, just as again, we're just trying to make good use of the court's time.
Okay.
This is an example. So where I've highlighted in yellow, these are the places out of the testimony that there's written objections on file. If we could just go to page 90 as an example. So if we start at page 90, 13, this, and like I say, anywhere in the ranges I've just given the court, I'm happy to go into. But so Mr. Kilday asks, and isn't it true that Carbon's production during that time was in paying quantities? Answer is yes. So this is what the plaintiffs are trying to use as evidence in this case. Again, one, he hasn't been designated, but there's a form objection. Mr. Kilday, on all these form objections, never went back and asked for a basis for them or anything like that. This is all preserved in addition to the substance. And so my form objection here is that that's compound. What he's inquiring about there is a period of time spanning between 1983 and 2014. That's not how production paying quantities analysis is done on a, whatever that 20-something year period of time. It's leading. It doesn't show that Mr. Brandt has personal knowledge of the expenses. It doesn't show that Mr. Brandt has personal knowledge of the revenue. It doesn't show that Mr. Brandt undertook a comparison of revenue against expense. It doesn't show that Mr. Brandt even knows what quote paying quantities is. And elsewhere in the testimony, he actually said that his understanding of paying quantities was just if the well is producing, if there's hydrocarbon coming out of the well, that's what he thought paying quantities was. So that's just an example. If you go to the next one, and that production out of that well was sufficient to cover Carbon's operating and marketing costs. Again, this question and the answer would never, if I wasn't in a deposition setting, if we were doing this in front of 12 impartial jurors in Karnes County, Texas, that question would have been sustained and the jury would have never heard the conclusory answer purporting to wave a hand in an unqualified fashion over 20 something years. With respect to the cessation of operation, I'm just going to go to an example of that. Can we go to page 90 of the deposition? We're moving on to category number 2 at line 7.
Your Honor, would it be best if I respond to these in sequence since they're in 3 groups, or do you want me to wait and respond in toto after he's gone through all of these?
Or do you have totally, Mr. Weimeyer, on this point?
There's a grand total of 3 categories, and this is the second one. I did just conclude the first one about production and paying quantities.
Right. Let's just do it one at a time. So go ahead, Ms. Kilby.
Thank you, Your Honor. So this is asking about items that are rationally within the knowledge of the witness. Under Rule 701, lay witnesses who are not designated as experts are allowed to give opinions as long as those opinions are rationally based upon the witness's perception and it's helpful to clearly understanding the witness's testimony or to determining a fact in issue. This is not a witness like Gary Gonzenbach, the defendant's expert witness, or Greg Robertson, the plaintiff's expert witness on paying quantities. This is not someone who's coming into this new to try to analyze someone else's records with which he is unfamiliar, to try to make an analysis anew about whether or not something that historically happened in the past was or was not producing and paying quantities. This is someone who lived through this as the president of this very small company that had very few wells. So when I ask him whether or not there was production in paying quantities from 1997 to 2014, that was a time period he lived through. That's something he has personal knowledge of. That's something that he has familiarity with. And the deposition testimony that we included includes Mr. Brandt's statement that if any of these wells had ever been unprofitable, that's something he would have known about. And they were not ever unprofitable. They were always earning a profit. They were always covering the production and marketing costs of carbon in every instance on both wells. Those are items that are within his knowledge, and those are items that he is entitled to give opinions about. In fact, I would argue that these are facts. When it comes to Mr. Brandt, these are facts that he's testifying about, not opinions. When Mr. Gonzenbach or Mr. Robertson takes a look at it historically after years have passed, when they weren't personally involved, they're giving opinions. Mr. Brandt is giving the court facts that he was aware of at the time and that he can testify about. All of these questions that Mr. Weimeyer is raising are questions that go to the weight. They don't go to the admissibility. He's certainly entitled to cross-examine, as he did for many pages, as the court has seen, but we're entitled to ask him his fact recollections about whether or not this well was making a profit and covering marketing operating costs, and that's what we did. I would also say that there's been a suggestion that there were leading questions. First of all, this is not our witness. This is not a representative of the plaintiff. This is a neutral third-party president of an operator that none of the plaintiffs have ever met or worked with. They just receive royalty checks from him, just like the defendants and their predecessors did. So this guy is on neutral ground. He's not our witness. He's not the defendant's witness. So I believe both sides are entitled to ask leading questions of him. But secondly, more importantly, Rule 199.5 C sets forth the objections that must be asserted at the time of the deposition to preserve them. And all that was preserved was objections as to form. Objection as to the leading nature of a question is a separate objection that must be independently asserted at the time of the questioning. And that was only done in 1 or 2 instances here. All the excerpts you've been shown, there's lots of objections to form, but no objections to leading, and that would not be a proper objection, even if it had been preserved. As to reasonable period of time, you were shown some questions where that was discussed. There were questions that you were shown yesterday by Mr. Waymeyer, where he was asked what he understood that to be. And he gave a very accurate and very proper answer that it depends on the circumstances in the well, but he would think it would be a period of months, maybe 6 months. All of that is fair game. All of that is proper. He's given what he thinks on that, and he's entitled to do that. That's rationally within Mr. Brandt's perception, and it's helpful to the trier of fact and helpful in clearly understanding Mr. Brandt's testimony. So all these objections should be overruled, Your Honor.
Right. Mr. Wimmer or anyone else?
Again, Your Honor, if it's absolutely expert testimony, he doesn't have one case in the entire state of Texas that would say that reasonably prudent operator standard or that production paying quantities is appropriate for a lay witness. And the Texas Supreme Court is not going to make that the law in the state of Texas. If he gets past that, you saw the compound nature of the questions, the leading. If he's got a case that says an objection form doesn't capture the leading aspect, that would be, I'm happy to be told I'm wrong on that, but I'm not aware. I've never had that ever enforced in any trial that I've participated in that form didn't also capture leading. Leading would not capture form, but form captures leading. It is how I've always had judges apply it, but I'm happy to be told I'm wrong there. With respect to the, and again, like I said, I mean, the idea that in Texas, we're going to have lay witnesses testifying to production paying quantities in reasonable periods of time, and that we can do it in waving your hand over 20 something years is absurd. And he hasn't, again, there's a foundation objection in there too, and he never showed a foundation for witnesses' knowledge.
Hey, let me ask about the designation as an expert. Does that not matter if you're saying he's a lay expert, or is he a real, I mean,
there's no such thing as a lay expert, Your Honor.
lay opinion, yes.
A lay opinion, I would agree that if
let me ask Mr. Kilday though. Let me ask.
Yes, what we're saying is he's not an expert. He's someone who has personal knowledge of these facts. He lived through them. He's the president of the company. He would have been aware if they were losing money. He would have been aware if they're making money. He's giving fact testimony about the facts that underpin the ultimate conclusion of production and paying quantities, which is, are you earning revenue that's sufficient to pay operating and marketing costs and return at least a small profit to the operator? That's a fact that is an underpinning of the opinion of production paying quantities. So I'm saying he's giving fact testimony, and to the extent anything that he's giving constitutes an opinion, it's an opinion under Rule 701, not an expert opinion. It's a lay opinion for which no expert designation is necessary. And there's lots of case law, Your Honor, on this about people who are involved in a company can give opinions about how much money they earned or how much money they didn't earn on damages analysis and in other contexts where you don't have to be designated as an expert when you're personally involved with it.
All right. Mr. Wimmer, your next objection or
Thank you,
next
Honor.
category?
Thank you, Your Honor. And I think the reporter's record is going to reflect that Mr. Kilday agreed on the record on day 2 of these proceedings that production paying quantities was an expert issue requiring a battle of the experts. Those are his words. With respect to the next category, that is the cessation of production doctrine, the temporary cessation. I showed the court yesterday where there was over 120 days consecutively of goose eggs in the production. That's a complete absence of production that would cause termination in the absence of Mr. Kilday being able to show reasonable diligence to restore operations. And then in 2013 to 2013, there was an additional 60+ day period of goose eggs. he doesn't have any evidence whatsoever as to the second period of goose eggs. With respect to the first period of goose eggs, he tries to close that with invoices for work performed. I don't have an objection to those. That invoices are evidence, but they're not evidence that meets his problem. What he needs is evidence as to the reason that the invoices correlated with and corresponded to reasonable diligence during that time frame. I'm just going to give an example, and let me get this in for the record. The objections to Mr. Brandt's testimony on cessation of operations comes from pages 90 and 106 through 107 of his deposition. Here's an example on where at page 90, he was asked, regardless of when Carbon stopped paying the term royalties, isn't it true that Carbon continued to produce oil and gas out of the Schnitz-Rydell well continuously from 1997 and June of 2014? I showed the court yesterday in the plaintiff's own evidence at Exhibit 2G that test, when he just agrees with Mr. Kilday in response to a compound, vague, and leading question, that's categorically false. There was over 120 days of goose eggs in 2010. There was over 60 days of goose eggs in 2013. So the testimony is just completely false and proved false by the Exhibit 2G in the record. But it's compound, and he doesn't have the expert designation or qualification to opine as to reasonableness. If we go to page 106, this is the second place. And I think we'll start at page 20, at line 21. So here's an example. The question of plaintiff's counsel was during the time period of late 2010 and early 2011, was Carbon acting with diligence to resume production from the Schnitz-Rydell well within a reasonable period of time? And in response, there's a form objection that is leading, it's compound, it doesn't show a foundation for the witness's personal knowledge. And he says, certainly did. And then in the next portion, he asks for speculation and says, why was it important to Carbon and why was it important to Carbon to act with diligence to resume production? He says, because we had a 60-day clock on the lease. So you don't have to take my word for this reasonableness being the correct test and this being a matter of expert nature. This comes out of the plaintiff's own evidence. I'm going to publish Plaintiff's Exhibit 14D. This is Mr. McFarland's email correspondence to EOG. And let me see if I can't get in. You see Mr. McFarland's choice of underlying at the bottom. What Mr. McFarland is emailing to EOG in response to knowing that they had the goose egg problem was that, quote, where an oil or gas lease is produced in paying quantities within the primary term of the oil and gas lease, and the cause of cessation of production was thereafter necessarily unforeseen and unavoidable, and where the lessees in good faith used reasonable diligence to resume production and at great outlay of money and did within a reasonable time in view of the conditions disclosed by the record resume production, the estate did not terminate as a matter of law because of temporary cessation of production. You can take that down. I'm sorry, I gave you the wrong reference. That's Plaintiff's Exhibit 14C for the record. So there were 3 layers of reasonableness in there. There was a good faith element. There was a reasonable diligence to conduct the operations, reasonable operations, and there was a reasonable time frame. All of these are expert issues in the state of Texas. Mr. Brandt hasn't been qualified or designated one. If the plaintiffs tried, we would have certainly had a Robinson motion to have something to say about that. And so we would ask that the specifically enumerated sections out of the testimony be stricken for those reasons, and there's additional bases for those in our written objections that we'd ask be sustained as well.
Kilday?
Your Honor, my argument on this is going to sound familiar, so I can keep this one a little bit more brief. These are issues that are rationally within Mr. Brandt's own perception because of his personal involvement with these wells and with this very small company operating these wells. He is not coming in as a third-party expert to examine a bunch of documents and then give opinions to the court as an expert. concepts like whether or not someone was acting reasonably or in diligence, when you're asking the very person who is the president of the company operating the well and has personal knowledge of it, he can testify that his company acted with diligence. That is a lay opinion that's rationally within his own perception, that's helpful to understanding his testimony or helpful to the trier of fact in understanding the issues. That is a straight up lay opinion under Rule 701. And Mr. Waymeyer is correct that we both have experts on matters where retained experts, third-party retained experts who were not involved in this like Mr. Brandt was, who would need to be qualified as experts in order to render their expert opinion under Rule 702. That is not Mr. Brandt. Mr. Brandt lived it. He was the operator. He was the one with knowledge. He was the one living through this, and he can testify about whether or not there was ever any cessation of production that was for an unreasonable period of time. He can testify about whether or not his company was or was not acting with diligence to bring production back online. Those are lay opinions under Rule 701 when it's of the person who is involved as the operator. So all these objections should be overruled.
Would Mr. Brandt, though, have to say that he knew what the standard was for that to be a legal opinion? By that, I mean, it's unlikely he's going to come on and say, no, I think that we acted unreasonably. But would he have to be, would he have to say, I know what the standard is in the oil and gas business, and we met that standard?
Your Honor, he's giving his rational perception of himself as a witness who was involved in this, and he can give that lay opinion under Rule 701. He's not being presented as a legal expert. No one's asking him the legal definition of any of these issues. He's, again, the ultimate legal conclusions depend upon testimony, and some of that testimony is retained expert opinion. Some of that is simply a fact, and he can talk about what they did and when the well was offline and what steps they took to resume production and how long that period was, whether it was reasonable in his lay opinion and whether or not their actions were diligent in his lay opinion.
Certainly, but does that amount to expert testimony that it was reasonable?
No, Your Honor, when it's
diligence,
not when it's coming from the person who was in fact the operator. I agree that if anybody else were to come as an outsider and render an opinion about Carbon's conduct, looking at their documents, listening to the testimony, and as a third party opinion giver, that would be expert opinion. But when it's coming from the operator, him or herself, talking about their own conduct, then they're allowed to give that as a lay opinion under Rule 701. This comes up a lot in the context of damages and whether or not things were profitable or unprofitable, whether or not there were losses. And courts routinely say that the company actors who have knowledge are able to give that, and it doesn't need to be designated as an expert opinion.
Your Honor, may I be heard very briefly?
Yes, sir.
I took the witness on voir dire, and I have an exact answer to your question, and it's sworn out of his mouth. Can we go to the bottom, please, here? This is page 172 of Mr. Brandt's sworn testimony. Let's go up a little bit. There we go. We're at page 172, line 2, and Mr. Brandt was asked by me on voir dire. Now, in terms of, are you familiar in Texas with the term of art called, quote, a reasonably prudent operator? No. And in terms of, under Texas laws, it's developed what a reasonably prudent operator would do or not do. You have no opinion about that and aren't qualified. And what did Mr. Brandt swear? In utter contradiction to what Mr. Kilday just told you, he swore no opinion and probably not qualified either. And so when the defendants come back with their ask for attorney's fees here, the number is high. That's because there's 13 defendants, and the court will hear that the reason the attorney's fees are so high is that we've had to respond to things like what Mr. Kilday just told you when the witness swore he had no clue.
Your Honor, Mr. Waymire's conflating two completely separate issues. That testimony dealt with the reasonable prudent operator standard. We're talking about topic number 2 on Mr. Waymire's outline, which deals with cessation of production. They're two completely different concepts. And his testimony about whether or not his company acted with diligence to resume production is admissible lay opinion testimony. His testimony about whether or not the production was online or offline for a reasonable period of time, that's lay opinion witness testimony. These questions that you were just shown that there's objections to are not asking him to give opinions about what a reasonably prudent operator would do in the same or similar circumstances. They're questions about what he did in the context of cessation of production, completely separate issue.
Were there also questions where he was asked how long was too long to restore production? And he was asked, is it days, weeks, months? And
he was asked questions about whether there was production for a reasonable period of time. And that's the exchange you saw yesterday in connection with the summary judgment motions, where he said that he believed that at all times there was production and paying quantities over a reasonable period of time. He also said, as a fact basis, that there was always sufficient revenue to cover marketing and operation costs over a reasonable period of time. And then Mr. Waymire asked him, you were shown this yesterday, about what he thought a reasonable time meant. And he did say, I don't know specifically, I think it depends on the circumstances. Well, how long do you think it is? Is it months? Is it years? And he said, I think it's probably about 6 months.
I can pull the testimony back up. That's not what he said, Your Honor. I'm trying to move through and make good use of the court's time. The court saw it. He did not say that.
that's fine. Go ahead. Ms. Kildane, yes?
Yeah, I said he did say about 6 months.
With respect to, in the last, on lay witness testimony, was it cold? Was the sun really bright? Yeah. What kind of temper did the gentleman display in having to respond to the silliness? Those are things that would be lay opinion testimony rationally based on perception. I'll tell you the place that the Texas Supreme Court has struggled mightily and that they've actually retreated and started moving back the other way. The place that you can start blurring the line, the only place, is on the landowner rule, the property owner rule in Texas, where initially the question was, is a landowner qualified to just sit in the seat and put his hand up and swear and say, I think Blackacre is worth $1 million? And that's been the one place that the court has even come close to struggling on, does this fall into 701 or 702? And in the more recent opinions that come after Speedy Stop, the Texas Supreme Court has carved it back and said, you're not going to get to just, even in this little landowner rule exception, you're not going to get to just sit up there and say Blackacre is worth $1 million, and since I'm the landowner, it's based on my opinion and it's rationally based. You still have to have something. And so to the extent Speedy Stop went that far, they've actually carved even that back since then. But I think, I mean, that would be the only place. The third category, Your Honor, is on the idea of royalties being paid. What comes out of the testimony is that Mr. Brandt had an accountant. He wasn't the accountant. And we've heard Mr. Kildane speak to quote unquote decades of production being paid. We objected to that. And specifically, we've filed written objections to pages 80 through 82, 91 through 92, 320 through 323, 361, and 361, where Mr. Brandt purports to testify about royalties. If I can have for a moment, I've shown the court this before, but if we go to slide 4, there we go. He was taken on board Dyer. Do you know how long Carbon continued to pay the term royalty interest owners out of production from the Schnitz-Rydell well after 97? I don't know. Do you know how long Carbon continued paying the Frells out of the production from the Schnitz-Rydell well after 97? I don't know. He didn't know before that either. In response to all of these questions, there was a timely asserted, you can take it down. There was a timely asserted form objection And we've laid this all out in the written objections, but questions of this nature don't have a foundation. It would necessarily be hearsay and predicated of hearsay on hearsay under Rule 805, because what he's purporting to talk about are hypothetical royalty payments over 30-something years. All of these questions would be compound. I mean, we've had fights over particular months here. How you would wave your hand over decades, the way Mr. Kilday attempts to do, and have someone who wasn't even the accountant say, oh yeah, everybody was paid during that time. It's also vague. And here, I'll just give an example of that. If we can have his Mr. Brandt's deposition and the excerpts of what we've objected to pulled back up. You have the page, John. Is 320 the best one? So if we go to 323, just as a let's just go up a little bit. Here we go. Page 322. So at page 322, he's asked by Mr. Kilday in leading fashion, did Carbon pay those royalties to the various participants in the Schnitz-Rydell unit starting in 1992? Objection form. The form objection is premised on that's compound. You're talking about decades. It's vague. When he says, quote, the various participants in the Schnitz-Rydell unit, who is he talking about? We have no clue who the participants in the Schnitz-Rydell, is he talking about the Schnitzes? Is he talking about the Rydells? Is he talking about somebody else? He's using this testimony as efforts to create a fact issue on ratification. And we've visited extensively where even if this testimony comes in, he's certainly not there. But with respect to any defendant, again, not communist Russia. I'm entitled, when I represent my defendant, DDR Gaddy, in this court, to know if you're saying my client DDR Gaddy got something, tell me about DDR Gaddy. He has no clue whatsoever. If he's talking about a predecessor entitled to DDR Gaddy, tell me which predecessor entitled you're talking about and what did they receive when, so that I can come in here and under my due process rights defend myself against the $80–90 million rock that's been thrown by these plaintiffs 2 decades late. That's the problem with all of these questions. That's why the compound objection is good. That's why the vague objection is good. That's why the lack of foundation and lack of personal knowledge objection is good. And that's why all of the testimony in the complained of pages that I just cited should be excluded. Thank you, Your Honor.
Mr. Kilday?
Yes, Your Honor. So it sounds like this is not any longer arguing about opinions and expert designations. It's arguing about the specific questions. So I think we need to look at each question in turn. But the basis that Mr. Waymire cites for his lack of knowledge is a question about for how long did you continue paying the royalties after 1997? And he said he didn't know that. And the fact that he doesn't know specifically what month he stopped paying royalties to particular individuals does not change the fact that he was aware that royalties were being paid back in 1992 and back in 1997 and for years after 1997. Those are the nature of the questions I was asking him because we needed to establish that royalties were being paid. Now, the participants in the unit, if you look at the questions right after that Mr. Waymire didn't read, I asked him specifically about the Schnitz tract and the owners of the Rydell tract and the owners of the Frells tract and the royalty owners who were entitled to be paid royalties as to each of those tracts. Those were the participants in the unit. And it changed year to year because the interest owners changed. These interests had been fractionated out to so many different participants, and people would die and their heirs would take ownership, or people would do a conveyance, or people would do a sale. And so the idea that we need to ask for every particular month, years after the fact, when records have been lost by Carbon because of a flooding event, tell me specifically how many dollars and cents were paid to this individual at this time. Of course, he's not going to know that, but he's a fact witness who was involved in operating this well with his very small company. He's the president of the company, and he can say We were paying the royalty owners that were entitled to be paid, which includes the participants in this unit, the owners of the royalties under each of these 3 tracts at all times back in the 1990s and in the 2000s. He can say that. And the fact that he doesn't know specifically when those royalty payments may have stopped at this point in time does not change the fact that he has an adequate foundation to speak to the fact that they were paying royalties when they were due and when they were owed. So these objections should be overruled.
Your Honor, lest I be accused of misrepresenting, let's look, he said, look at the questions after, let's look at them. We'll pull up to further illustrate exactly what I've been saying. So I think we
Judge,
were.
I can't hear.
Okay. Ms. Cavazos, can you hear me?
I can't hear all of a sudden.
I hear you, Your Honor.
Can you talk to him?
No. Judge,
Yes.
y'all just kind of just disappeared. All I got was Mr. Waymeyer saying, Your Honor. I don't know what happened.
We can hear you.
Everything just went silent. We were just getting into Mr. Waymeyer's testimony. And that's where I ended.
All right, Ms. Cavazos, you can hear us? Okay, go ahead, Mr. Waymeyer, if you want to start over just on.
Yes, Your Honor. Lest I be accused of misrepresenting the nature of these questions and all of the form objections I just mentioned, let's look at page 323. I think that we were looking at page 322 and he indicated to you that we needed to keep looking farther. Here's 323 objected to. And those royalties were paid out of that production in the Austin Chalk. That's same objections that we've just talked about, same problems. He just admitted that the witness would have no clue whether any particular defendant or any particular defendant's predecessors in title was paid 1 nickel in royalty, which is the entire point of our objections. He said, of course, he's not going to know that. If he doesn't know after 1997, he's not going to be clairvoyant and be able to somehow know about any particular predecessor in title in the year before. If we continue, again, I don't know, keep scrolling down, what was unfair or what else he wants to look at. But all of the questions were of the exact same vein. And we can go anywhere in the range. The additional category that we have of objections to the Brandt testimony, this is all in our written objections, goes to pages 11, 83, and 84. The basis of these objections is that there's myriad asserted in the written objections, but primarily these are legal conclusions. And so what Mr. Kilday is doing is interrogating an elderly man who's never heard of the Wagner and Brown case about Wagner, Brown, and its holding. And so with respect to pages 11, 83, I'm sorry, that's 83 and 84. And then 11 is talking about the quote unquote legal effect of the Schnitz-Rydell unit, which is, you know, there's plenty of problems with the question that are stated in the written objections that we'd rely on, but it is conclusory and would call for a legal conclusion as to its effect. So we'd ask that pages 11, 83 through 84 be excluded for the reasons in the written objections, and specifically, in addition to that, that they're conclusory and legal conclusions.
All right. Anything on final issue on point on that, Mr. Kildane?
Yeah, I'd like to respond to 2 points that Mr. Waymire made. First, with respect to the previous issue about the payments of royalties, I did not concede that he has no clue and did not testify about payments to the royalty owners. I believe the opposite. I believe he did testify that at all times royalties were being paid to the participants in the Schnitz-Rydell unit, to the owners of the royalty interest in the Schnitz tract, the royalty owners in the Rydell tract, the royalty owners in the Frells tract. What I did say is that he should not be expected to know years later the specific number of dollars and pennies that were paid at any particular month to any particular individual. That's what I conceded. So I think I've been misrepresented by Mr. Waymire in terms of what I said or what I conceded. So I did want to clarify that. And then as to the point that was just made about the Wagner and Brown case, we're not going to be trying to introduce into evidence at trial any opinion or thoughts from Mr. Brandt about the holding of the Supreme Court. But I do think it's probative that when Mr. Brandt and his company chose to stop paying term royalties to our clients and their predecessors, they did not consult the Wagner and Brown versus Shepard case. They weren't aware of the Wagner Brown versus Shepard case. Our contention is that they were wrong in their choice to stop paying the term royalty interest owners. And I do think there's a probative fact that it's probative evidence that they did not consult this controlling Texas Supreme Court case law. And we'll rely on the court to decide the meaning of Wagner and Brown versus Shepard. But it is important that Mr. Brandt and his company did not get legal opinions about whether or not they could cut off the term royalty interest owners. And specifically, they did not get any advice or consultation about the Wagner and Brown holding and did not take that into account. So that's all that testimony was designed to do. We're not going to get into, you know, the holding and try to put into evidence what Mr. Brandt does or doesn't think about that holding, but his lack of awareness of that holding is what's probative.
I get the impression that legal fees were not a significant part of Carbon's overhead.
Well, they certainly did not want them to be.
Okay. All right. I have a question. This is probably as good a time as any to ask. And I think I signed a order, Mr. Kildane, letting you amend a declaration or something where you had talking about stripper wells and how things were done informally.
Correct. There was a pagination glitch when he signed that affidavit. So thank you for signing that order to make sure those couple of sentences were not inadvertently omitted.
Okay. And I guess the question I have is, Mr. McFarland said, and I agree with him, that the term royalty is not dependent on the lease, that they're entitled, and that if their production is occurring after the 15 years, then they're entitled to their share, whether there's a lease or not. But is the converse true? If you have a cessation of production that's long enough that it would terminate their term royalty, if the parties to the lease calculate, well, there's nobody else out here offering to lease this place, it's better to get a little bit every few months than to get nothing at all, and they just leave the lease and leave everything in place and keep taking their royalty checks, does that do any good for the term royalty owners, or could the term royalty owners still be expired, still have expired due to cessation in production, even though the lease is by consent, tacit or otherwise, still in effect?
So I'm not sure I understand all the details of the court's hypothetical. So walk me through again exactly what you're asking, Your Honor. I apologize. I just didn't follow it all.
Okay, all right. I agree that the term royalty, the landowner and the oil company couldn't have said, hey, let's screw these term royalty owners. Let's sign a termination of this lease, and then we'll come back in a week and we'll sign a new lease and we'll divvy up their part of the royalty between us so we're both benefit. That they're the term royalty owners, I think, would have a lawsuit there. And so because the termination of the lease in that case wouldn't have if there wasn't a genuine cessation of production, but just a fake one to terminate their rights, they would still be able to go sue, even though successfully they didn't have a lease. But if there is 6 months or whatever, there's this period of cessation of production that if there had been no, and maybe it's a fact question whether there was due diligence to try and reestablish production, but let's just say there had been no attempts during that period of time to reestablish production, that should have been more than sufficient to terminate the term royalty for cessation of production if the operator just gets enough cash to go back out there and get the well going again and start sending royalty checks out, and everybody takes them. That is, the landowners at least take them. Would that revive the interest of the term royalty owners, or would they still be out, even if nominally even if actually everybody else is still getting paid under the lease?
May I respond to that, Your Honor? I'm the oil and gas lawyer here.
Right, okay.
Mr. Waymire put up a minute ago the email that I sent to EOG back when we were discussing with EOG about whether we had a claim. He quoted what I wrote in there, quoted the rules. It's quoted correctly. So there is a temporary cessation of production doctrine that applies to this kind of a term royalty conveyance. An oil and gas lease, on the other hand, like the leases that were included in the Smith trial unit, have an express provision about cessation of production, that it can't cease for more than 60 days unless operations to restore production occur within that 60 days. So that's right. So, but that provision doesn't apply to the term royalty interests that were granted to our clients or to our clients' predecessors. The common law rule that's developed by the courts on temporary cessation is what applies to determine whether those term royalties remain in effect or not. And
certainly, I get that, but my question is, what if under both the common law and the express terms of the lease, there was a cessation for production for enough time that the term royalty thing was ended and the lease should have been ended, but eventually the operator got the well going and started paying royalty checks, and everybody just kept operating under the lease for another 15 years or whatever.
So I'm not sure I can give an answer to the question, Your Honor. I think that as you say, the term royalties continuation doesn't depend on the continuation of the lease. But I think you'd have to look at the facts of the particular case about whether there's a temporary cessation and then the operator comes back and gets a new lease and starts producing the well again.
Oh, not a new lease, just I operated at a very low level on the for representing oil and gas operators. I remember one guy I found in his chain of title, there were 4 owners of the well, according to the Railroad Commission records, that there was nothing in the deed records. You would just have operator A, and then there'd be operator D would have a conveyance to operator E, and then operator G shows up. And this had been going on for years with these little fly-by-night outfits running stripper wells. And he wanted to know if he should, if he could go out there and put a whole bunch of money into this well. And I told him, all right, I'd get a ratification or a lease or something, because it just, a whole lot of things happened informally, and there were cessations of productions, and there were people, filing their P forms claiming they were the new operator, and there was no record of any of that in the deed record. So a lot of things happen informally. So I'm just asking, even if the lease, there was somehow, if there was a cessation, even if the lease somehow was by ratified or just by agreement, they kept operating under it, could it be that the term royalty had expired under the common law, even if the payments continued under the lease?
If it was a long enough period of time, that's possible. I agree with that.
Your
It would
Honor,
be substantially longer, I think, than the time periods that we're looking at in this case. And in this case, the lease was kept in effect by operations because the operator conducted some operations with no lapse of more than 60 days. So there's been no contention that the Frio's lease terminated because of the operator's lack of operations.
of course, in this case, the Frio's lease terminated because it was expressly released in 1997. And I think Mr. Grable and Mr. Waymeyer cited the relevant law yesterday with regard to the resuscitation of dead interests such as these once they've expired. If they have expired, they have expired, and they're not going to get resuscitated because an instrument on which they do not rely and on which they cannot enforce is later ratified by the landowner.
Your Honor, may I be heard in very brief reply?
Yes.
So with respect to the 60-day operations clause, the lease Mr. McFarland tries to point back to is a 1956 lease. That lease was obviously released in 1997 and ceased to be in force in effect. The period of an utter cessation of production that we talk of here is in the year 2010 for over 120 days and in the year 2013 for over 60 days. And so the 60-day thing is an utter red herring. And I don't know if this gets to the court's point here, but yesterday I wanted to respond to Mr. McFarland on this. With respect to the idea that a NPRI owner would participate in lands that are not theirs, the way that the law operates is that it is dependent on a lease. And so under the Merriman, Texas Supreme Court case, a lease that would include a pooling clause or an entireties clause operates as an implied offer to share so long as the lease exists. And so the NPRI owner, in the absence of a lease, doesn't get to share anywhere else. It's dependent on the existence of that lease and the holding of Merriman that by inclusion in a lease of a pooling clause or by inclusion of a lease of an entireties clause, that's an implied offer to share as well. And there's plenty of cases that discuss negative entireties clause and the fact that a NPRI can absolutely be shut out of any kind of pooled sharing or participation if you don't put it in the lease. And so here, when the lease goes away in 1997, under the holding of Wagner and Brown and Chieftain, under Merriman, and as recognized in Montgomery versus Ritterspacher, another Texas Supreme Court case, there's no more implied offer. Because again, this is in the weeds from an oil and gas perspective, no doubt, but the sharing only comes about through the case law that has developed that it operates through the entireties clause or the pooling clause of the lease by the mineral executive. And here, I'm not retreating from our position on motion for summary judgment number 2. Here it is different because the lease was executed first before the NPRIs came into existence. And when the NPRIs came into existence, the instruments creating them did not provide for pooling or for perpetuation of those by pooling. So that might be clear as mud, but yesterday I was listening to Mr. McFarland's argument, ready to pull my hair out because the London versus Merriman case speaks directly to this issue and they're wrong.
We'll just have to disagree on the law.
Y'all off on that tangent, and I'll apologize for that. All right, your next issue, Mr. Wimmer.
Yes, the next one is going to be the objections to the declaration of James Starr. This is their title opinion expert. And he's got 3 declarations that are in the court's record. Mr. Starr has a declaration at Plaintiff's Exhibit 3. He's got a declaration that's contained at Plaintiff's Exhibit 9, and he's got a declaration at Plaintiff's Exhibit 12. We've objected to all of those in writing. We would stand on the written objections, but a brief summary of some of the most glaring ones are as follows. First, he absolutely, unquestionably, and has sworn to the unauthorized practice of law. Here's the statute. I'm going to publish, if it pleases the court, section 81.101. And what the Texas Government Code defines as unauthorized practice of law is preparation of a pleading or other document incident to an action or special proceeding, or the management of the action or proceeding on behalf of a client before a judge in a court, as well as a service rendered out of court, including the giving of advice or the rendering of any service requiring the use of legal skill or knowledge, such as preparing a will, contract, or other instrument, the legal effect of which, under the facts and conclusions involved, must be carefully determined. And so again, here the question is this a service out of court requiring legal skill or knowledge? Let's look at what the witness swore to. I asked him, this is page 221, line 18 through 11 of his deposition. My question is, in coming to the opinions that you formed in this case, did you bring any legal skill or legal knowledge to that task or not? Answer, well, you could probably phrase it that way. I mean, you have to know how to interpret these instruments, which I guess would be legal knowledge, but I'm not an attorney. So he's testified that in preparing his title opinion here, he brought legal skill or legal knowledge to the task, which is exactly the service that is defined in the Texas Government Code at 81.101. Let's look at the next page. The Texas Supreme Court has expressly held that the preparation of a title opinion in Texas constitutes the practice of law. There's the Texas Supreme Court case that so holds is unauthorized practice of law committee versus American Home Assurance. That's 262 Southwest 3rd, 24, Supreme Court case 2008. Rescue Concepts is a Houston case that cites it and says, quote, preparing title opinions constitutes practice of law. What was going on in the case was there was basically a title insurance company that was issuing title policies and having non-lawyers associated with rendering the title on the title policies, and they were selling this to clients, and that was shut down as absolutely being a quote unquote title opinion and unauthorized practice of law. Let's see what Mr. Starr, what Mr. Kilday told you yesterday, that he said he wasn't preparing a title opinion. Let's see what the distinction was for Mr. Starr as he swore to it. He was asked at page 47, line 9, other than the fact that you are not a lawyer and a lawyer did not prepare Exhibit 86, this is his title opinion report, how is this different than a title opinion? He says a title opinion is prepared if you're speaking of a title opinion that's used in the oil and gas industry. When you say title opinion, you mean a title opinion rendered by a lawyer. This was rendered by me based on my interpretation of the documents, and that's all there is to it. And I said, and that was my question, is that the difference that you would draw for the jury here between what you prepared at Exhibit 86 and a title opinion as it's understood in the oil and gas industry is that you prepared 86 and you're not a lawyer. True? He agrees, I'm not a lawyer. I said, anything else you can share with the jury? No. So I told the court yesterday that what he said was that the only difference between a title opinion such as would be rendered by one of the board certified oil and gas attorneys at my office and the title opinion that he rendered for compensation, in this case as a legal service requiring the use of legal knowledge and skill, was that he doesn't have a license. And that's exactly what this testimony said. I gave him, the last question was, anything else you can share with the jury? If you've got some distinction between a title opinion prepared by a lawyer and what you did, other than you don't have a license, tell me about it. And as he concludes there, he had nothing else other than he doesn't have a license.
Does that go to its admissibility?
Absolutely.
If you have a lawyer who gets disbarred for some reason and then they jump up and sign a title opinion, even though they no longer have a law license, that might be go to the weight that, you know, whatever reason they got disbarred for, or perhaps they just didn't pay their bar dues and got suspended. Does that go to the admissibility though?
Under the Texas Disciplinary Rules of Professional Conduct, all of us as lawyers and justice have an obligation to not participate, encourage, assist, aid, or abet a crime, which unauthorized practice of law is a crime. And we all have an obligation not to sponsor it, further it, participate in it. And so to further your hypothetical, I don't have a case at my fingertips that says someone who's engaged in an unauthorized practice of law can now, can testify because he's qualified and just doesn't have a law license. What the State Bar of Texas in its disciplinary rules, and what the Texas legislature has said in the Texas Occupations Code and Texas Government Code is that full stop, this is both civil liability and a crime, and it cannot happen.
Oh, sure.
Now, this witness did not even know that there was a landman exemption to the unauthorized practice of law. So the only reason we're even talking about landman exemption, or that Mr. Kilday knows anything about landman exemption, is because I brought it up at the deposition while I had him under oath to make sure that he didn't claim that what he was doing here, rendering a title opinion for money, somehow fit a landman exemption. Here is the whole statute. Mr. Kilday selectively summarized it for you yesterday, but this is what it actually says. The practice of law does not include acts relating to the lease, purchase, sale, or transfer of a mineral or mining interest in real property, or an easement or other interest associated with a mineral or mining interest in real property, if the acts are performed by a person who does not hold the person out as an attorney licensed to practice law. What that's getting at is the landmen who are actually out there in the field trying to negotiate an oil and gas lease with lessors, landmen that are at the courthouse preparing a run sheet, not rendering a title opinion, but preparing a run sheet to assist a title opinion lawyer in rendering title as part of a purchase, sale, or transfer of mineral or mining interest. A landman that prepares a curative instrument, such as a ratification. That's what the landman exemption is for. This is not, I mean, our industry would be destroyed if landmen could begin preparing title opinions, and that oil and gas operators paying millions of dollars in royalty can now rely on a title opinion prepared by a landman. That's absurd. That is not the exception. It certainly doesn't apply to compensated title opinions to pursue compensated title opinions to pursue litigation. Let's see if Mr. Starr thinks that what he did fit within the landman exemption. Here's his sworn testimony. Pages 30 and 49 from his deposition. I asked him, you understood from the beginning of your engagement in this case that the work that you would be doing concerning the Frio tract did not pertain to leasing, purchasing, selling, or transferring of mineral or mining interests in real property, or easements of interest associated with mining interests. You understood that that wasn't what you were doing in this instance, was it? I understood it didn't have anything to do with the sale. Yes, sir. Or a lease, purchase, or transfer of minerals. Correct. Down at the bottom, you have the case file at the top of Exhibit 86 report reflecting this is litigation. Certainly, by the time you put your signature on Exhibit 86, you knew that the opinions that you were offering were being used for the purpose of prosecuting litigation, didn't you? I knew that at the time, not at the inception of my work, but that at the time this document was prepared, that this work was part of this lawsuit, yes. And that it was being used for prosecution of a lawsuit and not being used to acquire by lease, purchase, sale, or transfer mineral or mining properties or an easement. Well, at that time, I would assume so, yes. He has testified to the elements of the unauthorized practice of law. He has testified that, and this is no remarkable matter, but he has testified that this does not fit the landman exemption. I do not hide from this. I don't put my head down on it. I don't say it softly. He is committing a crime. He is committing a civil action that is punishable by the unauthorized practice of law committee, and that would be prosecuted by a district attorney. It is absolutely a civil liability and a crime, and he's taking money for it. And absolutely, the law in Texas is not that a landman can go render a title opinion. Let's look at this. When I say it's a title opinion, can I have his? I'm just going to show you his report. This is a division order title opinion calculated as to the alleged NPRI owners. This is Exhibit 12F, I believe. The court has seen plenty of title opinions, I'm sure. We'll look at this and see if there's any distinction whatsoever between this and a title opinion. All right. This is the plaintiff's Exhibit 12F. This is, I mean, like, it's a collection of these papers, but let's just start at the top. He has prepared a quote summary of the plaintiff's individual ownership. You can see through that he goes through complicated successions. Let's keep scrolling down. This is a title opinion. This looks no different than the form of title opinions that my office prepares and charges clients hundreds of dollars an hour to analyze, run sheets prepared by a landman, and then render title off of them. Here we got, so he arrives at a tract participation decimal. He is saying that, this is just an example, for Mark Guy Powell, that in the Frells tract, according to his interpretation, using legal skill and knowledge of real property records, it is his opinion that Powell owns 0.012695531 in the Frells tract. Let's go down to the end where he, the last of it. Then he applies a tract participation fact. This isn't just a mineral acquisition title opinion. I told you it's a division order opinion. You go all the way to the last page, all the way to the bottom. He's now applied unit factors. All right, here we go. And so it is his opinion that Mr. Apperson is entitled to be paid off of gross production associated with the Blanc unit, 0.00303402 of gross production. It is his opinion that he has rendered here with no law license that is what he owns as a share of gross production on a unitized basis. So you go beyond just fee mineral title. This goes all the way to division order payment. So I don't, you know, the objection is, one, even if he was a lawyer, lawyers don't get to sit up there and opine on title or opine on a decimal entitlement, period. So it's a legal conclusion, full stop. Two, he's not a licensed attorney. He doesn't go to CLE. I don't care if you've been a landman for 1,000 years. That doesn't qualify you to interpret and opine on the legal effect of instruments in the state of Texas. You need to sit for the bar exam, be qualified to sit for the bar exam, pass your ethics, keep up with your ethics, and demonstrate yourself competent to do that. And then third, again, this is a crime. I don't hide from it. This is absolutely a crime, and it's absolutely a violation of the civil provisions. And we would ask that Mr. Starr's title opinions, his declarations, which simply recite title, this is going to be for the record exhibits 3, 3A, 3B, 9, 12, 12A through F be stricken.
All right, Mr. Kilday.
Yes, Your Honor. Several points in response to this, and foreshadowed some of this yesterday. First of all, just as a statutory construction point, Mr. Waymeyer is again conflating two very different phrasings, and he's using his rather than what the statute says. What we just heard is that Mr. Starr is not entitled to render opinions as a part of a purchase or a sale or a transfer or a lease. That's not what the statute says. What the statute says is that for purposes of the definition in section 81.101, unauthorized practice of law, the practice of law does not include acts relating to. It does not include acts relating to the lease, purchase, sale, or transfer of a mineral or mining interest in real property, including the kinds of opinions that Mr. Starr has given in this case. So what Mr. Starr has done is he has gone back through the history of title on each of these tracts for each of these landowners, for each of the term royalty interest owners, and he has traced the transfer or sale or lease or purchase of each of those interests throughout history, and he has aggregated those documents together for us. He has studied all of those documents, and he has told us what those documents say. All of that is relating to the lease, transfer, purchase, sale of all these interests over time. So it's just categorically false to say that that is somehow the unauthorized practice of law. Secondly, Your Honor, this is a classic example of you're darned if you do and you're darned if you don't. Mr. Waymeyer just said, I wrote it down, I want to quote, that lawyers don't get to opine on that in a lawsuit. So what he's saying is you must be a lawyer to do this. And if you're a lawyer, you don't get to do this in court
because the court is the expert on the law. And I agree with him that it would be improper for us to hire a lawyer to come testify to the jury about legal principles. It is the province of the court to instruct the jury about the law. So what we have done is what's proper, which is to get a landman who is entitled to do what this landman has done under section 954.001 of the Texas Occupations Code, to gather the documents, study the documents, summarize and communicate what they say, and then we'll leave it to the court to decide. The court is the expert on the law. If the court wants to say, no, that's not where title transferred in response to a proper objection or countervailing testimony, then the court can tell the jury that legally he's wrong. Title didn't transfer from this person to that person. That's for the court to do, not for a testifying lawyer expert witness. So we've done the only thing you can do, which is testify with someone who has pulled these documents together and leave it up to the court. I also want to point out that he's not holding himself out as a lawyer. He is not charging hundreds and hundreds of dollars. He's charging a tiny fraction of the fees that Mr. Waymeyer and people at his firm would charge to do similar work as a lawyer if they wanted to render a title opinion. He's not holding himself out as a lawyer. He's being very clear about that. Each time he's asked, he's saying, I'm not giving a legal opinion. I'm giving you my opinion. It's up to a title lawyer or the judge to decide, you know, what the law is. I'm not giving a legal opinion. And finally, I want to close with this. The unauthorized practice of law is something where people have overreached, as Mr. Waymeyer is attempting to do here, all over this country. And one of the leading experts on this area of practice is Pete Cnty, who's my law partner. And I can bring you dozens and dozens of Supreme Court cases from courts all over this country, finding that an application of unauthorized practice of law statute such as this infringes upon First Amendment rights and due process rights. Mr. Starr is allowed to look at documents and say what he thinks about them, just like an operator can, just like a landowner can, and you're allowed to speak out loud what your opinions are without getting accused of unauthorized practice of law. If you were charged.
All right, so Mr. Kilday, let me flip around. I asked Mr. Waymeyer if it mattered, okay, in that even if Mr. Starr is testifying via Zoom from prison because he's in prison for unauthorized practice of law, he either knows what he's talking about or he doesn't. Well, let me flip that around. Okay, he may have the right to say that and not be criminally punished for it, but does that make it admissible in court as expert testimony?
Your Honor, again, we think these issues ought to be the subject of stipulations. There's not any contest as to any of his opinions on this, but the defendants are saying, no, you need to put a witness up, and it can't be a lawyer and it can't be a non-lawyer. You can't do that, Your Honor. If they're going to force us to put up the proof, we're putting up the proof in the only way possible, which is with a non-lawyer, with an expert who's a certified professional landman and has been for nearly 40 years. He is qualified and certified to do this, and he does it as part of his daily practice and has for 4 decades. So I don't see any basis for him being behind bars for anything. And if anyone were to try to urge that, as Mr. Waymeyer is, that would get shot down on First Amendment due process grounds. He's entitled to testify, and these objections should be overruled.
In 60 seconds, he has a First Amendment right to, I suppose, have a blog that says, gosh, I've gone out and I've got an opinion about Apperson's title, and this is what I think. He took money for it. That's when the State Bar of Texas and the Texas Supreme Court and the Texas legislature has something to say about it. And Mr. Kilday just said, well, the difference here is he just took a fraction of the money that a lawyer would charge for a title opinion. Do you think that the Texas Supreme Court and the Texas legislature and the Texas
unauthorized practice of law committee
and the Texas unauthorized practice of law committee might have a little problem with someone who doesn't have to adhere to the rigors that we do, doing exactly what we do for a cheaper fee? That's exactly what the statute, both criminal and civil, is for.
And Your Honor, it's exactly analogous to vendors such as LegalZoom, who do this all over the country and get charged with unauthorized practice of law all over the country, and that gets found to be unconstitutional. You can charge a fee to do work in in areas that are similar to what lawyers do and charge a fraction of the fees for it without infringing upon the unauthorized practice of law statutes. And if those statutes are enforced the way Mr. Waymeyer is attempting to do here, then they get stricken down on First Amendment and due process grounds. All Mr. Starr is doing is studying documents that lay people have to study all the time. He's giving his opinion, and his opinion can be challenged. It's not being challenged, but he certainly can testify as to what the records say and what the math shows about who owns what.
I'm ready to move on, Your Honor.
All right, yes, let's move on to the next.
We have an objection to the Exhibit 7, 7A, 7B, and 7C of Ms. Adalia Romanos. This is their
What page is that on your?
It starts at page 34, Your Honor.
Go ahead.
So Ms. Romanos relies entirely on the Jimmy Starr title opinion. So a non-lawyer landman's opinion about title at a division order level in terms of a fractional interest in gross production on a unitized basis. So with Starr out, Ms. Romanos' testimony goes out too. Second, it's irrelevant for the reason that she opines on unitized decimals, and by these plaintiffs' own admission, they don't even claim a unitized entitlement until July of 2018, and under Montgomery versus Rittersbacher, a ratification would only be effective on a prospective basis, not a retroactive basis. Third, it's irrelevant for the reason that it could in no way inform or assist a jury, because as the court noted yesterday, as it actually looked at Exhibit 7C after Mr. Kildate misrepresented what was on it, this is not communist Russia, and my clients, defendant DDR Gaddy and defendant Stephen Bressler, are entitled to say, what are we being sued for, and how have you calculated the damages against me, and what plaintiff is saying I owe them damages. There's nothing in her expert report that would permit a jury to answer what would actually come on the jury verdict form. So for example, Leland Apperson, who's dead, but if you look at the Jimmy Starr title opinion, he's not. But if I want, the jury has to answer, what does DDR Gaddy allegedly owe Mr. Apperson as a plaintiff? And there's no way, and Ms. Romanos testified that there's no way she didn't prepare that analysis. Secondly, we know she didn't prepare the analysis and couldn't have prepared the analysis because what the plaintiffs didn't do here was conduct any analysis of what the defendants own. And so they haven't said that the defendants don't own something. They've just said, we do, and we want it to pro rata burden everybody by a percentage of 38%. That's a completely arbitrary percentage. There's no basis in the law for charging each defendant with a pro rata 38%. Makes no sense whatsoever. And so the opinion is irrelevant on that basis as well. Finally, Exhibit 7C is a brand new report, brand new opinion out of Ms. Romanos. And that one was served on November 20th of 2020. The reports were due an entire year earlier. That's a brand new report with brand new opinions that comes 3 days after her deposition. So what happens is her deposition is taken. And I asked her, did you form any opinion about my client, defendant Bressler, the trustee? No, I didn't have records. Okay, so Mr. Bressler, you've got no opinions. You've conducted no analysis. You've got nothing you're going to tell the jury about on that. No, I don't have any of that. Mr. Bressler exercised his right to designate no controverting expert because there was no plaintiff opinion against him. But now in Exhibit 7C, being the November 20th, 2020 report, now she purports to make a guess, not based on actual records from EOG, but just make a guess. And that's out of order. We would ask that Exhibit 7C be excluded for the additional reason that the entire report is tardy. Under 193.6, it's tardy and requires exclusion. Under the court's docket control order providing for the timing of expert designation and reports, it's untimely. It's untimely as coming after her deposition was taken. And so on a timely basis, we'd ask that be excluded as well. Thank you, Your Honor.
Okay, Your Honor, I heard several points. I want to take them up one by one. First of all, there's some suggestion that there's some impropriety because Jimmy Starr portrayed Leland Apperson as a living human and he's dead. Mr. Apperson is a World War II hero who died in December of 2020. So very, very recently. And of course, Mr. Starr's report preceded that by some time. So I don't see the point of that comment, but Mr. Apperson did indeed leave us at the ripe old age of 102 very recently. And as soon as there are papers indicating who the executor of his estate is, we'll have to deal with the administrative tasks of swapping out the plaintiff for the estate instead of Mr. Apperson individually. The main challenge being made to Ms. Romanos is what we just talked about, which is Jimmy Starr can't give an opinion about ownership and neither can a lawyer. So nobody can do it. So this kind of lawsuit can't be brought. And we think that's absurd. And we think that's a self-defeating argument. Of course, Jimmy Starr can opine about ownership. And of course, the court can rely upon that or choose not to. The court can decide for itself whether that's proper or not proper. But Mr. Starr can pull those documents together and give his opinion about what they say. And we've provided those calculations and decimal interests and numbers to our damages expert, and she has relied upon them. And that's proper, and that's not a basis for excluding Ms. Romanos. The 38.9%, he said 38%, I think it's 38.9%, is an ownership interest that represents the total ownership share of the plaintiffs in the royalty. So these term royalty deeds that we've talked about in this lawsuit representing, I think it's 25% plus 25% plus 12.5%. So there's a total of 62.5% of these term royalty deeds out there. Our clients are not that entire 62.5% of the royalty. Our clients are 38.9% of the royalty, but they own that 38.9% in the royalties attributable to the entirety of the Frells Tract. So no matter which part of the Frells Tract ends up getting sold or conveyed or transferred to anyone, there's still a burden of 38.9% applicable to the royalties from production from that portion of the Frells Tract. And that applies whether it's the road or whether it's some other segment of the Frells Tract. And we don't just say 38.9%, we show the decimal interest total for each of the plaintiffs. So we know what it is. So it doesn't matter where the production comes from, the percentage ownership of the royalty is the same. And it does aggregate 38 to 38.9%. So that is the percentage for which each defendant's royalty payments are burdened to the plaintiffs. And you can segregate that out by plaintiff. The numbers are all in Ms. Romanos's reports, and the defendants have that. There's no failure to designate. There's no failure to timely give notice of anything. It's all in her reports. And then finally, as to this November report, this came up yesterday. EOG has a duty to supplement discovery responses. And that's something that we have been in communication with Mr. Truss about, and it still hasn't happened. And so at the deadline for our supplementation of Ms. Romanos's report, she timely and properly supplemented her report with the best evidence available, since we don't have yet EOG's supplemental information about royalty payments. And she has independently calculated Mr. Bressler's share based upon the 8/8 royalty and the portion of that royalty attributable to Mr. Bressler. And we don't know whether Ms. Romanos's calculation of that is penny for penny the same as what EOG's numbers will eventually show if they ever comply with their obligation to supplement. But we decided we're not going to rest on waiting on EOG. Our deadline to supplement discovery is coming up in November. We're going to provide supplemental opinions that show another way of calculating what is owed for Mr. Bressler. And she timely did that. She properly did that. The only reason it wasn't in prior reports is because the data was not included in EOG's production to us showing the calculation of royalties. And we sent interrogatories on this to all the defendants, and everybody said, look at EOG's statements. It's missing. The court can look at Exhibit 11A and see that EOG's discovery is missing Mr. Bressler. And so at the deadline for supplementing expert reports, we provided a supplemental report so that we would not be left with nothing as to Mr. Bressler, which is where we were. And so we now have information about Mr. Bressler calculated by Ms. Romanos. It's proper, it's timely, it's before the court, it's part of the summary judgment record. There's no basis for striking it. These objections should be overruled.
May I have 60 seconds on that, Your Honor?
Go ahead.
So the first statement on this 38% is just so completely, utterly wrong under the law, which is exactly why it had a qualified title opinion lawyer prepared this, we wouldn't be here. The 38 point whatever percent ignores that under the law, you have to burden an MPRI against the correct mineral interest. And so so it's not a pro rata across the entire Frales tract on every defendant. You have to look in and see who's burdening and what share. Additionally, all of the defendants don't claim through floating royalty shares or fixed royalties. You could have Duhigg issues of over conveying or under conveying. And so when Mr. Kilday tries to go through and say every single defendant is burdened precisely by 38 whatever percent by each plaintiff, that makes zero sense. Take, for example, say your honors in the chain of title and you received a fixed 1/128th share of royalty. You don't bear any of the alleged MPRI claimed by these plaintiffs. You have a fixed 1/128th royalty, not a floating 1/128th share of royalty that could hypothetically be burdened. Mr. Ellison's remarks yesterday or the day before, I think what he was alluding to is that it's at least the contention of the Gums that they have a fixed royalty interest, not a floating royalty interest. And even then, you would still have to go back and attribute each plaintiff to a particular defendant based on the respective different chains of title. That's what a division order title opinion, if prepared appropriately and correctly, would do. That hasn't been done here. And then with respect to Ms. Romanos in the late report, he knew what the DCO said about the timing of expert reports. He knew he didn't ask for continuance of that. He knew what the summary judgment proceeding was to ask for continuance of summary judgment proceedings. He didn't do anything there. So he's had recourse under the rules if he felt like someone hadn't complied with their discovery obligation. They didn't. There was no opinion out of Ms. Romanos about Mr. Bressler in any way, shape, or form. After her deposition, this is brought to light, and lo and behold, Mr. Kilday goes and gets one 3 days later. It's absolutely untimely.
Your Honor, I'd like to be heard on one of those points very briefly. Our 38.9% applies to whatever has been paid to the defendants. And I presume EOG and the defendants are working properly amongst themselves about how royalties ought to be paid and distributed. What we're looking at is as to the dollars that were actually put in someone's pocket, to the extent that 38.9% of that should have been paid to the plaintiffs, we absolutely believe that they are burdened in that way. And if they want to make contribution claims amongst themselves because of how EOG did or didn't pay things properly under the Duhigg rule, et cetera, that's up to them. But we absolutely believe that the royalties that were paid from this production, from the Frales tract, they were all burdened by the term royalties. And if we're right about that, then 38.9% of those term royalties should have gone to the plaintiffs instead of to wherever they went. And so we are looking at the actual amounts paid to the defendants and the actual amounts suspended. And our claim is that 38.9% should have gone to the plaintiffs. And again, if there's any problems with how that was allocated on the Duhigg rule or otherwise, that can be addressed among the defendants by contribution claims or other reconciliations. So,
and if you have a defendant has a fixed royalty and their royalty isn't burdened by your client's portion, and some other defendant has to bear all of the burden of your client's 38.9%, how do you calculate that?
Well, what we're looking at, Your Honor, is money was paid into their pocket. And so the money that was paid into their pocket that should have been paid to ours, we're saying we have a claim for money had and received based upon that. And, you know, there's not 100% transparency about all of these side deals that these defendants may have amongst themselves on any of that. So we are making a claim for payment of the royalties to the plaintiffs that instead went to the defendants, and 38.9% should have gone to the plaintiffs. And so we're making our claim for that.
Can you tell me if you're making a claim against defendants who don't owe your clients anything because they stand in your client's shoes, and that if you're correct, you have a fixed percentage of the royalty and they have a fixed percentage of the royalty also, and some other defendant has to suck it up and take the entire loss?
Well, again, Your Honor, we're
Prevail?
just looking at the dollars that were paid that should have gone to the plaintiffs. So we're making our claim based on that.
Your Honor, I'd like to insert myself if Your Honor's question's been asked, just on behalf of EOG, if I may.
Go ahead, sir.
It's an absolute outrage that Mr. Kilday continues to try to turn his own burden on its head and drop what he's supposed to do on both the court and on the defendants. We are at trial. The last 4 days have been a trial of the issues in this case, and hopefully a dispositive one. And it's Mr. Kilday's burden to bring before the court evidence sufficient to survive the motions for no evidence motions for summary judgment. He cannot avoid those by making vague and completely inappropriate allegations about that it's somebody else's fault, that he didn't get what he was supposed to be developing over the past number of years after waiting on even filing a lawsuit and then finally doing it and then complaining that other people aren't doing what he's supposed to do. If Mr. Kilday had a problem with any of this, the time to take that up was long ago. And he's chosen not to do so. And he's trying to slither out from under the mistakes that have been made by casting generalized aspersions against other parties. My client, who doesn't have a stake in a penny of the money that Mr. Kilday is fighting over right now, has gone through tremendous lengths and spent tremendous amounts of time trying to provide the information requested. And if Mr. Kilday was not pleased with that, there was a time to take that up with the court. It's not today.
Your Honor, we did file a motion to compel as to the EOG supplementation, and Mr. Truss assured us that he would timely supplement in advance of trial, but we didn't want to rely on him. We're not blaming anyone. What we're saying is that we supplemented our discovery as required in compliance with the scheduling order with a supplemental report from Ms. Romanos that shows her calculation of these amounts corresponding to Mr. Bressler, which is one of the items that's been missing from EOG's discovery. And so we have timely supplemented, and the opinions are proper. They are before the court, and we are ready to proceed. And I'm not trying to get a continuance here at all. I'm simply saying that the report that Ms. Romanos provided in November that's being complained about, it's not untimely on her part. It's untimely because we didn't receive the actual documents from EOG. And so she calculated it on her own within the discovery period and provided those opinions timely to the defendants. So 7A, 7B, and 7C are proper, and the objection should be overruled.
But is it possible, Mr. Kilday, that your clients are suing defendants in this case who don't owe your clients anything? Because even if your clients recover everything they're asking for, they would not recover from that, all of the defendants?
Well, our plan, Your Honor, as I indicated yesterday, is that we will recover from EOG. We're going to pursue the claims against EOG because they have a 4-year look back instead of a 2-year look back. And so we will look to EOG to pay our clients. The claims against the individual defendants are only in the event EOG is insolvent or becomes bankrupt. So we have sued all the interested parties. They're also necessary parties on the declaratory judgment claim. But our claim for recovery, our plan for recovery, is to be compensated by EOG on the 4-year look back, not the 2-year look back.
So that's a yes?
Your Honor, we believe that the opinions of Ms. Romanos speak to this about what is owed by each of the defendants. And if the defendants want to say they're wrong, they can put on evidence of that. But Ms. Romanos has given her opinion about what is owed from each defendant. And is it possible that she's wrong? Sure, that's what a trial's for. If they want to put on proof that she's wrong, they can do that. But that's, again, as to weight and as to counter evidence, that's not as to admissibility. Ms. Romanos' opinions are admissible. And if the defendants want to say she's wrong, they can cross-examine her.
Your Honor, this is Alfred Allen. May I speak for just a second?
Sir.
As an attorney who has done title examination for the last 40 years, as probably 90% of my practice, in this case, we've seen two different charts where on one side, there's an indication of what the defendants have been paid as a total. and on the other side, a chart that says what the plaintiffs say that they're owed by all of the defendants. That is not indicative of what's actually owed by anyone. What would have to be done by Mr. Kilday is to go in and start at the beginning in 1945. If you assume that the Frells owned 100% of the minerals at that point, and run all of the different chains of title through all of the different plaintiffs and defendants and match them up to determine which plaintiff was owed by which defendant, specifically taking into consideration what is in the chain of title to each one of those defendants in order to arrive at the correct amount that they may allege was owed to them. They haven't done that. They've simply put it all in one big bundle and said, they owe us this. And that's not the way it should have been done. And they do not have evidence showing what they have to show in order to prove that the defendants owe them money. A specific defendant owes a specific plaintiff money. Thank you, Your Honor.
And let me ask, has there been any change of ownership among the defendants since the date that the plaintiffs are trying to look back to? By that I mean, do we have 100% the same ownership today that you had 4 years before this lawsuit was filed?
I don't know that offhand, Your Honor. I just am familiar with my own client's interest.
Your Honor, Bob Grable again. That is true with our clients. Our clients bought these minerals in a commercial transaction, and our predecessors owned the minerals in some portion of time covered by the plaintiff's claims. So yes, that is true for our clients.
Your Honor, for my client, Cannon Staley, she's owned the mineral interest that she's had at issue in this case for the entire period.
All right, so Mr. Kilday, what evidence do you have of what any particular defendant would owe you from a particular month?
Right, Your Honor, Ms. Romanos has calculated exactly what was paid to each defendant for each month and from each well, and all that's exhaustively included in the spreadsheets that are attached to her report. And so we have all that, and she has given her opinion and calculation on that. And the only one that I can think, there is one change of ownership I'm aware of, but we have the specific amount that was paid to each defendant in this lawsuit, for which we're seeking recovery of the 38.9%. And I'm hearing some good cross-examination questions, but I'm not hearing any basis to say that Ms. Romanos is not competent evidence. So we think these objections should be overruled.
Your Honor, when the Court of Appeals gets a hold of this thing and writes it up, it's going to reflect that the way the plaintiffs pled their case and have conducted to this point had more problems than a math book.
Your Honor, Gary Ellison, may I speak briefly?
Yes, sir.
There was change in ownership from the GUMs to the GUM limited partnerships. That occurred, however, it certainly was before the 2-year look back that's being asserted, and it may have been before the 4-year look back being asserted. I think it was. Our deeds are in there. But my point is this, that the incompetent nature of the report ascribing damage dollars to the GUM limited partnerships when they do not owe anything under the law through the Dewey rule, that is a misallocation completely of what their claim is. But Ms. Romano was incompetent to give legal advice or to make opinions as to ownership. All she did was rely upon the incompetent report of Mr. Starr. And incompetent opinions by a subsequent expert does not render either of them competent or admissible. Mr. Waymeyer can address that in better detail than I can. But insofar as my clients are concerned, there is no damage claim under any model for the 38% as to their interest in their portion of the land. And it is not the law that allows the plaintiff to say, I'm going to sue all of the defendants and make them sort it out. That's not the law at all. The law is the plaintiffs have to prove an obligation against these parties, And they can't do it with incompetent evidence, and they can't do it with the evidence that is before the court, and they can't do it with competent evidence. And they have no liability assessment against the Gumps whatsoever, even their own percentage admissions today speak to that issue, notwithstanding all of the other problems Mr. Waymeyer has brought up.
Your Honor, I'm ready to move to the next objection if you are.
All right, anything else, Mr. Kildane?
Just one final point. I'm hearing lots of people say, I think this is wrong for this reason or that. Those are the things that cross-examinations are built around. It's not about the admissibility of the evidence. Ms. Romanos is a competent witness. She can testify to her report. And these defendants, if they want to challenge her, and I'm hearing they do, they can challenge her on cross-examination. But she can testify, and there's no basis for excluding these reports.
All right, sir, but what I believe I heard was that there are defendants against whom the plaintiffs may not have any claim at all.
And if that's so, they can show that at trial. But Ms. Romanos has her opinions and her reports and her calculations, and those are properly before the court, and there's no basis for striking her opinions. This is something to be decided as a fact issue at trial.
All right, but if you were standing here telling me we have a claim against every one of these defendants, and if we prevail, then Ms. Romanos's numbers are correct, and that's how much we'll collect, that's one thing. But if you're telling me that, well, we may not have a claim against some of them,
what I'm
we know her numbers are not correct because some of them won't have to pay anything even if we prevail, and some of them, and the rest of them, some of them will have to pay more.
Your Honor, I would just like, today is about evidence. I would like somebody to put their hand up and swear every single defendant owes precisely what's in there. Nobody is willing to perjure themselves. Mr. Kildane certainly isn't going to swear. No one in this case will swear that as a matter of law and fact, that amount is owed by each defendant. He's told you it's guesswork. I'd like to know who's going to put their hand up and swear that each defendant owes that.
It's not guesswork, Your Honor. We have Mr. Starr has prepared his opinions based upon the real property records, and Ms. Romanos has prepared her calculations. They will each swear under oath as to what they're testifying to. And if the defendants want to show that they're wrong, they can do that, and we can let a jury sort that out. That's what jury trials are for. This is a question about admissibility of evidence. This is not the trial that determines who's right and who's wrong. This is the trial to determine whether or not we have more than a scintilla of evidence so that we can get to trial. And we have substantially more than a scintilla of evidence from an admissible witness.
They never analyze the defendant's title. They cannot say that any defendant doesn't own 100% of what they've paid or 0% of what they've paid. They didn't do the analysis.
Mr. Starrs put 293 documents in the record. He did analyze title, and he did go through that in his report.
Okay. All
Let's
right.
look at that.
Your next point.
Thank you. We object to exhibits 5A through E.
And what page is this on?
I apologize, Your Honor.
34?
30 is where it starts, Your Honor.
Okay.
The defendants in the case have followed every single rule of procedure. The plaintiffs don't hold themselves to any. Exhibit 5 is a collection of 3 declarations from witnesses who were never identified in response to disclosures. And so under 193.6, their testimony requires exclusion as never over 2.5 years being identified as a person with knowledge of facts. Additionally, the business declaration at Exhibit 5 of Joseph Compiegne, or however you pronounce it, again, not designated and required mandatory exclusion, purports to authenticate and establish a hearsay exception to a 1964 division order that was prepared by Shell. He doesn't have any knowledge about it. Based on his birth date, he was 4 years old when that was done. Even if you allowed the late witness in, we haven't had a chance to depose. He was 4 years old, and there's a rule against the testimony of children. Under Exhibit 5B, and they've labeled and organized these things in an extremely strange way, so it's kind of 5/5B, I guess. Darren Wilder He's not a designated fact witness. Mr. Kilday mentioned about discovery obligation. We asked during the discovery period to depose all of the plaintiffs. He said no, even though we were within the discovery period. But Mr. Wilder, in any event, was never designated. Again, he attempts to establish a hearsay business records exception on a 1983 division order associated. I can't remember if it was Great Western or who it was, but it certainly wasn't his record. He's late. It requires mandatory exclusion under 193.6. Even if you allowed it in untimely, that's a burden the plaintiffs haven't pled or met. He doesn't have any clue about the method of preparation or chain of custody associated with a document from 1983. With respect to Exhibit 5, this is Travis Walney. Again, not designated as a witness in this case at any point in time. That mandates automatic exclusion. What Mr. Walney tries to do is prove up a business records hearsay exception to royalty statements for only one plaintiff. Mr. Kilday said the record had a whole bunch of plaintiffs. Even if you ignore the evidentiary problems with what he's trying to do, the grand total actually is one plaintiff. So when he told you that there's a whole bunch of royalty statements from different plaintiffs, that's categorically false. With respect to the royalty statements, I guess that's 5C, 5D, 5E. The objection to those, again, they're incredibly paltry, but would be that they lack authentication. And then going back to the two division orders, the Exhibit 5A and the Exhibit 5B division orders that were prepared decades ago, our position on those is in addition to being hearsay and not properly authenticated, they would contain legal conclusions as to ownership from persons showing no qualification or methodology associated with with those, and just simply irrelevant. They don't make anything at trial more likely or less likely. A division order from 1964 and a division order from 1983. Thank you, Your Honor.
Your Honor, these are business records affidavits. They're simply for the purpose of proving up records that are in the custody of some of the plaintiffs. They are specifically allowed under Rule 90210. These are business records affidavits to prove up records. These are not people with personal knowledge of facts in dispute in this case. They're not going to be witnesses at trial. The rules allow documents to be authenticated and for business records exceptions to be proved up by way of a business records affidavit. Our scheduling order has a deadline to do that of this Friday. And so to suggest this is somehow untimely or improper is absurd. And of course, people can prove up records from when they were, 4 or however old, or even before they were born, if they're a records custodian at a company, and these are documents kept within the company. So these records are admissible not only under 8036, the business records exception, they're also admissible under 80316, which is documents more than 20 years old. And to the extent that they relate to title and ownership and property, they would be admissible under 80314 and 80315. There's absolutely no issue about these people being designated as fact witnesses. They're not fact witnesses. We're not presenting them as fact witnesses. They're not going to testify as trial. The records come into evidence if you have a timely business records affidavit on file, and the case law and the Texas Rules of Civil Procedure make that clear. No one's going to ask them to take the stand at trial. All that we're doing is proving up some business records. Now, there's been some aspersions cast at us for something about depositions. I want to address that. This case has had 3 different scheduling orders. The discovery period in this case was supposed to end in late 2019 with a trial in March of 2020. Around 60 days before then, I got contacted by Mr. Ellison to indicate that the defendants needed a continuance. And I won't go into the details, but we readily agreed and postponed the trial setting from March of 2020 to October 2020 and put in a new scheduling order with a new discovery period with the discovery cutoff to be in May of 2020. None of the defendants noticed any depositions before that first discovery period. None of the defendants noticed any depositions before the end of that second discovery period. The only deposition that was taken was of Mr. Brandt. And because there were suggestions that they wanted to take depositions of the plaintiffs, what I told them when they asked a second time for a continuance of several months because of COVID, again, very cooperatively and very readily agreed, and we pushed the trial setting off from October of 2020 to March of 2021. But what I said was, you guys have talked about wanting to depose people. We need to notice them and take them, and let's set a 60-day window up. And I sent them emails last spring and last summer saying, tell me which ones you really want. None of them have personal knowledge of any facts. If the court wants to see those emails, I can certainly provide them. But the defendants didn't ask to do that. They didn't notice a single deposition. And then 4, 5, 6, 7 days before the end of the third discovery period, they sent deposition notices for every single plaintiff to take place after the discovery cutoff, the third discovery cutoff had closed. And at that point, I did say, if you want these, you're going to need to set a motion. These people don't have personal knowledge, and we're not agreeing to them being deposed after the conclusion of the third discovery period. They didn't set that for hearing. They didn't file a motion to compel. And so this gets back to Mr. Waymeyer's suggestion that, if you wanted this, you needed to bring this up sooner. But again, there's no plaintiff that has personal knowledge of any of the facts, any of the issues about historical production or about production and paying quantities, but they can prove up their business records. And that's what these witnesses have done, is simply file a business records affidavit, put those before the court. They're properly before the court. There's no reason to strike them. These objections should be overruled.
Your Honor, you just heard him say not a single plaintiff has any knowledge about any historical payment. So all you have is Mr. Brandt, and obviously you've seen the utter problems with that.
But they do have knowledge as business records custodian that these are records kept by the company. And that's all they've proved up in these affidavits, and they're admissible under 803.6, 803.14, 15, and 16.
Your next issue, Mr. Wiemer?
Exhibit 14 is the declaration of John McFarland.
All right, what page is that on?
This is addressed, Your Honor, at our page 44. So the declaration of Mr. McFarland is all 805 hearsay within hearsay. What he's purporting to do in the declaration proper is repeat, rephrase, summarize in a self-serving fashion what is actually contained in sub-exhibits 14A through F. With respect to sub-exhibits A through F, the written objections are that Mr. McFarland's self-serving emails contain legal conclusions, are hearsay, contain hearsay within hearsay, and are not appropriately admissible. I believe what they use it for is for purposes of establishing the presentment of claim that they're required to. These are utterly irrelevant to presentment of claim, and I'm going to show you why. If we can please have again, the declaration proper, all it's doing is authenticating and hearsay within hearsay, summarizing sub-exhibits A through F. But let's look at what he actually said about the presentment of claim. I think is it D? Wait, go back. Oh. Let's keep going. This actually utterly disproves there we go. Here's what Mr. McFarland said. They say this is now the presentment of claim. Can you scroll up? Let's get the date for the court. This is May 9th, 2017. And what Mr. McFarland says at the very last two lines is, I think our next step is to write a formal demand letter asserting our claim. If you have other facts that you believe show the MPRI has terminated, we're glad to review them. So again, we've got the hearsay legal conclusion, basis to exclude all of this to the extent it's being offered for the truth of anything contained in its four corners. But to the extent that this is all they rely on in terms of their allegation that they've presented a claim, what's in their evidence here in the May 2017 emails that this is not the presentment of claim, that they're going to present a claim in the future. And of course, there's no evidence in the record of a written or mailed presentment. And what this reflects is that it's not intended to be the presentment, that there's something to come that never does come. And again, there's no demand made on behalf of any particular plaintiff or any indication. If we go up, I think someplace he purports to represent all of the royalty owners ever in the Frells tract. As lawyers, we're not permitted to hold ourselves out as representing somebody that we don't. Let's go up. Keep going. He says, we represent the owners of the term royalty interest conveyed by the attached royalty deed, period, full stop. I think if you ask Mr. McFarland if he represents all of the owners of the term royalty interest, he will agree to you ethically he does not. And so then if you start playing picky choosy and guessing at who on April 26, 2017, before they start soliciting clients in the mail to sue on a contingency fee basis, he was purporting to make demand on, obviously, you can't tell from this who he would be purporting to make presentment on behalf of. And then if we go to the bottom, he didn't present a contract claim. He didn't present a 91-402 claim. What he asked was that the monies be put in suspense, and EOG did exactly what he was asking for. Let's just go to his end exhibit. He didn't say pay us, which would be a presentment under Chapter 38 or 91-402 if you'd have put it in the mail. Keep going. Go up a little bit. Yeah. He's told John again, sorry again for the delay on this. I confirmed this week with EOG that they have put all affected parties in suspense. However, EOG is not willing to share the names of those parties at this time. Thanks, Brandon. In the prior emails, that's what he asked for. So our objection is that it's hearsay. If it's being offered for the truth of anything in it, it's hearsay within hearsay. It's got legal conclusions. And to the extent that it's being offered as evidence of presentment, it's irrelevant because it wasn't put in the mail under 91-402. 2, it doesn't speak to being a presentment on behalf of anybody. And 3, it didn't ask EOG to actually pay anyone anything. It just wanted them to put it in suspense. That's what they did. So it's also irrelevant. Thank you, Your Honor.
Go ahead, sir.
Yes, Your Honor. Mr. McFarland's affidavit is proper and competent summary judgment evidence. There's no basis for striking it. It contains a number of documents and proves them up as true and correct copies. It shows the correspondence back and forth. It goes to notice to EOG. It does go to presentment. If Mr. Waymeyer wants to make his argument that that's not good enough, he can make that as a legal argument. That's not an argument against admissibility. There's some suggestion Mr. McFarland is now also doing something wrongful by representing who he represents. And our firm does represent all of the Doherty family, which is the successors to Mrs. Doherty, which is the assignee of the term royalties conveyed to T.C. Huddle. Mr. Huddle owned the 1/8 term royalty interest for a very brief period of time, flipped it to Mrs. Doherty, and then her descendants are all clients of our firm. So when Mr. McFarland says we represent the owners of the term royalties represented by the attached term royalty deed, what he attached was that 1/8 conveyance to Mrs. Doherty. And we do represent all of those plaintiffs, and we did at that time. So there's no basis for striking this. Mr. Waymeyer can make his legal arguments about whether or not that does or doesn't comply with what's required, but this exchange of correspondence did happen. To the extent it's necessary to prove presentment, it's in the record. To the extent Mr. Waymeyer's right that it must be by the mail, that's fine. He can make that legal argument. We believe that the proper remedy for an argument of failure to do proper presentment is to abate the case so presentment can be made. But there's no suggestion that anybody was going to write a check anyway. This claim has been presented for 2.5 years and nobody's paid it. That's why we're still here, and that's fine. That's what courthouses are for. But this is proper and competent summary judgment evidence, and the objection should be overruled.
How much more, Mr. Waymeyer?
I'm sorry, Your Honor.
How much more time do we have?
I'm sorry, I didn't anticipate this much discussion on these things. To be perfectly honest, Your Honor, I think it's 30, 40 minutes. I'm sorry.
All right, go ahead.
At Exhibit 1L, and I apologize. I'm very sorry I don't have these page references that are handy for you. That's at page 4. This is the carbon to EOG assignment. And so again, there's no evidence in this record of any production and paying quantities after 2014. There's also not up to 2014, but this is what this paper is what the plaintiffs try to use to get up to the year 2014 to satisfy their burden. Our objection to this is that it's hearsay. It contains hearsay within hearsay to the extent that it contains recitations about the, about validity. And I'm sorry, I'm actually conflating these things. The argument also goes to deposition exhibit 10, sub exhibit 28. So 10, sub exhibit 28 and 1L is the Carbon EOG contract, and then 1L is the assignment that's placed of record. So that they kind of go hand in glove. What he tries to use 1L for is to say that the Schnitz lease was perpetuated and that the Rydell lease was perpetuated. And what he tries to use exhibit 10, sub exhibit 28, as they've labeled these things, is that contract between EOG and Carbon. So again, it's just, that's not how you put on evidence in the state of Texas as to production paying quantities. I know the court asked, could this be an admission against EOG? As to all of the non-EOG defendants, it's certainly no admission or hearsay exception. As to EOG, I think they have the additional basis that it's conclusory, it's not qualified, it's matters of expert nature, and Mr. Trust may have something else to add that I'm missing, but we'd ask that those be excluded, or at least be received with a limiting instruction that they're not being received for anything except for passage of title, and not for the idea that it's production paying quantities, or that the leases were actually in effect.
So let me make sure I'm correctly understanding, Your Honor. I thought we were just talking about the assignment from Carbon to EOG. Is there another document that I heard you say that we're conflating two documents, Mr. Waymire, and I apologize. Are we just talking about that one document right now, or is there some other series of documents that are part of this objection?
Exhibit 10, sub exhibit 28, the way that you mark your exhibits.
Got
it. It is the contract between EOG and Carbon.
Okay.
And 1L is the assignment that comes out of it.
Okay.
Companion documents.
Thank you. Thank you. Thank you for the clarification. I got it.
We've now understood over the course of argument that that they use this to try to say, well, obviously the leases are in effect because they're on an assignment, and obviously there's production paying quantities because Carbon said so. It's just not evidence, Judge.
Well, Your Honor, this is admissible, competent summary judgment evidence. It's admissible under not only 803, 14 and 15, which relates to documents that have an effect on real property and statements contained within documents that affect real property. As to EOG, in addition, it's also an admission of a party opponent. So this is competent summary judgment evidence that should be admitted. There's no basis for striking it. The objection should be overruled.
Next.
Your Honor, this is kind of a collection, and I'm just trying to cut through this and move it along. On the 82 unit designation for the Schnitz et al. Oil unit, and all of the commission papers associated with the 1992 operation. So if you look at these, if it's the plaintiff's contention that the record should be received for the substantive accuracy of what's in them, I just don't want the Court of Appeals to be confused on this, because the well was not producing from the Upper Edwards limestone formation. And so I'm just asking that these be received with a limiting instruction that they're being used for the purpose of, I guess, notice under their limitations or ratification argument or whatever it is, but not for the substantive accuracy that the 82 designation of unit is valid, or two, for the substantive accuracy that between 1992 and 1997, or I'm sorry, for all times after 1992, that the Schnitz Rydell well was producing from the Upper Edwards limestone formation, as everybody agrees Carbon lied to the commission and it was not.
Go ahead, sir.
Okay, thank you, Your Honor. I think we're talking about Exhibit 1H, which is the 1982 designation of pooled unit. And if I understood the general references, I believe we're talking about Exhibits 2H, 2I, 2J, and 2K, which are the Railroad Commission documents that relate to that 1982 pooled unit, the certificate of pooling authority, the permit application, the permit, and
All right, and I say to slow down a bit, Mr. Kilday, for the Ms. Cavazos.
Okay, I apologize. I know the court wants us to move along.
I understand, but yeah.
Okay, but if I'm understanding the documents correctly, this is pretty clear. These are all certified records of public documents, so they come in under 8038.
And in addition, they are all more than 20 years old, so they come in under 803.16. They are also all documents affecting an interest in real property and statements included in records affecting real property, so they come in under 803.14 and 803.15. There's no basis for these objections and they should be overruled. And further, the defendants attach some of these very same documents to their summary judgment proof.
The question is what they're being used for, Your Honor. And again, just because Carbon lied to the commission and reported on Form W-2 and on the production reports that production was coming out of the Upper Edwards Limestone Formation, I cannot have those documents received for the purposes of establishing somehow it was, when the record is uncontroverted that they weren't.
It's all admissible under 803.8, 803.14, 15, and 16. So these objections should be overruled.
Your next objection?
The next objection, Your Honor, is to Exhibit 13. This is the Greg Robertson affidavit or declaration. I'm just going to put up Exhibit 13 so that we can look at it together. There's myriad objections to his lack of a showing of a qualification, lack of a showing of a methodology, lack of a showing of a reliable methodology, lack of a showing of relying on reasonably relying on documents with the sound foundation. But let's go, the substance of the opinion comes in at page 2. And he says, in order to give my opinion, I reviewed production from the 2 wells reported to the Railroad Commission, the applicable title information in the public record, all of the records of the wells produced by Carbon, and Bob Brandt's deposition. Bob Brandt, president of Carbon, testified that records of revenues from production of the wells were not available. So in order to estimate the revenue generated by that production, I used the annual average domestic crude oil prices provided by Plains All American, a crude purchaser that has operations in the subject area. So the objection there is that this is not a pricing for crude that sold or traded in Karnes County. That crude is an average annual price. I mean, this is not Cushing, Oklahoma. This is not Henry Hub, Louisiana, in Airing. I mean, this literally, he has no idea where the pricing came from. So there's a huge problem on even the revenue, which was the only half of the analysis that he did. If you go to the next one, he says there is also limited information for operating expenses incurred in operation of the wells since '83 when Carbon took over the wells, and certainly not sufficient information to be able to provide a cash flow analysis of revenue and operating expense. I therefore used my experience and knowledge of operation of wells, and in particular wells of the type of these wells operated by Carbon, to judge what amounts of operating expense would likely be incurred. I have operated wells in this same area completed in the Edwards and Austin Chalk formations. First Rock completed a well, I'm going to mispronounce it, I'm not even going to try. A former Edwards well located 2.5 miles southwest of the Schnitz-Rydell number 1 in the Austin Chalk. And that well has produced in paying quantities and continues to do so today in a manner very comparable to the history of the Schnitz-Rydell well. Again, this is conclusory. Under under Rule 166 AC, an affidavit or declaration from an expert that is not clear, concise, free of contradiction, readily susceptible to controversion, that is not admissible summary judgment evidence. And I don't have to tell the court about the standard of evidence that's ips dicti, just I said so. This is just absolutely I said so. If we continue to have and we showed the court yesterday, there's piles of expense information. There's piles of expense information by month that all by themselves, if you just use those, show that the wells were unprofitable over the entire period of time. Absent, I think maybe there were 2 years that the thing was profitable. 97% of this well's production came out of the well before the 80s. And so, I mean, but let's get to the I understand. Here he says, this is the meat of it. I understand that a lease is considered to be producing and paying quantities as long as a well on the lease produces revenue in excess of operating and marketing costs when examined over a reasonable period of time, or a prudent operator would continue to operate the well with a reasonable expectation of profit in the future and not merely for speculation. He didn't analyze costs against revenue. The reason that they don't attach his report is because in his report, he didn't burden any cost in the universe against revenue. All he did in his report was took out a fraction of landowner royalty and took out a fraction of severance taxes. He says, I conclude that based on this evidence and my experience and knowledge in operating marginal wells, it is my opinion that there was production paying quantities from one or both of the two wells during all time periods from the time Karn took over the wells up until the time operations ceased on the Schnitz-Rydell number 1. So he doesn't say both wells, he says one or both. So when we talk about free of contradiction, what we need to know is which of the both wasn't producing in paying quantities. And so that's a contradiction with the idea that both wells were always PPQ. He specifically says there it's not. As you continue through, he says, although we do not have actual figures on operating costs, that's false, and I showed the court that that was false yesterday. There may be limited periods of time during the 15 years when Karn operated these wells that their costs exceeded their revenues. What Mr. Robertson now admits, after his deposition was taken and he was shown all of the costs, he didn't know that there was a pump jack on it. He didn't know this was a saltwater, had saltwater being generated. He didn't know that this was a well producing shallower than the Upper Edwards and wasn't a flowing gas well. He didn't know any, he learned all of this on the fly at his deposition because he didn't actually look at the Karn records. That's why they don't attach his report, because you would see how absurd these opinions are. But if you just look here now, what he is saying is that in fact, the well wasn't always profitable. There were periods where costs exceeded revenue. And these opinions all come about after his deposition where he was shown that the wells weren't profitable. And so that is a contradiction within the affidavit or declaration as well. He doesn't say how long expenses exceeded revenues, but he acknowledges, yeah, now that I'm looking at it, even though I've never performed a cost analysis or looked at actual costs, the thing was probably unprofitable. He says, it is my opinion that during the times when revenues from the well were low, Karn reasonably continued to operate the wells with a reasonable expectation that the wells would return to profitability, as evidenced by the fact that the combination of rising prices and workover efforts did in fact increase net revenues from the well after periods of low prices and production. Again, all of these defendants have a basic due process right at the trial of this case, this being treated as a trial under Rule 63, that if these plaintiffs are going to use quote unquote evidence, that the evidence satisfy the standards under Rule 166 AC, that the declaration not be conclusory, that it be susceptible to readily being controverted, that it not have inconsistencies and contradictions within it, that it show qualification and a qualified methodology in the four corners. This doesn't cut it. Exhibit 13 should be excluded. But I don't want to lose sight of the fact that they still lose on the no evidence challenge. Even if you receive this, they still lose on the no evidence challenge because they have complete periods of cessation of production altogether with no evidence of reasonable diligence in there. And two, because they have zero evidence of production and paying quantities or any quantities at all after the year 2014, between year 2015 and the present. Exhibit 13 should be excluded.
So, Your Honor, I think we've already addressed the merits argument on the summary judgment. If the court wants to relitigate that, I'm happy to readdress the arguments that we've already covered about whether or not we have satisfied our burden to produce more than a scintilla of evidence and so forth, and what that shows, and all the issues about the tens of millions or 80 or 90 millions of dollars of production from the EOG wells that the defendants now say was not producing in paying quantities. But I think what we're here on today is on a challenge to admissibility of evidence. I want to focus my arguments on that. If the court wants to hear more merits-based arguments, I'm happy to respond. This is competent summary judgment evidence. The Exhibit 13 is Greg Robertson's declaration. It's 3 pages long. It's single-spaced. It has a lot of information about his background and his experience. We covered that yesterday in talking about the no evidence points. Mr. Robertson is an experienced operator. He has been an operator of hundreds of wells. He continues to operate, I think it's 29 wells in the area surrounding Karnes County, including wells in Karnes County. He certainly is qualified to render the opinions of the type that he has laid out here. He has described his methodology. He has described what records were there and what records were not there, and what he did in order to reach proper conclusions about the profitability or not of this well, and about whether or not a reasonable and prudent operator such as himself would continue to operate this well over a reasonable period of time. So
did he go back and look at things after his deposition?
What, Your Honor, what happened was he looked at the entirety of Carbon's records when we first hired him and when we first got those records. And what happened is he didn't get deposed for, I think it was a year after he rendered his report. And when he was shown specific documents at the time of his depositions, he was asked, have you seen this before? And he said, no. But if you look at the errata sheet, he remembered that he had looked at the entire record, and he under oath signed his errata sheet saying, I had looked at that before and I gave it the weight that I deemed appropriate. So no, he didn't go change anything about his report. This declaration was drafted from his report because we wanted to be sure we use Mr. Robertson's opinions and words to the most extent that we could. We worked with him on this declaration where he was telling us what to write and what to say, and we had his report. And so he was able to put this declaration together, and it contains his opinions. It contains the bases for them. And under Rule 702, he is certainly a witness who has specialized skills and experience and training. He certainly can testify as to his opinions on this. His opinions will be helpful to the trier of fact to understand the evidence and to determine the issues that are in dispute in this case. I hear that Mr. Waymeyer thinks he's wrong. That's not a basis for excluding evidence. This is admissible, competent evidence, and there's no reason for striking it. The objection should be overruled.
Your Honor, in 60 seconds, 166 AC exists precisely to prevent what this thing is. And two, how on earth could somebody claim to be an expert qualified to testify on the productivity and profitability and reasonable diligence on a well when they showed up to their deposition having no idea what well they were testifying about? A flowing gas well could not be more different in the universe than an actual saltwater producing, electricity consuming, horsehead pump jack lubrication needing well. He said pumper is free. The pumper records show $500 every single month just on the pumper. The pumper alone renders the thing unprofitable. It says no electricity. There's electricity statements every single month. I mean, today is about real evidence, and 166AC couldn't be more on point to what he's trying to do with this conclusory. And it contradicts itself. It acknowledges that the well is not profitable, even under the analysis that only goes on in Mr. Robertson's head that isn't shared with any of the rest of us.
Your Honor, just because Mr. Waymeyer thinks that Mr. Robertson is wrong does not mean Mr. Robertson gets excluded from evidence. It means he gets to cross-examine Mr. Robertson and put on his own witness. Mr. Robertson's opinions satisfy the requirement of Rule 702, and it is admissible, competent evidence. Mr. Waymeyer is free to disagree with it to his heart's content at trial, but this is competent evidence, and the objections to admissibility should be overruled.
And do I have a copy of that on the plaintiff's response?
I'm sorry, Your Honor?
What page would Mr. Robertson's declaration be in? And
this is the one where there
was to DDR Getty's no evidence.
Oh, I see.
Going back to my specificity obligation, they don't even marshal through or try to use it.
So it's Exhibit 13, it looks like.
It's Exhibit 13, and Your Honor, this is the one you identified where there was a pagination error where you signed an order yesterday or the day before to allow the subsequent alternative version that doesn't omit a couple of lines between pages 2 and 3.
Okay, and what page will that be in the 720 pages of your response?
Your Honor, the original summary judgment filing, I can't tell you what page it was on, but I can tell you we provided the new affidavit that didn't omit those couple of lines with our motion that was filed within the last 48 hours. And if you would like another copy of that, I'm sure I can pull it up while we're on this hearing and attach it in the chat.
Please.
Sure, certainly.
Right, go ahead, Mr. Weimer.
Your Honor, turning to page 42 of our objections, we have an objection to Exhibit 11 and 11A. Mr. Kilday has attempted to attach unsworn interrogatories from EOG and a summary worksheet from EOG at 11A. First, it's not unsworn interrogatories are not evidence. They can't be used at trial. They can't be used at a Rule 63 trial under 166A. So because they're unsworn, they're no evidence. With respect to 11A being the alleged summary worksheet, in addition to it not being evidence, we have an objection that it would be hearsay as to all of the non-EOG defendants. And third, it in any event is irrelevant for the reason that it doesn't meet any of the specificity that would be actually needed to even under the plaintiff's view of the world, even if you say they do own a royalty and they don't. They say they ratified in July of 18 now. Again, just the method of the evidence as they try to use it informs in no way the case or the model that they seek to present to the jury. So it's irrelevant.
Your Honor, I apologize. I was trying to multitask there and I was doing so poorly because I didn't find the affidavit yet. So which document are we talking about? Which exhibit?
11A.
Oh, this is the EOG production records and the royalty payment records?
Yes.
Okay, well, this is what many of the defendants swear to, what many of the defendants incorporate in their responses in Exhibit 8. We've got selected discovery responses from 6 of the defendants asking them what royalties were paid to them, and they say, look to the EOG records that have been produced. We asked EOG what royalties were paid, and they say, look to the records that we're producing. And this is the summary sheet from the records that they produced. And so, of course, this is admissible evidence. This is admissions of party opponents all over the defense side of this case, as well as proof from EOG about what royalties they paid to the various defendants. This is critical to the calculation of the royalties that are owed to the plaintiffs is what royalties were paid. And this is EOG's discovery responses about what royalties were paid.
And I will briefly insert myself to say that Mr. Kilday knows full well that the spreadsheet contains what EOG paid to each of those identified parties, not necessarily limited to the tract under which Mr. Kilday tries to recover, that was the best that EOG was able to do with their accounting system, and that Mr. Kilday has within his capability, if he chose to spend the time, energy, and money to do so, to figure all of that stuff out instead of relying on others to do it for him.
And Your Honor, to that point, I can swear that as to my client, DDR Gaddy and Bressler, that they own interests in tracts that have nothing whatsoever to do with Frell's tract, and that they've been paid on, and presumably would be reflected in these numbers. And so, as the court had, as I talk about the irrelevance of the way that they've organized their things, for my folks, there are absolutely tracts that have nothing to do, and this came out in the STAR deposition, was shown to him, have nothing whatsoever to do with Frell's tract, but they seek to take this summary spreadsheet that's unsworn and hearsay and use it against us when it has nothing even to do with the Frell's tract.
Your Honor, the court can look at the discovery questions that are posed in Exhibit 8 and in Exhibit 11 and what this is a response to. And the questions that we asked is what royalties were paid relating to the Frell's tract. And if they have given us erroneous information, that's on them, not on me. And, they can certainly raise these points in their own evidence and in cross-examination of witnesses at trial, but that again goes to weight. It doesn't go to admissibility. This is a document produced by EOG in response to a specific question, series of questions actually, about the royalties paid relating to the Frell's tract. And this is what they point to. This is what the other defendants point to, and it's admissible summary judgment evidence.
It's stunningly disingenuous for Mr. Kilday to sit here with his partner, Mr. McFarland, on the phone when he knows full well that both of them have been informed that this is not tract specific with regard to the Frell's tract. And they've known that for many, many, many months.
If the evidence was sworn, Your Honor, we we could have real evidence. And again, that's why an interrogatory answer is not admissible at trial in the absence of being sworn. It's not sworn. And also under 197, Rule 197, I think 0.2 or 0.3, I think it's 0.2, interrogatories aren't usable by one party against another, even if they're on the same side of the docket. And so all of the non-EOG defendants have that additional objection, is that even if the EOG interrogatory was sworn, it's not, even if there was an exception to hearsay proved against us, there's not, you can't use them against us, but under 197.2.
Okay. How close are we to the end?
I think I just have 2 left, Judge.
All right, are you okay, Ms. Cavazos, to keep going for a few more minutes? All right, we'll take a break before the next one. Go ahead, sir.
Exhibits P, and I apologize, Judge, page 11 of the objections.
Okay.
They attach 3,000 pages of stuff to the response. They say that is P1 through P104 and D1 through D293. None of it is labeled. I don't know what the 3,000 pages. So Your Honor cannot go to any paper called P1. He can't go to P2. He can't go to P3. He can't go to D201. I have no idea what they're calling their P1 through P104 or D1 through D293. With respect to whatever the 3,000 pages of stuff are, they don't marshal or say in any way in the response what the heck it is, how it works, what they do. And so as what I call my lack of specificity, deficiency and specificity objection, as the San Antonio Court of Appeals says, is just attaching a bunch of junk to your response doesn't make evidence. And so I don't know what they think is in the 3,000 pages of junk. It's not marked, so there's no P anything, there's no D anything. In their response, they don't discuss the relevance of the interplay between the hypothetically unmarked papers. And so we would object and have them exclude under the San Antonio Court of Appeals precedent that if you haven't used it and directed the court to how it works and where it is, it's no evidence.
Mr. Kilding?
Yes, Your Honor. I discussed this at length in our presentation, and it's also discussed in our briefing. Exhibit 9 is a declaration, a short declaration from Jimmy Starr that attaches the underlying public records establishing title on both the plaintiff side and on the defense side. And that's only there because the defendants make a fuss that he can't just testify to things, and best evidence is look at the documents. So we've attached the documents showing the title history for these various real property interests, royalty interests on the plaintiff side and the defense side. Now, Mr. Waymeyer says that they're not labeled and he can't tell what they are. Declaration number 9 from Mr. Starr begins with an index describing exactly what they are, by number, by name, by date, by volume and page number, and then attaches all of those records. So it's specifically identified in Exhibit 9, and it's referred to in our presentation this week as the real property record showing the ownership interest, to the extent that the court feels like, you know, I can't rely on Mr. Starr because this is a legal opinion that the court needs to make. The records are there showing ownership. That's what those records are relevant to, is the chain of title and history. And all these documents are referenced in the run sheets and the flow charts that Mr. Starr prepared. But just so that there's no ambiguity about whether he can be counted upon, the documents themselves are part of the summary judgment record. That is, of course, admissible and competent summary judgment evidence. And we would again rely on 803.8 public records, 803.15 and 14 relating to transfers of title affecting interest in title, and 803.16, which is documents more than 20 years old. All of this is admissible. All of it is relevant to ownership, and there's no basis for this objection. It should be overruled.
I'm ready for the next one, Judge, and the last one.
All right, Mr. Wimmer.
Page 45 of the objections. This is the Exhibit 16 declaration of Doug Kilday on the fees. I'm just asking for acknowledgement of limited admission or limited acceptance, to the extent it's being used to attempt to meet the element of reasonable and necessary attorney's fees, I have no problem. To the extent he's trying to use it for the substantive accuracy on the merits of the case, I have an objection that that would be self-serving hearsay, contain legal conclusions. He's not been designated as a fact witness. And so I have no problem with 16 coming in, but only with the provision that it have a limiting instruction or limiting receipt, that it's only for reasonable and necessary fees.
I can concede for the court that that was not an effort to put admissible evidence into the record as to the merits of the claims. It is solely for attorney's fees, both as to reasonableness and necessity, and also as to the allocation and segregation as to the different claims and defendant groups. But obviously, we don't have a jury here. This is not an affidavit or declaration I'm trying to introduce to the jury, but it's solely there because of the no evidence motion. And the no evidence motion did make a point that we had no evidence of attorney's fees. And so we put this declaration in to show that, yes, indeed, we do.
Okay.
And Your Honor, just I've tried to, given the time constraints, and you've been so generous with your time, and on behalf of all the defendant group and our clients, we thank you so much, and thank Ms. Riley and all of the court staff with all the time you've given on what's a very important issue for us and our clients. But with the written objections, which were not responded to, number pages 1 through 45 in substance. And so I've presented them in cursory fashion and hit the high points. But in terms of the ruling that we would ask for, it would be for everything that's been preserved in the written paper.
And Your Honor, we're happy to be heard on any of those that Mr. Waymeyer wants to take up. Obviously, we think that the objection should be overruled in their entirety, and we're happy to address any of those. I want to echo Mr. Waymeyer's thanks to the court staff, Ms. Riley. We appreciate your patience and attentiveness. And then just finally, in wrapping up, the court yesterday asked us to provide a chart of some sort that outlined the different motions that are before the court. We've attempted to do that. I'll attach that now in the chat for the court's convenience. And we appreciate the court's time and courtesies.
Okay, and Mr. Wimar, did you say that you were going to produce one for your objections?
I will produce my idea with what we've started on here is just objections to Exhibit 1, sustained, overruled, objections to Exhibit, if that pleases the court.
But that's fine. That's fine.
And Your Honor, I tried to attach that in the chat and it tells me it's blocked for security reasons. Is that because it's not a PDF?
Probably, but I don't know.
Let me, if you can leave the chat open so that I can attach that, I'll endeavor to resave that as a PDF, or if you'd prefer, I can submit it separately.
It doesn't matter. We're going to be I'll be here for quite a while because we still have the Peeler case.
Okay, well then I'll just turn my camera and my mic off while I resave that, and I'll attach it to the chat momentarily.
All right, that sounds good. And who is here for the Peeler case at 1? Mr. Truss, are you taking off?
I'm not staying, Your Honor.
Okay, Mr. Guthrie, I'm not sure who else is here. Mr. Kirsten. All right, I'll be back at 20 after. Ms. Cavazos, I'll release you until then, so we'll be getting a little bit later start, but I'll be back at 20 after.
Thank you, Your Honor.
Your Honor.
Lori.
Yes, ma'am.
Do we have anybody else besides Peter?
I'm just gonna put in chat for the case with the Virgil Mason Roberson with Megan Harkins, Ninfa Carrillo, and Rasheen Mazahete.
Yes.
They said that, let me post that real quick. They have an agreement and they're gonna be e-filing an order or orders on that case.
Hello, ladies.
Hello.
Okay, we reached an agreement, thank God. And you should have the orders, the temp orders, and the order appointing an amicus, and an order terminating some child support for a period of time. You should, it should be there with you. If not, then I'll let. Megan was having some problems with her computer.
Yeah, she said she got kicked out.
But I think we signed them all and we're okay.
Y'all e-filed that, correct, Ninfa?
Yes, yes.
Okay, I'll look for them and send them to the judge.
Okay. If not, would you let me know?
Let me check real quick if you want to hold on 1 minute.
Okay.
I can get in it real quickly.
Okay.
You know, everybody's having trouble with Zoom.
I know with this weather, everything just
Yes.
interfering.
My husband, he's a videographer, and all his witnesses are being knocked off.
Uh-oh.
They're having trouble.
It is lightning and thundering here in San Antonio.
Oh, yeah. I don't see the order in the e-file at this time.
All right. Give it a few minutes.
Okay.
And I will, I don't think she emailed it. I know she knows better than to email, but let me talk to her and find out.
Yeah, and maybe she can send it to you. You can post it in chat. That's how Judge Wilson likes it.
Okay.
But
I see it in e-file.
Oh, you do?
Yeah, it's an agreed temporary terminating
Right.
child support, temporary orders, and order appointing amicus.
Right.
Yeah, it's there. It's on the page 2.
Should be 3
I
orders.
don't have a page 2. Let me
Oh,
get
I'm
out
sorry.
of
Well, it's probably because yours looks different, but yeah, I see it on there.
let me go back in, maybe update mine. Let me go back in and see if I can find it. I still don't
So that was the only one?
I think I don't see it. Is it with Judge Wilson already?
I don't believe so. I think it just came through. So you might not have it in your queue. If you can only see your queue, then it's not in your queue yet.
Oh, okay, yeah. I can't see it yet. Maybe it takes a few minutes to come through. Because I don't have a page 2. The last one I have is a Carlos Rodriguez on the very bottom.
Yeah, so it is though.
Okay. I'll make it up. Orders for e-filed. You can plug in the calls number. Yeah, it hasn't come through yet. Okay. I'll be looking for it.
Okay, sounds good.
Would you let me know if text me or email me if you haven't received the orders, please?
Well, I think Chris says she sees it. It's just probably maybe going
Okay.
through the
through
the system. It probably just hasn't gone through it. We've
Well,
been
just in
kicked out
case-
of LGS this morning, and we've had a few.
Yeah, I know. Just
problems.
in case if there's some problem, just let me know and I'll if I need
Okay.
to do something on our end.
Okay, I don't know if I have your number, Nifa.
Okay, 210.
Okay.
744 4915.
4915. Okay.
Okay.
Sure.
I'll be on standby on the phone. You know. I got other things I gotta do at 1:30.
That's fine. Yeah.
Okay.
I don't know if it'll be by 1:30, but we'll get a hold
No,
of
no,
you.
no. It's okay. No, it's okay. Whatever time you need to come in, then let me know.
Okay.
All right.
And if I
Give
don't
me a call.
contact you, that means it went through. Okay.
Okay. All righty.
Thank you.
Thank you.
Bye-bye.
So the peeler is the only one left?
Let me make sure. I think that
Okay.
was it. Let me just double check on that. Yes, ma'am, that was it. Just the peeler
Right.
case.
Okay.
And they're supposed to
right.
come back at 2?
I
Is that
thought
the
it was
time?
120.
Oh, 120?
I'm thinking.
Miss Riley, are there docket call dates we could look at for an October 11th trial?
October? Yes, let me check. October, I have, there's 2 weeks with Judge Wilson starting October the 11th and October 15th. Those are the beginning of the trial weeks. And the jury docket call date is September the 15th.
Okay, thank you.
Then let's see, is that the next one after that? I don't have anything after that date, but
I think we've agreed on an October 11th trial date, and we'll
Okay.
get a proposed order to Judge Wilson with September 11th, or sorry, September 15th as the docket.
okay. And I think y'all are on for next week too. On the 16th and the 18th, I have y'all down.
That's right.
Right. And I think that's it at this point. Does that sound about right?
Yes. Are there hearing dates in April? The parties are not able to agree on dates in March.
Okay, let me look. April.
We just need 2 more, maybe.
April 5th. And then April 13th, 14th, 15th.
Okay.
April 27th, 28th, and 29th. And that's all contingent on whether or not they're going to start the jury trials up, but I don't think we won't know till April 1st on that.
Thank you.
You need dates in May or anything else?
I hope not.
I hope not.
All right, well, so y'all know how to get a hold of me.
Did I hear right that we're starting at 120? Ms. Riley?
I don't know. I thought I had notes at 2 o'clock, but then that was earlier today. But then he said he was taking a break and would be back at 120. But I don't know if he meant we only have one other case ahead of yours and ahead of the peeler case. So I'm not 100% sure.
Okay, thank you.
You're welcome, sir. Judge,
Yes, ma'am.
I received an email from Megan Harkins and copied with Ninfa Carrillo and
Right.
Miss- okay, I
I
sent you a
saw
little
your-
note.
Yes,
Yeah.
thank you.
And I don't see the order yet in the e-file, but as soon as I do, I'll certainly get it over to you.
They should be already in y'all's queue.
Thank you.
Thank
I'll
you.
double check.
Turn my ringer back off. Right, San Miguel versus Peeler. Everyone here?
Good afternoon, Your Honor. It looks like everybody is here.
All right, hold on a second. Yes, ma'am.
We're missing a wireless mouse.
What's that?
A wireless mouse. We found a wireless mouse. Were you missing one?
No.
No, okay.
I threw about 3 away because they stopped working, but no, I'm good. Okay, I'm sorry. All right, so hold on, let me shut down all the documents from the last hearing. All right, so it looks like there's a statute of limitations motion and one on statute of limitations on lease payments.
Correct, Your Honor.
Okay.
One's a joint with Kiewit and Steck, and the lease payments is just a San Miguel motion.
Right. So joint motion first?
That's the plan. May it please the court. Somebody, I'll go ahead. May it please the court. The issues in the Peeler's lawsuit and their counterclaims are older than I am. They're older than San Miguel's corporate representative, Dave Burris. We've had a corporate representative testify about things that happened before he was born, about things that happened when he was in elementary school and in college. And the statute of limitations affirmative defense is designed for just such a scenario. It compels plaintiffs to assert their claims within a reasonable period of time, while the evidence is fresh in the minds of the parties and witnesses. It protects defendants and courts from having to deal with causes of action in which the search for truth may be seriously impaired by the loss of evidence, fading memories, the disappearance of documents, or otherwise. It protects the public from the perils of stale claims. I'll share my screen. Your Honor, so I want to give a brief roadmap of what I'll be talking about this morning. First, I'll go through the standards for statute of limitations motions. Then we'll go through the evidence of that staleness, the evidence that was attached to our joint motion. Then we'll go count by count, showing why certain claims are time barred. For that portion of the argument, I will be referring to a chart that was in the reply brief, and I also separately posted that chart in the box. And then finally, we'll go over why tolling doctrines that were raised in the Peeler's pleading does not save their claims. So first of all, with regard to the deadlines, the statute of limitations, the Peelers filed their counterclaims on August 14th, 2018. So for the negligence, trespass, and statutory torts, we are looking at a 2-year statute of limitation term, and then 4 years for the breach of contract and the declaratory judgment. Starting off, I want to acknowledge that there are certain actions in this lawsuit that are within that did accrue within the last 2 or 4 years. Your Honor has heard about discharges from Pond 7 that occurred in the summer of 2018, that occurred close to the filing of the counterclaim. Those we are not asserting are barred. There are also discharges, unpermitted discharges from the power plant. There's a list here, July 30th, 2019, March 31st, 2018. We are admitting, we are conceding those are not time barred. There are a series of unpermitted discharges from 2015 that you'll see here on this list, and those are time barred with regard to the tort claims because those are outside of the 2-year window. So more on the standards. A cause of action accrues when a wrongful act causes some legal injury, even if the injury is not discovered until later, even if all the resulting damage has not yet occurred. And that's important here because certainly the claims that the peelers are making, they suggest that there are injuries that are happening today. There are injuries that are likely to happen in the future, but that's not what we're considering when we're talking about statute of limitations. Claim can be barred even if the injury is not discovered until later, even if all resulting damage has not yet occurred. And the date when a cause of action accrues is a question of law. It's something that Your Honor can certainly decide. And this came up in the response to our motion. There was a suggestion that San Miguel, STEC, and KMG had to give a precise date when a claim accrued, but that's not the standard. We do not have to establish a precise exact date for the accrual to prevail on our motion. It's enough to show it accrued prior to that relevant time period. So now I would like to go over, I'll stop sharing my screen and go over some of the evidence that shows when these claims accrued. And I'll turn to Tony, and I want to start, if you could, Tony, to put up Alonzo Peeler's deposition testimony, volume 1. So here these are admissions of a party opponent. These are Mr. Peeler's own statements that we're going to go through. Along those lines, how often are you getting out to the ranch in Christine? I try to go every morning, say 95% of the time. And when you go in the mornings, what is it you're doing at the ranch? I'm meeting with Josh. Josh Coleman is their ranch foreman. And how often do you get out to the acreage to take a look around, so to speak? Well, after I get through meeting with him, I'll try to go make a round 3 times a week. Not all of the ranch, but in some place on the ranch. Let's go to the next quote. And here we're talking about conversations with San Miguel. Taking aside these 10-acre tract issues, is there another concern or issue you remember bringing to San Miguel where you didn't get a response or an adequate response, in your opinion? And Mr. Peeler said, well, when I started noticing, you asked me when, I don't remember when, but for example, that big pile of ash that's on the property and on my property and on their property, and the water was oozing and seeping out. I asked about them, and who I asked was Gerald Camber. And I said, when are you going to fix this? We're working on it. And I started getting that phrase in the early 2000s. We're working on it. We're working on it. And that's all I got. That's the results. And I still don't have an answer. All right, next one. And here we have it. And what is it about that area we've marked in blue that gives you concern? It was killing the grass and the brush, slowly but surely. And when did you first start noticing that? There was an area right there. It must have been 10 years. Did you tell San Miguel about it when you noticed it? Yes. So here, 10 years ago from this deposition. And then the next quote. What happened about those green areas? When you marked in green as seeps or waterlogged, when did you first notice those? Well, let me tell you my first answer because it's not an easy answer. First noticed it 8-10 years ago, but I really noticed it getting a whole lot worse in the last 2 years. Then we can go to volume 2 of Mr. Peeler's deposition transcript, Tony. And Your Honor, this, what we're about to see does piggyback off of what we were talking about just on Tuesday. Question, and when did you first identify the placement of ash on the leased premises as a problem? Answer, well, the time when it really hit me was when they were bringing ash off somebody else's property. And when would that have occurred? When they, I don't know the date, but I'll tell you the incident, when they started mining on Harrison. Also attached to our response, Your Honor, is a declaration for Dave Burris explaining that records show that mining on the Harrison property started in 2000. So Mr. Peeler saw that ash from the Harrison property placed on his property more than 20 years ago. Next, I want to look at Jason Peeler's deposition transcript. So in recent times since this lawsuit, do you watch the operation at the plant? What I can see from the outside. Okay, and where do you stand when you look at it? It's all around, all over. And how often are you there? Every 2 weeks, more or less. And how long are you there every 2 weeks? Half the day, most of the day. And what do you do there? I play with my cows. And look at the plant operation. I watch the dying ground getting bigger, watch the coal ash blow off the piles, watch the spring continue to seep. Which pile do you see the ash blow off of? 8 and 11 or 8 and 10? Okay, sometimes the plant too. Oh, in the back of the Kiewit mining trucks that aren't covered. And Your Honor, this testimony, he's not giving a year, but it's very clear that he can see these problems. From where he stands, he can see seeps, he can see ash piles, he can see the plant operations, he says himself. Next, I want to turn to the report from Gordon Johnson. Tony. Now, here we have a table from his report, and it's a summary of aerial photographs. So he's looking specifically at photographs, all right? And if you'll scroll down, Tony. On the left-hand side there, you'll see, scroll up just a little bit, looks like January of 2002, right there on the left side. And he says, in January of 2002, vegetation stress impacts. Vegetation stress and discoloration is present at the northeast corner of the power plant. Your Honor, that northeast corner of the power plant, you've seen lots of photographs of it. It is sometimes referred to as, quote unquote, the feathered area, where you've seen photographs of salting on that ground. And the Peeler expert is saying that occurred in January of 2002. He goes on to say that in April of 2010, more than 8 years before the filing of the counterclaims, there was vegetation stress impacts. And he goes on to say the extent and magnitude of vegetative stress northeast, south of the power plant, and he adds to it. He says north of Pond 7 and north of Ramp Pit 8 are at historical maximums. He just produced this a year ago, and he's saying that it was actually at historical maximums in April of 2010. Next, let's look at the Brown report, Tony. Another Peeler expert. Here you can see on the left-hand column, he's talking about 2002, 2003, and he's looking at the Pond 10 area. And he says, seeps developed and flowed into Pond 10. These seeps continue to this day. And then below, if you could scroll up a little bit, we'll see the date. March 2007, talking about seeps at Pond 7, Pond 10, and Pond 11. So their own experts are opining that the problems that the Peelers are complaining of in 2018 have been in existence for decades. Next, I want to turn to the deed recordations. Tony. Now, attached to our pleading, there are a voluminous amount of deed recordations, but I just want to show Your Honor a sample. This one that we're looking at now is from March of 1983. So talking about when I was in elementary school. And this says here, the highlighted portion, San Miguel Electric Cooperative, Inc. will permanently deposit industrial waste on the land described herein. A copy of the notice of the registration, including a description of waste disposed of and a description of the waste disposal facility, is attached as Exhibit A and is made part of the filing. It's in the records. And if you'll look through those records, Your Honor, you'll see that they're specific about what was deposited into the pits. In the early days back in '83, there was office refuse. That falls off the recordations, but there has been ash, fly ash, and you'll see a reference to scrubber sludge. It's a byproduct of making power when you burn lignite. A scrubber, the limestone, is introduced into the stacks to take CO2 out of the air, and there is a byproduct from that process called scrubber sludge. So it's all in the public record. This was available for the peelers to see, certainly. And turning to the next example we have, it's actually from 19...
And let me ask, what sort of document is this? Is it just a declaration?
It's here right at the top. It's an industrial solid waste disposal site deed recordation. So it's recorded there in Atascosa County that these wastes were deposited in the mine area. And the records are clear about it's an interesting document because it does explain it's in the mine and it does explain what it is, which we're talking about the ash and the scrubber sludge office refuse.
Okay, and is this being deposited on land that San Miguel owns, or is it on the premises, on the buffer zone?
This was all on the leased premises, Your Honor. Yes. So turning to the 1997 example here, it's a little bit different. It again says that San Miguel will permanently deposit industrial waste on the land described herein. Again, lists the copy of the notice of registration. It describes the wastes. And you'll see this in some of the recordations in 1997 and then closer to today. They also notify of this one-time disposal. It says, in addition to these wastes, approximately 800 pounds of Class 2 waste consisting of approximately 100 pounds of dilute sodium hydroxide and 700 pounds of absorbent was deposited as a one-time disposal. So it's not just we do ash, this is what we do. There was a one-time disposal and San Miguel made sure that it was in the deed recordations. If Your Honor would like more information about specifically these waste disposals, we did go into that in some detail in the motion we filed regarding in response to the peeler motion for summary judgment as to ash placement and solid wastes. So there's a bit more detail in there, but this is definitely in the deed records. And Tony, let's go to another public record, the order approving permit 11G. So the permit that authorizes mining on the peeler property is permit 11. It's gone through different iterations and it has to, under the Railroad Commission guidelines, it has to be renewed. So this is the most recent renewal, 11G. And this, the order, this is attached to our pleading, is dated October 22nd, 2013. We're currently in the process of seeking a renewal, and Your Honor heard some information about that when we argued the plea to the jurisdiction. But this is
all right. And give me a minute, please, Ms.
Okay.
Frau. I'm sorry, I'm unable to get this to respond. I'm going to have to reboot my computer. So I believe Ms. Riley is the host right now, and I am the co-host, and I will going to have to reboot this. I'll be back as quickly as I can.
Thank you, Your Honor.
All right.
So we're still looking at this order approving the permit 11G.
Okay,
Signed
and
by-
give me just a moment. I just signed out and then signed back in without rebooting, and I hope perhaps that would help. Okay, now I stopped the sharing. Let me ask you to go ahead and reshare your screen, and hopefully it'll work.
All right, Tony, if you could share that permit 11G approval, that would be great. So again, this is in the full order approving it is in our attached to our pleading, but I want to direct you to this table. It talks about the final ash pit reclamation, all right? And Block A, Area A, San Miguel, Area A on the Peeler property, final pit. It's that pit, Your Honor has seen pictures of. It has water in it. It has a pile of ash next to it. This says here, the last year of coal removal was 1990. It's going to be 30 years till final grade, 32 for spoil regrade, and 33 for topsoil regrade. And I will acknowledge that our current renewal application puts those dates even further out because of the difficulty it has been with this particular area of the property in dealing with the water. But it is in the Railroad Commission order. It's in the renewal application. And if you look through that order, you will see that service to landowners is part of that permit renewal process. So the peelers not only would have had this, available in the public record, they would have been served with these documents as the landowner. And on that point, I want to share a case.
Object, Your Honor, that's not correct. The landowner is not served with the document that Ms. Frio just showed you. All they're served with is notice that there is a permit being going up for renewal. That's all, Your Honor.
Well, they had notice of the permit. I'll take that. I won't fight you on that right now. I do want to show the BP America Production Company case, Tony, if you could. So this is a case out of the Texas Supreme Court from 2011. And there the court relied on public documents, like the order we just saw, to hold that the discovery rule and fraudulent concealment did not prohibit the application of the statute of limitations. And I want to start on page 7, if you would, Tony, the large quote on that page. And this quote just sort of gives you in a nutshell the history here. In the case, the marshal's expert testified that he determined BP operations in continuing to rework a specific well were not in good faith because on the well log and the plugging report filed with the Railroad Commission within the limitations period, while the well log contained highly technical information regarding the resistivity, conductivity, and spontaneous potential at various intervals in the formation, it was this information regarding the reservoir's geology that led the marshal's expert to conclude that BP's continued activities on the well were not in good faith. Although the expert came to this conclusion after being provided with internal documents indicating BP's efforts to keep the lease alive, the log and the report alone were sufficient to discover what the expert ultimately concluded, that BP's efforts to obtain production at shallow intervals after other intervals proved unsuccessful were not in good faith. The expert acknowledged that anyone would have been able to obtain copies of the log and the report from the commission records and reach the same conclusions. Although technical, the public documents concerning BP's operations were available to the marshals. That table we just saw, Your Honor, I wouldn't describe it as technical. That table is a lot more easier to read than what I just described here. And in the BP case, that was sufficient notice to preclude application of the discovery rule and fraudulent concealment. I want to scroll down to another quote that makes this, and we can skip the Wagner-Brown quote if you want to go to the next page, that makes this case another one to pay attention to. It says, we have repeatedly held that reasonable diligence obliges owners of property interest to make themselves aware of pertinent information available in the public record. And Your Honor, we just showed you the table, but it's not like what happened at BP. you can see that pit. Anyone can go out there. Mr. Peeler goes out there 3 times a week. Jason Peeler goes out there. This has been open and notorious. The pace of reclamation is not a secret. Maybe these landowners couldn't see what BP was doing with regard to their exploration, but that was still enough to defeat discovery rule in this case, and fraudulent concealment in this case. And here we have not only the permit documents, but also they can see it. It's there. It's not hidden. So I do want to next, Tony, if you can stop sharing your screen. I'm going to share my screen and go through that table that is in our reply brief. Let's see. Are you able to see that? No, not yet. There we go. So here is this table, and we'll go through it rather quickly, but I think it's worth going through because in the response, there was an accusation that it wasn't clear what claims we were actually saying were barred by limitations. So first, let's look at the mining contract, the mining lease. The peelers say that San Miguel failed to reclaim the mined areas within 6 months following cessation of production. Well, the peeler's own pleading admits that lignite ceased being produced in 2004 on their property. And we've just shown you permit 11G. They know what was going on out of their property in 2005. They knew about the pace of reclamation, certainly before the breach of contract claim was filed in 2018 and the 4 years preceding that. Next, we have San Miguel failing to level and save and remove topsoil and level and restore the excavated areas of the Peeler Ranch and sprig and establish grasses selected by the peelers. Now, Alonzo Peeler again says he remembers seeing the big pile of ash that is above contour in the early 2000s. Also, Alonzo and Jason Peeler are out on that property. Certainly they can see it is open and obvious what grasses are being planted on that property. San Miguel, the next claim here, San Miguel disposed or allowed to be disposed coal ash and other solid or hazardous waste in the mine pits and on the Peeler Ranch in violation of the express terms, which we of course disagree with, as we've argued before, and in violation of the implied easement of reasonable surface use. And that's where Mr. Peeler said in, he saw that ash when the Harrison property was being mined, and we know that that began in 2000. We also have the deed records that show the solid wastes that were disposed. Turning to the buffer zone lease, there's a claim that there is widespread contamination of and damage to the Peeler Ranch, loss of use due to contamination of soil, surface water, and groundwater. They also say there's a claim that contamination from the plant has caused visible damages to the vegetation on the Peeler's Ranch. Quoting from the claim, the Peelers engaged consultants to investigate possible sources of contamination on the ranch, given apparent recent, that's their word, recent changes to the landscape, vegetation loss, water seepage, and a fish kill in a tank previously stocked with bass. But what do we know? We know that Mr. Peeler said he noticed grass and brush dying on his property 10 years ago. Gordon Johnson, we just looked at his report. He stated that vegetation has been, changes has been visible since early 2002. And again, stated that of April 2010, the extended magnitude of vegetative stress northeast, south of the power plant, which would be in the buffer zone, are at historical maximums. Your Honor, that's not recent. Turning to the tort and statutory claims, again, we're on a 2-year.
Let me ask while you're still on contractual claims.
Yes, sir.
So what are you asserting would be the impact of all this? By that, I mean, if your clients are violating the contract, they're breaching the contract, and the peelers don't call them on it for more than 4 years, are they scot-free and they can continue to enjoy the parts of the contract they want and the peelers don't have any recovery? Or are the peelers just restricted to any damages they incurred in the 4 years before they filed suit for things like, whether it's for failure to restore or for ash placed on the property, things like that?
Well, Your Honor, one reason we're going through paragraph by paragraph here is because you'll see that there are claims that we agree survive. But that's the way statute of limitation works. There's actually some case law that we're citing that says, sometimes what might seem like a plaintiff who deserves relief, sometimes the statute of limitations knocks those claims out. We have a set of rules for a reason, and we are asking the court to apply those rules. Several of the cases cited in our brief, this Texas Supreme Court overturned jury verdicts. They said, sorry, this was barred by limitations. And the law is very clear that once the peelers knew of these injuries, they had an obligation to bring those claims, and they did not. That was their choice, and that's where we are today. And I would certainly assert to the court that because of some of the timeframes, it has been difficult to gather documents, to find experts. We just heard a quote about Gerald Camber. He doesn't work there anymore. So in what he knew or what didn't happen, who knows? The peelers didn't notice his deposition. So this is a classic case of when a huge lawsuit filed about things happening decades ago. And you'll see in the lease payment argument, they're claiming about lease payments from 1989. There has to be some limits when plaintiffs wait so long to file their lawsuits. And the case law is very clear that these time barred claims that are delineated here are barred. Turning to the tort and statutory tort claims, again, 2 years. 2-year claim, these 2015 discharges, these are discrete events that happened when San Miguel appears to have had a water balance problem during the spring of 2015 during heavy rain periods. Those are barred by their own words. Going to the next claim, storing contaminated wastewater in ramp pits 8 and 10 in such that the wastewater seeps through the soil on the Peeler Ranch in daylights and low areas, killing vegetation from approximately 2009 to present day. In the face of their pleading says they've seen these since 2009. Pumping wastewater that has infiltrated soils in Area A from one pond to another in Area A, thereby allowing it to spread through the soils and groundwater in the Peeler Ranch from approximately 2009 to present day. It's on the face of their own pleading, because of course we know the waterlogged seep area Mr. Peeler has known about for 10 years. Next, we have violating the implied easement of reasonable surface use in the mineral lease by storing and disposing on the Peeler Ranch coal ash waste resulting from lignite mined from off-tract properties. Again, we have the quote about he noticed the ash when the Harrison property began being mined, and that occurred in 2000. Violating the implied easement of reasonable surface use in the mineral lease by disposing of other solid or hazardous waste, mixed waste landfills created from old mine pits. And then according to publicly recorded deed records filed by Cnty, other solid waste generated at the plant and from mining activities were handled, stored, treated, transported, and/or disposed of in unlined landfills and a container storage area in the acreage in and surrounding the mine and plant. Your Honor, again, the publicly filed deeds that are cited by the peelers as support for their claim put them on notice. They've been recorded. There's also some quote in our that's attached to the brief where Mr. Peeler said at one point he saw San Miguel put some tires in an old pit, and he said, I don't want those tires in there, and San Miguel took them out. That's attached to the pleadings. So he was able to see what was going in and out of these pits. Again, it was open and notorious and certainly publicly available information.
Right, but do the peelers have a duty to go down to the courthouse in Jourdanton and browse through the deed records and see what's been recorded?
Your Honor, the case law says that most of those cases have to do with deeds when their property is transferred. So is it clear that they have affirmative duty to do that? No, but there is a higher burden put upon royalty owners, mineral interest owners in the state of Texas to be mindful of publicly recorded documents. The peelers got paid, the record will show, almost $10 million in royalties. This isn't a little old lady who didn't understand the deed records that were filed in the courthouse. And again, the items that were deposited into those pits were open and notorious. The next one is that Movens created a dangerous condition by failing to exercise reasonable care in its handling, treatment, storage, transportation, and disposal of coal ash and other solid and hazardous waste and wastewater. Again, Mr. Peeler saw that big pile of ash in early 2000s. He noticed grass and brush dying on his property 10 years ago. The peeler expert Gordon Johnson stated that vegetation changes around the peelers complained of had been visible since 2002. He also stated that as of April 2010, it was at its historical maximum. Next, we have violating the requirement to complete reclamation efforts on all land disturbed. This is one of their statutory torts. All land disturbed by surface mining activities as contemporaneously as practicable with mining operations. Peelers admit mining ceased in 2004. Permit 11G tables. They were certainly on notice if they, as they strongly maintain that surface mining activities weren't reclaimed as contemporaneously as practicable with mining. And then we have causing or allowing pollution or surface or subsurface of surface or subsurface water. And that's where we get to the seeps. The seep evidence, I think, is perhaps the most obvious, open and notorious. Mr. Peeler remembers seeing it. Anthony Brown recognized that seeps began developing in 2002, and that as of March 2007, the seeps developed at Pond 7, 10, 11, and that as of August 2011, the vegetation kill areas caused by the seeps had encroached into pasture land areas. The declaratory relief section is fairly short. I'll go through that quickly. They're requesting a finding that the movements, San Miguel, STEC, and KMG are responsible for costs related to alleged contamination and disposal of ash. Again, you have the same evidence we've been quoting. And then requesting a declaratory judgment regarding alleged seeps, leaks, and discharges into the buffer zone. And again, their own expert, Anthony Brown, recognized seeps in 2002, March 2007 seeps at Pond 7, 10, and 11, and that as of August 2011, vegetation kill areas caused by the seeps had encroached into pasture land. So moving away from the chart, I would like to turn to some of the tolling doctrines that the peelers have claimed resuscitate their claims. And I think, Your Honor, after hearing about the case law and the standards, that the peelers are going to have a difficult time meeting those. I'll share my screen. Let's see here. So for the first tolling doctrine we have is the discovery rule. And the case law is very clear that it is a very limited exception. Something has to be inherently undiscoverable. It is a legal question whether something is inherently undiscoverable. When the facts on which liability is predicated can be proven by direct physical evidence, it can't be inherently undiscoverable. It also has to be objectively verifiable. The peelers had to know are exercising reasonable diligence should have known. One of the classic examples you'll see in the discovery rule cases are claims where a patient had a sponge left, negligently left after surgery. Inherently undiscoverable once you're sewed up there. A pile of ash above original contour, not inherently undiscoverable. Seeps, dead vegetation, not inherently undiscoverable. The peelers knew or had certainly reasonable cause to examine what was causing these things, and they didn't. They waited, and the claims are barred. Before we get to fraudulent concealment, I did want to show Your Honor another case. This one is Tony, I'll stop sharing my screen. If you could show the ExxonMobil Corp versus the Lazy R Ranch.
Is that the well with the steel scrap that was cemented in down the board to keep it from being reopened?
You might know more of the details. I was focusing more on the timeliness and discovery of the claims, Your Honor. But ExxonMobil is on quite a few of these statute of limitations cases. The case discusses groundwater contamination.
That's different. Go ahead.
Okay. In the case, there was no evidence of groundwater contamination, but there was evidence of contamination on the surface of the ranch. And the ranch said the statute of limitations couldn't bar the groundwater claims because they hadn't occurred. So they were saying there's contamination on the surface and it could go to the groundwater. That was their claim, but the court rejected that theory, saying the contamination on the surface is the triggering event because the ranch had notice of the injury, even if there was no notice of the full extent of that injury. So here's a quote. The ranch also argues that regardless of when its claims for surface contamination accrued, its claims for groundwater contamination cannot be barred by limitations because it has not happened yet. But a claim accrues when the injury occurs, not afterward, when the full extent of the injury is known. The issue then is when the ranch's claim for surface contamination accrued. Let's go to the next quote, Tony. Soil contamination from oil spills is unquestionably objectively verifiable, but it is not inherently undiscoverable within the limitations period. So this is going to their holding that there was no showing that the discovery rule applied and also that fraudulent concealment applied. And this is what I thought was really interesting here. There was a woman who lived on the Lazy R Ranch, and she was deposed. Her name is McDaniel. And this is the next quote. McDaniel testified that she often drove across the ranch, observing ExxonMobil's operations and seeing and being told of oil spills and cleanup operations. You can go to the next portion of this quote, Tony. There was nothing inherent in the possibility of contamination that kept the ranch from hiring Nickel sooner than it did. Nickel is their environmental consultant. It has so many parallels to this case. Mr. Peeler, he looks over his ranch. He knew there were seeps there. He knew there was a pile of ash there. He knew Harrison ash was being put in there, but he didn't hire the consultant until 2017. And the Texas Supreme Court, again, undoing jury verdict, says discovery rule doesn't apply, fraudulent concealment doesn't apply. This was open and obvious, and they're just talking about oil spills. I would assert that the ash cap and the pit full of water in the timeline is more open and obvious than an oil spill. So the cases are clear, the appealers were on notice, and the discovery rule is not going to save their claims that are time barred. Your Honor, you've seen those pictures. You've seen the picture of the pile. You've seen the pictures. You know it's open and notorious, and certainly Mr. Peeler has said so at his deposition. We also know Jason Peeler, we saw his testimony that he can see it all from his property, and as seen in photographs, aerial photographs where you can see part of his plane, he also flies his plane over that ranch and certainly can see what is going down below. Turning back to my slides. The next doctrine is fraudulent concealment. It applies when the defendant is under a duty to make a disclosure but fraudulently conceals the existence of a cause of action. There's no such concealment here. It was all open and notorious, Your Honor. And certainly the testimony, the deposition testimony that I've shown you and the Peeler's own expert report shows that these things were obvious. San Miguel certainly didn't try to attempt to hide what was so open and obvious. The Peelers also say there is a continuing tort occurring here. This certainly does not save the contract claims. In addition, the Texas Supreme Court has not endorsed the continuing tort doctrine. Courts of appeals that have looked at it have held that it does not apply to permanent injury to land. And for temporary injury, in those courts of appeals, the Peelers are limited to injuries occurring during the last 2 years. So it's a stretch, you know, Your Honor. The peelers are asking you to apply a doctrine that hasn't been endorsed by the Supreme Court, and certainly it's very clear that it would not apply to permanent injury to land. And to the extent there's a dispute over whether there is permanent injury to land or temporary injury, that dispute would not bar summary judgment. Certainly the court could craft an order that would bar anything related to permanent injury and anything related to temporary injuries prior to the appropriate time period. And Your Honor, we're getting now to an issue that I, as San Miguel counsel, will be talking about that KMG and State counsel will not. And this is the Civil Practice and Remedies Code, section 16069. As you know, San Miguel filed its affirmative claim first. You know about the lockout letter. We were here talking about this just 2 weeks ago on the summary judgment motion for our affirmative claims. The peelers assert in their pleadings that our lawsuit about the lockout letter resuscitated their time-barred claims. This is the text of the rule. If a counterclaim or cross-claim arises out of the same transaction or occurrence that is the basis of an action, a party to the action may file the counterclaim or cross-claim, even though as a separate action it would be barred by limitation on the date the party's answer is required. Same transaction or occurrence is the key language here. Your Honor, it's just not. It's just not the same transaction or occurrence. As you know, San Miguel filed this lawsuit, and the very next day, the peelers filed a 62-page counterclaim. The purpose of this rule is to prevent a plaintiff from waiting until the adversary's valid claim arising from the same transaction was barred by limitations before asserting his own claims. That policy is simply not implicated here, and allowing its application here would arguably entice parties to breach their own contracts to force the other side to file suit in order to allow the breaching party to revive its time-barred claims. It's also on its face the claims that San Miguel, under this principle, would have been accused of waiting till the application of the statute of limitations briefed. It just doesn't make sense with our timeline. San Miguel got the lockout letter and got to the courthouse as fast as it could. There was no waiting for the statute of limitations bar to run on the peelers, especially since, as the evidence shows, it ran decades ago. I think it's important to note that the doctrine does not apply to Jason Peeler because he is not a defendant to our affirmative claims. And again, our affirmative claims do not involve the same transaction or occurrence as the counterclaims. The lockout letter, unilateral termination of the lease, threats to call the sheriff, install game cameras, lock the gates. And Your Honor, I do an exercise, and I don't know if all lawyers do, where I try to talk about my cases to my mom or my neighbor, someone who's not a lawyer, just to kind of, obviously not with confidential information, but just say, here's what I'm working on. Here's what this case is about. And I would like us all to sort of stop and think, how would you describe the affirmative claims and the peelers' counterclaims? What are these lawsuits about? If you were going to tell your neighbor, well, our affirmative claims are about that letter. What I called a nuclear bomb a couple weeks ago of a letter. What are the peelers' claims about? Contamination, seeps, ash piles, wastewater, electromagnetic studies, contaminants of concern, distressed vegetation. These two lists don't have much in common. And Your Honor, the counterclaims are what spun off 20 expert witnesses. 20. We've had several hearings about those. They're not talking about the affirmative claims, Your Honor. They're talking about the electromagnetic studies, the contaminants of concern, vegetation, aerial photographs. And it is clear, I think, to anyone who takes a look at the two lawsuits that it's simply not the same transaction or occurrence, and that in many ways, San Miguel was enticed to file this lawsuit. I think at a recent hearing, opposing counsel said, our plan was to file a federal lawsuit. Well, I've seen the 62-page complaint. It does not read like a federal lawsuit at all. Well, what about the mining lease, right? Are we talking about, we each are claiming breach of the mining lease? Maybe that's the same transaction or occurrence. Well, Your Honor, you've heard the arguments about the termination of the mining lease and whether or not it terminated in 2004. Well, that's all about the habendum clause, payment of annual rentals, dispute resolution, sections 2, 8, and 11. The counterclaim doesn't even cite those provisions. The contract claims in the Peeler's lawsuit, they overlap the torts. And that's what we were talking about 2 days ago, is how the contract and the torts are what overlap. And if you remember from our chart, the Peelers did seek a declaratory judgment that the mining lease had terminated in 2004. That's not in our chart for seeking resolution under statute of limitations. Arguably, that's the only piece of their lawsuit that is like ours. And we have those cross summary judgment motions on that piece of it. But the idea that somehow our lawsuit that kept them from calling the sheriff on our employees and our contractors allowed them to file this massive environmental lawsuit just defies common sense. They also assert that there's a continuing contract theory that somehow saves their breach of contract claims on the mining and buffer zone lease. But Your Honor, that's a red herring. They are not continuing contracts that term of art is applied. Those continuing contracts primarily apply to construction contracts that occur in phases with payment required at each phase. Hornbook law is that a breach of a contract starts the limitations clock. Also, it seems awfully contradictory for the Peelers to assert that the mining lease terminated in 2004, but also are saying it's a continuing contract. I am not able to square those two positions. And then there is the response also accuses us of failing to address their equitable estoppel claim. And that fails for two reasons. One, it's not in the Peelers pleading. And two, they have not shown that they meet the 5 elements of equitable estoppel. That is not anywhere in their papers. I do want to share my screen briefly. And I am getting close. I'm still sharing my screen. Look, I just want to share something else. I want to go to their, oh, come on. That's in the way. Let's see if I can do this. Pardon the technical interruptions. But here's the appeal. Oh, I stopped my video. All right. Let me restart my video. Well, you don't need to see me. So this is their live claim, right? You see that? It was filed November 18th. This is their live claim. So I'd like to just go through the exercise of doing a control find. And look, I already typed it in. Look for the word estoppel. And Your Honor, it's not there. There's no claim for equitable estoppel. We didn't address it in our motion because we didn't see it anywhere. So to conclude, Your Honor, we went through the evidence and it establishes that the claims outlined in our motion and reply are barred by the statute of limitations. The Peelers have not shown that they have been resuscitated by any of the applicable tolling doctrines. And the case law is clearly on our side. There have been, I think the 2 cases we went over today show that these were open and obvious conditions that they waited too long to complain about. And as a result, they're outside of their limitations period. And it has made trying this lawsuit a lot more difficult. And there's a reason we have statute of limitations, and it certainly is applicable here. So I would ask that you grant our motion for summary judgment.
And who's going to respond?
Your Honor, Mark Guthrie, Kiewit Mining Group. I'd like.
Oh, I'm sorry. Go ahead, sir.
That's all right.
When Mark is finished, Your Honor, Stack just has 5 minutes of a point they need to make, please.
All right, go ahead.
Thank you.
Guthrie.
Thank you, Your Honor. Well, I wish I could say that the claims are older than I am, but given that I turned 61 on Monday, I can't say that, but they're at least half as old. I want to go over some things that are unique to Kiewit Mining Group as opposed to the other parties. First of all, there's no declaratory judgment claim anymore against Kiewit Mining Group. We filed a Rule 11 agreement, and we have filed an agreed motion and order dismissing those claims for declaratory judgment as well as injunctive relief with prejudice as against Kiewit Mining Group. There are no breach of contract claims pending as against Kiewit Mining Group. The only claims against KMG that remain are tort and statutory tort claims governed by a 2-year statute. Another unique thing is that the peelers don't plead fraudulent concealment as to KMG. And so that should not be an issue precluding summary judgment in KMG's failure. And we're in a little different position with the issues related to the Civil Practice and Remedies Code section 16.069. And this is, we have this in common with STEC actually. We are not counter defendants. And 16.069 allows a defendant to assert as counterclaims or cross claims that would otherwise be time barred if they arise out of the same transaction or occurrence that are subject of the lawsuit against the defendant. It covers only the defendant's assertion of counterclaims or cross claims by the terms of the statute. There was a discussion in the motion to the effect that the claims against KMG and STEC are not counterclaims or cross claims. That's on page 20 and 21 of the motion. The peelers in their response don't even refute or address our argument that section 16.069 does not apply to the claims asserted by the peelers.
Your Honor, I could probably close this off real quick. We've never asserted that section 16 point whatever it is applies to KMG.
Well,
Okay.
Your Honor, if I may, even in their response to this motion, they persist in calling us counter defendants.
I think that's a separate issue, Your Honor. I don't think it matters whether we call them blue or green. Section 16.9 doesn't apply to them.
Okay.
All right. So
I'm happy with that. I'll move on. Not really unique to Kiewit Mining Group are the facts that neither the discovery rule nor the continuing tort rule or tort doctrine applies to the peelers' tort and statutory tort claims. And I misspoke. It's not facts. The court can determine this as a matter of law. We have presented evidence establishing that the peelers were aware of the conditions that they attribute to the alleged contamination on their property and KMG's activities and alleged omissions well before August of 2016. The peelers don't appear to dispute this evidence in their response or try to create a fact issue regarding it. Their two primary arguments are incorrect. We don't have to conclusively show when the peeler's cause of action accrued. All we have to do is show that their causes of action accrued before a certain date. Plenty of case law on that. We also don't have to conclusively prove that the peelers aren't entitled to their exceptions to the running of statute of limitations. Instead, it's the peeler's burden to raise a fact issue as to whether their exceptions apply. And by exceptions, I'm referring to fraudulent concealment, equitable estoppel, discovery rule, continuing tort. And they can't do so as regards KMG on fraudulent concealment because that is not pleaded against KMG. They can't do so on equitable estoppel because that is not pleaded against any of the movers. They can't do so on the discovery rule because, as Ms. Frill did a good job of showing you, it doesn't apply as a matter of law. It does not, or the peelers cannot do so on the continuing tort doctrine. This too is a question of law. And even if the continuing tort doctrine applied here, the peelers have failed to create a fact issue with competent summary judgment evidence that satisfies the elements of continuing tort doctrine. It is just not applicable. The peelers have argued over and over to this court that their claim damages to real property are permanent and not temporary. And the court can determine as a matter of law that continuing tort doctrine does not apply to permanent injuries to real property. Where a plaintiff like the peelers has actual knowledge of facts that give rise to their claims, none of these equitable exceptions, even if properly pleaded, would apply. The court ought to consider the peeler statement and their response on page 7, and I'll just quote it here. Specifically, the evidence submitted by counter defendants does not establish when the leaks, seepages, and overflows from counter defendants' surface impoundments and the fugitive dust counter defendants failed to control deposited enough accumulated contaminants, to pollute the peeler land and groundwater, thereby giving rise to the peeler's causes of action. But Your Honor, this ignores the peeler's definition of contamination. This might be a better argument if the peelers had evidence of and defined contamination as contamination exceeding a state environmental action level or a protective concentration limit. But under the peeler's definition of contamination, any exceedance over background levels is contamination. That's, to use the court's example, that is one of those glow-in-the-dark watches that gets dropped in a shredder one time or dropped in a lawnmower one time and scatters. So under their evidence, anything over a background level, one little bit of something that is a purported constituent of concern starts the clock. Now, we all know that the wind didn't start blowing in Atascosa County within 2 years of filing the lawsuit, or even within 4. The trucks hauling lignite to the plant and ash from the plant have done so since the 1980s. The lignite and ash piles at the plant have been there since the 1980s. According to the Gordon Johnson report excerpt that Ms. Frill showed you, Input 10 has been full of water since January of 2002. The ash pile at Input 10 also predates KMG's involvement at the mine, which started January of 2011. The last coal removal from Area A, which is where the ash pile and the water-filled pit at Input 10 is located, was in 1990, over 20 years before KMG first started work at the mine. Alonzo Peeler's knowledge set out in the motion and summarized in the chart we just looked at shows that he was aware of the ash pile at Input 10 and complained about it 10 years before his August 2019 deposition. He also knew about dying vegetation in the vicinity of the plant and the mine. He also knew about the Area A seeps. And I'm compelled to add this based on the court's ruling on the motion for summary judgment as to the tort and statutory tort claims and the discussion about standing in the court's order. All of this knowledge by Alonzo Peeler predates any involvement of the A.M. Peeler Ranch LLC, because Alonzo and Barbara Peeler conveyed their interests in the ranch, or a substantial portion of the ranch, effective May 1, 2014, to the A.M. Peeler Ranch LLC. The Peelers offered no summary judgment evidence that KMG was involved in any water discharge in June, July, or August 2018, or at any other time. So the issues about water discharges shouldn't prevent summary judgment in favor of KMG. The Peelers try to argue that they could not have been expected to know that invisible pollution was accumulating in the soil and water under their property. Ms. Friel's already covered the Lazy R Ranch case, and that's a 2017 Texas Supreme Court decision. I agree with Ms. Friel that there are a lot of parallels to this case in that one. The Peelers also, in their response, misstate the burden of establishing discovery rule, continuing tort doctrine, and the other exceptions to the running the statute of limitations. They misstate the burdens of proof specifically as to these excuses. The Peelers have the burden, not the movants, to raise a fact issue to avoid summary judgment on these exceptions. And the 2017 Texas Supreme Court case the Peelers rely on for the continuing tort doctrine, which is another ExxonMobil case called Rincones that you find at 520 Southwest 3rd, 572, discusses this burden very succinctly. A defendant moving for summary judgment on the affirmative defense of limitations has the burden to conclusively establish that defense. Yet when conclusively established, a plaintiff may invoke, here it was equitable estoppel as an affirmative defense in avoidance of the defendant's limitation defense. In that situation, the non-moving plaintiff, which here are the Peelers, bears the burden of establishing its defense. The non-movement must present summary judgment evidence raising a fact issue on each element of his affirmative defense and avoidance. So, as to any of these avoidances or exceptions to the running of limitations, the Peelers have the burden of establishing them or creating a fact issue with respect to them. Ms. Friel covered, I believe, the cases on the discovery rule related to things that were not inherently undiscoverable. And so I'll move on from that and rely on her argument. The continuing tort doctrine, if you look at the cases, it becomes apparent that, number one, the Texas Supreme Court has not recognized it or adopted it. They've recognized that courts of appeals differ around the state in whether or not it applies, but several have and several have not. And there's a case out of the Waco Court of Appeals that is cited in the Rincon case that says that trespass is not a continuing tort. The appealers don't dispute that the continuing tort doctrine does not apply to suits for damages or permanent injury to real property. There's a good discussion of that in the case we cite called Marquardt versus Texas Industrial Inc. 325 Southwest 3rd, 876, a Houston 14th Court of Appeals decision that involves a permanent nuisance. The appealers have objected to, well, let me back up. Let me deal with equitable estoppel again. Those both equitable and estoppel and fraudulent concealment should be easy for the court to dispose of insofar as KMG is concerned. Neither are pleaded against KMG, and equitable estoppel, as Ms. Frio pointed out, is not pleaded against any of the movements. We've objected to this improper assertion of equitable estoppel for the first time in a response to the motion for summary judgment long after the pleading deadline. And even if the court were to consider equitable estoppel or fraudulent concealment, the appealers have failed to raise a fact issue as to either as against KMG. The appealers present no evidence of any concealment or misrepresentation by KMG, nor could they. Now let me move on to the objection to our citation to the reports of two of the appealers experts, Gordon Johnson and Anthony Brown. They claim that their own expert reports are inadmissible hearsay. While we disagree with the conclusions, many of the conclusions of these experts, which are subject to a motion to exclude, we'll finish arguing next week. The statements in these expert reports that we've relied on are admissible summary judgment evidence because they are considered statements of a party opponent. They ignore the fact, the appealers ignore the fact here that these two are the appealers experts, not our own. The governing statute of limitations is in Texas Civil Practice and Remedies Code 16.003 in regard to the claims against KMG for injury to property, including the tort and statutory violation claims. It's a 2-year period, and any claims against KMG occurring before August 14, 2016, 2 years before the date the lawsuit was filed, are time barred. Your Honor, the appealers have wholly failed to create a fact issue or a legal issue, precluding summary judgment in favor of KMG on limitations. And we ask for that summary judgment as requested in the motion and proposed order. Thank you.
All right, Mr. Christine.
Yeah, thank you, Judge. I'll try to be very brief. The first issue I may be able to take care of. If I could direct a question to Ms. Whittle. I was going to make the same point that Mr. Guthrie started, which is that section 16.069, the so-called savings statute, does not apply to STEC, just like it doesn't apply to KMG. I don't know, Ms. Whittle, if you agree that it doesn't apply to STEC, just like you agree that it didn't apply to KMG, and I could save that argument if you do agree with that.
So no, I don't agree. We pled that we believed it applies to STEC as the contractor to San Miguel who made these decisions.
Okay, the judge, just very briefly, let me just finish the point that Mr. Guthrie had started, which is 16.069 is a so-called saving statute, which allows by its very language, allows counterclaims or cross claims that arise out of the same transaction to be filed against the plaintiff that would have otherwise been time barred if they are done within 30 days. It's undisputed that STEC was not a party to the original claim that San Miguel brought, and that STEC, like KMG, was added as a third-party defendant. There are not many cases on the applicability of Section 16.069, but there are two very important cases that are exactly on point, Your Honor, and I'll just give you the cites. One is the JMK case out of Houston. It's a 2006 case, which states that Section 16.069 makes no mention of third-party practice and by its express terms applies only to counterclaims and cross-claims. And the cite to that case is 192 Southwest 3rd, 189. There's also a case out of Corpus, Your Honor, SJW Property Commerce. The site is 328 Southwest 3rd, 121. And it says basically the same thing, that third-party actions are not contemplated by the terms counterclaim or cross-claim contained in Section 16.069 of the Civil Practice and Remedies Code, and that the purpose of Section 16.069 would not be served by rewriting it to allow a defendant to revive an expired claim against a non-party. And that's exactly who STEC is to that original lawsuit that was filed by San Miguel. We were a non-party. We were added as a third-party defendant. So that equitable defense, in effect, pled by the peelers does not apply to STEC. One other point that I wanted to raise, and Judge, it's been a couple of months. You may recall that STEC had a pending or has a pending motion for summary judgment on what I call the remaining tort claims for the damage to property outside the lease boundaries. You may recall that the arguments made by the peelers at that hearing were based on two theories. One was a respondeat superior theory, and one was a vice principal theory. Both theories, we argued, are completely unpled by the peelers against STEC and shouldn't have been considered by you. But the main thing is they were all based on a 2016 MSA agreement. You may recall that involved Mike Kezar and him serving a dual role as a general manager of STEC and of San Miguel. Everything that they pled regarding the torts outside the lease boundaries are based on that 2016 agreement. So no liability could arise before that agreement. And so as Ms. Frio put up, there are some discharges within that 2016 to 2018 period that she and the others were not seeking limitation summary judgment on. But anything before 2016 as to STEC could not be the basis of a claim because that would predate the MSA agreement. So it would be barred by limitations, but would also be barred based on the theories that the peelers set forth that were based solely on the MSA agreement, Your Honor. So those are the only 2 points I wanted to make as to STEC, and I appreciate it.
Okay. Anything else from the counter defendants? All right.
No, Your Honor.
Okay, we're going to take, let's call it a 9-minute break. Be back at 2:50. Then I'll let Ms. Whittle, or I thought I saw somebody else from your firm a minute ago, but I don't. But first, I have a off-the-topic question. I just wonder, Ms. Friel, do you have a stand-up desk, or do you just have a little lectern you stand at for Zoom hearings?
Vincent and Elgins has a setup for us. I have a light. I hope it works. I actually think it might be better to do like Guthrie and sit behind a desk, but yeah, it's a podium.
Okay, I just wondered, used to work for an attorney who had a stand-up desk. I just didn't know if that's what you had and had it clean. All right, I'll see y'all at 2:50.
Thank you, Your Honor.
All right, I'm back.
Your Honor, I think Ms. Whittle's up next. We'll wait for her.
Yes.
Sorry, Your Honor, I'm ready when the court is ready.
All right, go ahead.
All right, I'll begin by sharing my screen. Your Honor, first of all, I'd like to address Steck's argument. It is true that our theories of liability against Steck for the tort and statutory tort claims are based on respondeat superior and vice principal theories, and that those would have begun in 2016. So that any statute of limitations claims they might have should be denied, Your Honor, because the claims could not have accrued outside of the statute of limitations period. And the court has already denied Steck's summary judgment motion for on statute of limitations with respect to contracts, breach of contracts other than the rental payments. So that has already been decided by the court. So may it please the court, the coal companies filed a traditional motion for summary judgment as to the statute of limitations. The case law requires that the coal companies must conclusively prove all of the elements of their limitations defense as a matter of law. Because counter defendants failed to prove when any cause of action accrued, the court should deny their motion for summary judgment. And because the burden lies with the coal companies to establish the affirmative defense of limitations, and they have failed to meet this burden, the inquiry stops there. The court should not examine the peelers' exceptions to the statute of limitations, because requiring the peelers to rebut a defense whose elements the counter defendants have not established as a matter of law would improperly shift the burden onto the peelers. As a threshold matter with respect to the breach of contract claims, the court already denied Steck's motion for summary judgment on the breach of contract cause of action with respect to the statute of limitations. That is, except with respect to the unpaid periodic and or acreage-based fixed amount payments due under the mineral lease. For all the same reasons, the court denied Steck's separate motion for summary judgment on statute of limitations grounds. The court should deny this motion. First, the peelers' breach of contract claims cannot be barred by the statute of limitations because San Miguel's breaches are continuing to this day. San Miguel's breaches of contract continue each day. It does not properly restore the areas on the Peeler Ranch affected by the mining operations and fails to pay the peelers the reasonable market value of the buffer zone lease property that has been permanently damaged. The statute of limitations does not bar a claim or recovery for a continuing breach of contract, but San Miguel's arguments completely ignore the ongoing nature of the breaches, which the peelers pleaded. San Miguel nowhere demonstrates that the breaches are not, in fact, continuing. They do not even attempt to show this. On this basis alone, the court should deny the motion for summary judgment as to the peelers' breach of contract cause of action. Second, even if San Miguel's breaches were not ongoing, under continuing contracts such as the buffer zone lease and the mineral lease, the limitations period does not commence until the contract is fully performed. Because San Miguel makes no attempt to show, and indeed it is undisputedly not true, that the two contracts at issue have been fully performed, San Miguel fails to establish when the peelers' causes of action for breach of these continuing contracts accrued. San Miguel argues that the peeler's position that the mineral lease term has ended pursuant to its habendum clause is counter to this argument, but that's not true. The mineral lease is a continuing contract that has not been fully performed. It was continuing during its term, unquestionably, and it has not been fully performed, unquestionably. That said, San Miguel has ongoing continuing obligations to pay loss of use payments and to restore the property post-lease. In other words, San Miguel has not performed the restoration and payment obligations that remain due subsequent to the secondary term of the lease. Lignite production ceased in 2004, ending the term of the mining lease per the habendum clause. The peelers allowed San Miguel access for 14 years after the lease ended in order for San Miguel to perform its restoration obligations. But the post-secondary term restoration obligations continue and have not been performed. As to the mineral lease, the peelers have sued San Miguel and STEC for failing to meet the mineral lease's restoration obligations, which require in part that the lessee timely begin and diligently pursue restoration efforts until the property is restored to its original state and condition and returned to the peelers. The court has already denied summary judgment on statute of limitations grounds with respect to STEC other than as to the periodic rental payments. And I'll just note this misleading nature of the quotes that, or the way that counsel for San Miguel framed that breach of contract obligation. It is not that restoration has to be concluded within 6 months of excavation of an area. It has to commence within 6 months and then be diligently prosecuted until completion. With respect to San Miguel, the motion does not provide evidence of when San Miguel began, might have completed, or should have completed its restoration of the Peeler Ranch and returned it to the peelers. While there is no dispute that areas of the ranch have not yet been restored, San Miguel maintains that it has not breached the lease's restoration provisions. In fact, San Miguel claims that its obligation to complete restoration under the mineral lease does not arise until at least 10 to 15 years after 2037, when all mining in the San Miguel lignite mine is expected to end, and that STEC, as San Miguel's customer, will make the decision as to when the mineral lease has ended, and the leased premises are to be returned to the peelers. That testimony from the San Miguel corporate representative is attached as Exhibit A to our response. Under San Miguel's theory, the peeler's cause of action for restoration cannot possibly be barred by limitations because, based on San Miguel's argument, it would not even accrue for another half century. Accordingly, San Miguel has failed to even meet its threshold burden to establish, without reliance on disputed material facts, the date the peeler's cause of action for restoration accrued. So it is not entitled to summary judgment that limitations bars the peeler's contract claims. As to the buffer zone lease, San Miguel bears the burden of proving exactly when permanent damage was inflicted on the buffer zone property, which the motion does not even attempt to do. Again, the court already denied STEC's motion for summary judgment on statute of limitations grounds for the buffer zone lease. So this motion regarding the breach of contract claim applies to San Miguel only. The peeler's buffer zone lease claim is for breach of Article 8, which requires the lessees to pay the peelers if operations on or related to the plant site cause permanent damage to the leased premises. According to the plain language of Article 8, the 4-year statute of limitations for breach of contract cannot start to run until permanent damage is inflicted on the land subject to the buffer zone lease. To meet its burden to prove that limitations bar the peeler's breach of contract claim for the buffer zone lease, San Miguel must concede that in fact there is permanent damage to the buffer zone lease premises, offer conclusive evidence that the permanent damage occurred prior to August 14th, 2014, which is 4 years prior to the date the peelers asserted their claims, and then demonstrate that all of the peelers' possible defenses to limitations fail as a matter of law. San Miguel has not even attempted to satisfy this burden. The only argument it offers is that the peelers noticed dying grass and brush on their property within the buffer zone lease premises 10 years ago. But this argument reveals nothing about when damage caused by wastewater seepages, spills, or releases from the coal ash impoundments, which is on San Miguel's property within the plant's fence line, to the buffer zone premises became permanent, which is the triggering condition entitling the peelers to performance of Article 8. And the evidence shows that when Mr. Peeler pointed the area concerning him out to San Miguel told him his cattle were causing the damage. They even got a study to show him his cattle were causing the damage. San Miguel's limitations argument succeeds only if the fact that permanent damage has occurred is so obvious that as a matter of law, the peelers lacked due diligence in not knowing that it had already arisen prior to August 2014. The buffer zone does not contain any ash piles or wastewater impoundments. The damage was caused by the accumulation over time in the soil and groundwater of toxins from plant coal ash, which were introduced by intermittent wastewater overflows, the underground seepage of wastewater, and fugitive dust. San Miguel contends that the peelers are charged with knowing as a matter of law that invisible toxins in water, which largely traveled into the affected land underground, and blowing dust had accumulated in the buffer zone, that these invisible toxins had damaged the land, and further that such damage had become permanent. Neither the migration of the toxins into the buffer zone nor the permanence of the damage is open and obvious. San Miguel's own expert testified that it is not known with certainty how long the coal ash impoundments have been contributing to groundwater impacts under the Peeler Ranch, and that a person could not look at the ground and know that there was impacts to the underlying groundwater without installing some means of testing water quality. He also testified that San Miguel was not adequately informed about groundwater contamination until he confirmed the groundwater exceedances for coal ash constituents of concern in the beginning of 2019, which was after the peelers had filed their counterclaims. San Miguel has failed to meet its burden to obtain summary judgment on their limitations defense on the peelers' breach of contract cause of action, just as this court already ruled that STEC failed to meet its burden using the same arguments. The court should accordingly deny the motion. With respect to the tort and statutory claims, these are currently limited to the areas outside the leased premises and include both direct harm and stigma damages. In order to prevail on their motion for summary judgment, the coal companies must conclusively prove as a matter of law when the peelers' causes of action for harm outside the leased premises accrued. They have made no attempt to do this, and their motion should be denied. Within days of receiving a letter from Alonzo and Barbara Peeler in June 2018, notifying San Miguel that the mining lease term had ended, San Miguel, at Mr. Kezar's direction, began a series of massive ash-contaminated wastewater discharges over the Peeler Ranch outside the lease boundary in an effort to dewater Area A of the mine. Mr. Kezar testified that he knew that the wastewater was high in salt, but he approved the discharge over the Peeler Ranch outside the lease boundary because it was the most expedient way to get rid of that water. These discharges indisputably fall within the governing limitations period. So at a minimum, the peelers maintain causes of action for tortious harm to their property outside the lease premises as a result of these massive wastewater discharges, which occurred in June, July, and August 2018. And those wastewater discharges were part of a continuing tort, both planned and unplanned wastewater discharges to the non-leased Peeler Ranch that occurred prior to the summer of 2018 and continue to this day. San Miguel attempts to convert itself into the aggrieved party with these motions, claiming the peelers forced San Miguel to sue. But that's ridiculous. San Miguel chose, instead of talking to Mr. Peeler or his lawyers, as he requested in a series of letters beginning in April 2018, San Miguel chose to begin massive wastewater discharges over the peeler's land to get rid of this problematic water that it had been studying since 2004. Then, when the Railroad Commission and TCEQ would not help him out, he said, "Enough is enough. You're locked out until we can sort things out," which he had to do in order to protect his ranch outside the leased areas from further intentional harm. And then, instead of calling Mr. Peeler or his lawyers as the letter requested, or even responding with its own letter, or agreeing to the meeting Mr. Peeler had asked for back in April 2018 after the Easter weekend coal ash spill from the power plant, San Miguel sued the Peelers with a massive, broad sweeping petition, claiming to this court rolling blackouts in the state of Texas would occur if San Miguel could not access the Peeler Ranch, property it had essentially been ignoring and abusing for over a decade. The Peelers didn't cause San Miguel to sue. San Miguel made the decision to try to roll over Mr. Peeler after he had been patient and generous and easy to work with for decades. San Miguel was represented by 3 law firms at the time: Dykema Cox, Elder Roth Bray, and Jackson Walker. San Miguel had competent, talented counsel and chose to sue the Peelers. This court should not feel sorry for San Miguel because it chose to fight the Peelers instead of negotiating. In any event, the tort and statutory claims should not be dismissed under statute of limitations grounds. The coal companies failed to offer any evidence of the date on which the Peelers' tort and statutory claims accrued, and they therefore cannot conclusively prove their limitations defense on those claims either, which is their burden. Specifically, the evidence submitted by the coal companies does not establish when the leaks, seepages, and overflows from the surface impoundments at the plant or the mine pits and ponds, or the fugitive dust that they failed to control, deposited enough accumulated contaminants to pollute the Peeler land and groundwater, thereby giving rise to the Peelers' tort and statutory causes of action for the unleased areas. All of the testimony that Ms. Frio referenced had to do with the leased premises. You'll note she did nothing to demonstrate any of that testimony had to do with harm outside the leased premises. She did not show the court any maps to demonstrate what that testimony was actually referring to, which was within the leased premises. Indeed, they cannot even claim to have established this prerequisite to assert a limitations defense because they maintain to this day that no such pollution has ever occurred. In fact, they've argued repeatedly to this court that the Peelers cannot maintain a cause of action for tortious harm to real property until the Peelers can establish an exceedance of a regulatory threshold for a chemical of concern, which, even if such regulatory standards existed, would require repeated testing to determine when such an exceedance might have occurred from repeated injury over time. They insist that no pollution sufficient to give rise to the Peelers' causes of action for tort and statutory violations has ever occurred. And yet the Peelers should have known that the pollution was present so long ago on the land outside the leased premises that limitations now bars their claim. This position is self-contradictory and unsustainable. And it's worth noting once again just how large this property is. It's over 20,000 acres. For Mr. Peeler to have seen dying grass outside the buffer zone, which San Miguel blamed on his cattle, doesn't mean he should have known about claims he might have had in the off-lease areas for other wastewater and ash discharges. The coal companies cannot escape their burden to establish the date of accrual of the causes of action by insisting that the causes of action, in fact, have never accrued. The Peelers cannot be both too late and too early at the same time. As their only evidence of the date of accrual of the Peelers' tort and statutory causes of action, which the court limited to the unleased premises, the coal companies point to publicly recorded deeds for ash disposal within the leased premises. These deed records offer nothing to establish exactly when the coal companies trespassed or were negligent on the Peeler Ranch outside the leased premises with their toxic wastewater and chemicals, or when they violated applicable mining
Hello?
I lost it too, Your Honor.
Okay.
Mary, if you can hear us, we can't hear you.
I can't hear her either.
There are ice storms here in Austin.
It's not quite that cold here, but you may have seen me looking up previously when all the rain came. I'm the only one who got, I won't say paranoid, but concerned about some things at law school, like being in a flat roof building during a storm or.
I will tell you, being pregnant and having children, having read those cases, that was bad.
There was a time when I was in law school when I would worry about stepping on the metal grates or metal doors that lead down to the basements in front of buildings in downtowns, because I'd read so many cases about people breaking their legs, falling down inside them. I don't bother anymore.
Yeah.
So hopefully she'll sign back in.
I do hear it's worse for doctors.
Oh, yeah.
They learn all those diseases, and in med school, they get paranoid.
Judge, those grates still scare me. I walk around them.
Your Honor, sorry for the informality of I wasn't planning to make an appearance today, but I was listening in. I just got a text from Miss Whittle. She said the power went out at her house, and they're trying to, or power went out. I don't know if she's at the home or the office, but they're trying to fix it. But I can let you know once I hear from her. You know, but if you apologize.
Okay, that's fine. I've got some things I can work on, and sometimes they fix it real fast. If it's trees with ice falling on power lines, it may take longer.
Sure. I'll keep you posted either here or in the chat once I hear.
Okay, I'll be here.
Thank you.
Mary Keaton told us that your power went out.
Yes, it is back on. Took a little while. My internet's not working, but I'm basing it off my phone. So hopefully that will be stable.
All right, Ms. Cavazos, you ready? Right. Go ahead, Ms. Whittle.
Okay, yes, Your Honor. Okay. Ms. Cavazos, can you tell me where I dropped off?
Let me check. Negligent on the Peeler Ranch outside the leased premises with their toxic wastewater or chemicals or with a violated applicable mine.
Okay, thank you. So, Your Honor, had San Miguel complied with the lease limitation on peeler coal ash, then the deed disposal records would be evidence of nothing more than the disposal that had been agreed to within the leased premises. How do these deed records from the 1980s and 1990s demonstrate anything regarding Kiewit's disposal of off-lease coal ash on the Peeler Ranch in open piles from 2011 to 2016, which then later caused harm to the off-lease premises? And how do these deed records demonstrate anything regarding the wastewater seeps that San Miguel allowed to develop in the 2004 time period within the leased premises, later spreading underground to the off-lease areas? And how do those deed recordations demonstrate anything with regard to the coal ash infused wastewater held in the pits and ponds within the leased areas, which San Miguel failed to address until it started discharging the wastewater over the Peeler Ranch outside the leased area in the summer of 2018? Those deed records, which do not come up when you search for records for the Peeler Ranch, they only come up when you search for San Miguel. They would not have caused anyone who found them to discover the harm that occurred from actions outside of what was recorded and many years later. Again, we're talking about harm to the off-lease premises. How were the peelers supposed to know that what San Miguel was doing on the leased premises was causing harm off the lease? The coal companies have failed to offer any evidence at all, much less establish as a matter of law when the peelers' tort and statutory causes of action accrued. So they have failed to meet their summary judgment burden as to the peelers' statutory and tort claims as well. With respect to the declaratory judgment cause of action, as a threshold matter, the peelers have agreed to dismiss their declaratory judgment cause of action against Kiewit. So this doesn't apply to Kiewit. San Miguel and Steck's argument that limitations bars two of the peelers' declaratory judgment claims merely piggybacks on their arguments addressing the peelers' tort claims. This vague, non-specific reference is insufficient to meet their burden to establish when the peelers' declaratory judgment causes of action accrued. They cannot establish that coal ash toxins on the peeler property accumulated in the soil and groundwater so as to pollute and injure the property prior to 2014, because they insist that such pollution has never occurred. The motion should be denied. So in sum, Your Honor, the coal companies have failed to meet their burden, so the court should not even reach the peelers' exceptions to the statute of limitations. But if the court does reach the exceptions, the coal companies have failed to rebut those as a matter of law as well. The coal companies must conclusively disprove each of the pleaded exceptions to the statute of limitations. And counsel for Kiewit is correct that we do not plead that the Texas Civil Practice and Remedies Code section 16.069 applies to Kiewit, nor do we plead that fraudulent concealment or equitable estoppel apply to Kiewit. But for the other two defendants, we believe that all of these should be held against them. San Miguel initiated this lawsuit against the peelers. and therefore Texas statute squarely bars San Miguel from asserting limitations as a defense against any of the peeler's counterclaims, because those counterclaims arise out of the same transaction or occurrence as San Miguel's claims, and the peelers asserted them within 30 days of the peeler's answer due date. The peelers filed their original counterclaim petition, which asserts all of their current causes of action, the day after San Miguel sued them. This is well before the section 16.069's deadline of 30 days after the peeler's answer due date. This exception, again, does not apply to Kiewit, but we believe it should apply to Steck as the contract general manager of San Miguel. All of the peeler's claims arise out of the same transaction or occurrence that forms the basis of San Miguel's lawsuit: San Miguel's possession of and activities on the Peeler Ranch pursuant to the parties' leases and other agreements. San Miguel's original petition referenced past mining, ongoing reclamation, and ancillary activities on the Peeler property. It was broad sweeping in scope, incorporating all of the agreements between the parties over the years, the history of the mine and the plant, and the relevant regulatory requirements, including the same reclamation requirements the peelers rely on for their negligence per se and statutory counterclaims. It's worth looking back at that original petition and the accompanying affidavit and exhibits from Mike Kezar, the general manager of both San Miguel and Steck. Council's current portrayal of that petition as narrowly tailored simply does not pass the smell test. San Miguel's sole authority for its argument that the peeler's claims do not have a logical relationship to the dispute that was involved in the claims San Miguel filed, in fact, establishes the opposite. It cites to Freeman versus Cherokee Water Company at 11 Southwest 3rd 480. In that case, the plaintiff filed a lawsuit seeking interpretation of one provision, a single paragraph of a deed. The defendant counterclaimed, asserting that the deed was fraudulently executed. Because the circumstances surrounding the execution of the deed concerned entirely different essential facts than the proper interpretation of a single paragraph of the deed, the two parties' actions were not logically related, and Section 16.069 did not apply. In other words, the single cause at issue had nothing to do with the basis for the fraud claim. Freeman is easily distinguishable from this case. The Court of Appeals in that case noted in particular that the fraudulent inducement claim didn't involve the interpretation of the deed. But here, San Miguel's causes of action and the peeler's counterclaims involve interpretation of the same leases and agreements cited in San Miguel's original petition and appended to the Kezar affidavit. For both claims, the question of what is and what is not allowed by the parties' contracts is controlling. San Miguel's attempts to portray its request for a sweeping declaration that San Miguel has the right to unfettered access and use of the Peeler Ranch as a narrow, circumscribed request is frankly complete nonsense. San Miguel also sought a permanent injunction prohibiting the peelers from obstructing San Miguel's free and uninterrupted use of the peeler lease premises in any way. And San Miguel based its request on its historical and ongoing use of the premises and regulatory requirements it must meet. The existence and extent of San Miguel's ongoing rights under the peeler leases turn on exactly the same essential facts underlying the peeler's various claims, including whether the leases remain in force, the duties to mine and restore the Peeler Ranch, and whether San Miguel's mining and restoration activities have caused them harm by way of contract, tort, and statutory violations. Section 16.069 squarely applies. Texas courts apply a logical relationship test to determine whether counterclaims arise out of the same transaction or occurrence. The logical relationship test is met when the same facts, which may or may not be disputed, are significant and logically relevant to both claims. Here, San Miguel cited and appended all the leases and agreements relied on by the peelers for their claims, including the buffer zone lease, which San Miguel claims in its reply was not included in the original petition. It's easy to demonstrate that it was. Paragraph 22 of the original petition describes the buffer zone lease, cites to it, and claims the peelers have threatened to interfere with San Miguel's rights under that lease. It was also appended as an exhibit in the Kizar affidavit and discussed in the affidavit. And San Miguel argued to this court on Tuesday that all of the peelers' counterclaims within the leased premises are governed by the same contracts that San Miguel sued over. Because the same facts would be needed to resolve both claims, the logical relationship test between San Miguel's claims and the peelers' claims is clearly met. The peelers' counterclaims are squarely related to San Miguel's actions and omissions, which bear on whether San Miguel is entitled to the rights it asserts. With respect to their public policy argument, again, no one forced San Miguel to sue the peelers. The peelers wanted to stop the massive wastewater discharges that San Miguel started as soon as Mr. Peeler said he was concerned about the pollution and thought the lease was over and wanted to sit down and have a conversation. San Miguel made a choice to sue and had 3 law firms advising it that were all perfectly able to explain the consequences of filing such a wide-ranging lawsuit, especially a lawsuit that was so over the top as to allege rolling blackouts in the state of Texas with no actual support for such a preposterous claim. Bigger and better coal plants have retired in the state of Texas with no impact on the electric grid at all. The peelers didn't outsmart anybody. They were waiting for San Miguel to agree to discuss the issue when their counsel notified me that he was filing a TRO and setting a hearing. In any event, San Miguel has pointed to no precedent where a court has declined to apply Section 16.069 because a plaintiff was supposedly forced into filing a claim. So in addition to there being no facts and evidence to support such an assertion, there is also no law supporting San Miguel's position that public policy warrants disregarding the plain language of the Texas Civil Practices and Remedies Code. And San Miguel knows this is a bogus claim, or it wouldn't have waited over 2.5 years after significant discovery and lots of briefing to finally argue that Section 16.069 didn't revive the peelers' claims that might otherwise be barred. This is a last-minute Hail Mary, and the court should reject it. Ms. Frio argued today that we have rules for a reason, but she's asking this court not to make her client be bound by them. The coal companies also failed to negate the discovery rule because they have not conclusively shown when the peelers discovered or should have discovered their claims. Paragraphs 183 to 193 of our current pleading lays out the peelers' discovery of the contamination starting in November 2017, when it first engaged environmental consultants to investigate possible sources of contamination on the ranch, given apparent recent changes to the landscape, vegetation loss, water seepage, and a fish kill in a tank previously stocked with bass. There's no evidence suggesting that the peelers knew or should have known of the harm the coal company's pollution was causing on their property more than 2 years, much less 4, before they filed their suit in 2018. As pled at paragraph 217 of the counterpetition, San Miguel had a contractual responsibility under the mineral lease to return the site to its previous condition, and under the buffer zone lease to comply with state and federal environmental laws. The peelers justifiably relied on San Miguel's reclamation expertise and contractual obligations. The contamination that has resulted from the coal company's actions and the difficulty of returning the Peeler Ranch to its previous state and condition was inherently undiscoverable and is objectively verifiable, in part because mining necessarily destroys the property. So the peelers could not have known that reclamation had been postponed for too long for full restoration, or that San Miguel's wastewater management practices were causing harm that could not be undone. As recently as June 29, 2018, personnel from the Railroad Commission dismissed the peelers' concerns regarding the apparent changes in the property from the ash disposal and wastewater discharges practices, claiming coal ash is safe and approving the massive discharges over the peeler land as allowed by permit. The peelers were not aware of the widespread contamination until after March 2018, when San Miguel notified the peelers of a coal ash spill from the plant over Easter weekend and also published its 2018 groundwater monitoring report on the San Miguel website as required by the federal coal ash rule.
Your
which
Honor,
then-
I'm sorry, this is Mark Guthrie. I need to object. We're way outside the scope of the summary judgment evidence that they've submitted.
Your Honor, this is all in our pleadings. It's
I'll-
literally.
I'll
quoted
join
from
that
our-
objection.
Pleadings are not, your own pleadings are not competent summary judgment evidence.
Right, Ms. Whittle, is this in your summary judgment evidence?
We cite to our pleadings and our summary judgment evidence, Your Honor, and all of this is actually before the court in many pleadings.
Your Honor, the
Right,
late
I'll
law
sustain the
case-
objections.
So, Your Honor, San Miguel's massive wastewater discharges from the mine began in June 2018, and the peelers filed their claims in August 2018. Prior to 2018, the peelers reasonably believed that San Miguel's purported restoration was addressing any impact from the mining that they had observed. And indeed, San Miguel repeatedly assured Mr. Peeler that this was the case. The court heard counsel for San Miguel just recently arguing that if the peelers will just be patient, then San Miguel will restore their property as required under the leases. So when were the peelers supposed to know that was not true, or that it was no longer possible or economic to restore the property? Counsel for San Miguel admitted at the hearing on the San Miguel causes of action that mining looks bad. It destroys property, which then has to be restored. How were the peelers to know what they were looking at wasn't quite right?
Your Honor,
San-
again, not summary judgment evidence. I object.
I'll allow this, overrule that objection. I think this is argument, not stating facts. So go ahead.
So that San Miguel and its contractors were taking liberties or unreasonably delaying. These are questions of fact that cannot be decided at a summary judgment. The evidence shows that the peelers were unaware that the fugitive coal ash dust seeps and discharges had caused harm to their soil and groundwater. They cannot have been expected to know that the invisible pollution that was accumulating in the soil and water under their property was causing this problem. San Miguel knew and kept it from Mr. Peeler. San Miguel pushed
That
Mr.
is not
Peeler-
in the record.
It is in fact in the record, Your Honor. The testimony about San Miguel asking, or Mr. Peeler asking San Miguel about the area outside of the buffer zone, and them telling him it was caused by cattle. That's absolutely in the record and attached.
It is not attached to your pleading, and what you just described is contradictory to what you said before. Aren't the same thing.
All right. Is it attached to your response, Ms. Whittle?
Yes, it is, and it's also in the record in multiple pleadings, Your Honor. There's deposition testimony both from Mr. Kezar and from Mr. Peeler about that communication.
The communication involving the cattle, I agree, but making a broad statement that they hid it. No, what's in the record is that San Miguel hired a consultant and they looked at it and said it was caused by cattle. That's very different than a blanket statement that we fraudulently hid what was happening out there.
Okay. The evidence, when I look at it, will speak for itself, but please go ahead.
So, Your Honor, the point is their argument that Mr. Peeler should have known by looking at this can't withstand scrutiny, because when he asked San Miguel, who was supposed to be the expert he was trusting, who was supposed to restore his property, they told him they'd gotten a study and all of this was caused by his cattle. Because the coal companies offer no conclusive evidence that the peelers knew or should have known that their activities were causing his property harm, especially when all the parties agree that mining is a destructive activity, the coal companies have failed to satisfy their summary judgment burden to negate the peelers' claim that the peelers did not know their causes of about their causes of action until after 2016. The coal companies, and again, this doesn't relate to Kiewit, also have failed to negate the peelers' fraudulent concealment exception to the statute of limitations. Fraudulent concealment suspends the running of the limitations period. Evaluating fraudulent concealment requires inquiry into disputed facts. Those disputed facts include when the peelers should have known coal ash toxins were accumulating on their property, whether and when the harm became permanent, and when the coal companies possessed information regarding pollution or permanent damage to the leased premises that they had a duty to disclose. For the same evidence that we have attached demonstrates that San Miguel had actual or constructive knowledge of the dangers of the improper handling of coal ash, and that they have been evaluating impacts to the Peeler Ranch from San Miguel's wastewater disposal activities in the plant and the mine. They even developed cost alternatives and cost estimates for addressing the pollution and presented those to the San Miguel Board of Directors over many years. And San Miguel staff repeatedly assured Mr. Peeler, we will take care of it. That's the testimony Ms. Frio showed you earlier today. He repeatedly was told that, which he testified to. More specifically, San Miguel knew that its surface impoundments and landfill at the plant were causing contamination of the groundwater since at least May 2016, when San Miguel began testing pursuant to the federal coal ash rule.
Objection, this is the same ground we covered. That's not attached to your pleading, and the Kate's deposition that is cited here on your slide isn't in your pleading, attached to your pleading.
All right, now let me look, and it's 1B. It's 202 pages, and are there additional documents or things that are cited in the answer but are not physically attached or that didn't make it to me?
All the exhibits that were included in the box version.
The Kate's deposition should be attached as an exhibit, Your Honor.
Okay, and how do you spell that?
CATES.
Videotape deposition of Dan Cates. Okay, Ms. Frio, your objection was?
That it wasn't attached. It wasn't on my list. Maybe I don't have the right list. What exhibit is it?
I don't know. It.
If you see it, Your Honor, then I just didn't make it onto my list. But I have Burris, Kezar, Mr. Peeler, Hemingway.
We have a lot of exhibits, Your Honor.
All right, well, it's starting at page 180. I assume it's just excerpts, but.
Then I'll withdraw my objection.
Go ahead.
Well, Your Honor, we attached the deposition testimony supporting these allegations in our response, including from Mr. Kezar, who is both STEC and San Miguel's general manager and made decisions about concealment from Mr. Peeler during the time STEC was acting as a contractor to San Miguel. To the extent Ms. Frio disputes these facts, that demonstrates that she has not met her burden because counter defendants cannot conclusively prove that they did not fraudulently conceal material evidence, and they've not even attempted to do so, they cannot establish their limitations defense as a matter of law. And the Peelers also pled sufficient facts for an equitable estoppel defense. Equitable estoppel bars the limitations defense when a party makes representations that induce a plaintiff to delay filing suit until the limitations period has run. The evidence laid out in our response discussing fraudulent concealment also creates a fact issue regarding equitable estoppel of the statute of limitations. Additionally, evidence in the record demonstrates that San Miguel repeatedly reassured the Peelers over a period of many years that they were complying with their contractual restoration obligations and that they were, quote, working on the pollution on the Peeler Ranch, thereby inducing the Peelers to delay enforcement of their rights. So the evidence of the existence of evidence supporting an equitable estoppel exception bars summary judgment that the peeler's claims are barred by limitations. Finally, the continuing tort doctrine should apply to toll limitations for the tort and statutory tort claims against all counter defendants, because the coal company's tortious conduct was and is multifaceted and caused and continues to cause numerous discrete injuries to the peeler's land and water. There's been no single tortious act. There have been countless discrete torts causing countless and ongoing injuries to the peeler's land and water. So a limitations bar should not apply in this case. The only real defense to this made by the coal companies is that the continuing tort doctrine does not apply to our breach of contract cause of action, but we made that plain in our counter petition by noting that it applies to only counts 2 through 5. So I'm not sure why that's an argument. The coal companies also turn the law of continuing torts on its head and argue without support that the law grants them a free pass to repeat their wrongful conduct at will, indefinitely continuing to increase and compound the peeler's injury with no liability, because the limitations began to run the first time they violated the peeler's rights. And once it has run, they can never sue again for subsequent repeat tortious conduct. Again, this is counter to their position that the peelers have to wait until the pollution reaches some regulatory standard before they can bring a claim or their claims have accrued. In any event, the doctrine of continuing torts, in fact, provides the opposite. A plaintiff subjected to injury from a series of repeated events is not subject to limitations until the final instance of the defendant's wrongful conduct. Because the leaks, seepages, overflows, discharges of water, and the fugitive dust incursions all continue to this day, the coal companies cannot invoke limitations as a defense against any of the peelers' claims based on contamination from those invasions. They argue that the continuing tort doctrine does not apply in cases of permanent injury to property, and as such, it should not be applied to the peelers' tort claims because they pleaded alternative claims of temporary and permanent injury to their property. But the court has not yet determined whether the injury to the Peeler Ranch is permanent or temporary, and this disputed issue precludes summary judgment on a theory that would only apply if the harm is found to be permanent. The coal companies provide no evidence to establish that the injury to the Peeler Ranch is in fact permanent, and their expert Mark Hemingway testified otherwise. Fact issues exist as to whether the damage to the Peeler Ranch can be repaired, fixed, or restored, and as to the potential recurrence of the injury. The Texas Supreme Court has confirmed that harm to real property can qualify as temporary under the court's definition, yet ultimately be treated as permanent for the purpose of calculating damages if the cost of repair is unduly high. In such a situation, the continuing tort doctrine would govern the running of the limitations period, even if the harm were ultimately deemed permanent because of something like the economic feasibility exception. Contrary to Kiewit's statements today, the peelers have never conceded that harm to the area outside the leased property, which is what's at issue with respect to the continuing tort doctrine after the economic loss ruling. The peelers have never conceded that the harm in that area is permanent under the test set forth by the Texas Supreme Court. We pled alternately that the harm was temporary or permanent. That's an issue that the court has yet decided. These issues remain unresolved and cannot be resolved without considering disputed issues of fact. Because the coal companies have wholly failed to establish that the harm to the Peeler Ranch is permanent, they cannot negate the peelers' continuing tort exception to their limitations defense. And so summary judgment should be denied. In summary, the coal companies have failed to conclusively establish as a matter of law when the peelers' causes of action accrued. They have also failed to negate as a matter of law each of the peelers' exceptions to the statute of limitations. Because they've not met their burden, the court should deny the motion. That's all, Your Honor. Thank you.
Briefly, Your Honor.
Let me ask on the issue of the ash being dumped on the property that came from off the peeler's premises. Do you agree that Mr. Peeler knew about that a very long time before 2018?
He was told, he testified that he was told by San Miguel that they would take care of it. That they would remove it.
And is that in your? So the response is that he was told that by San Miguel that, yes, we're dumping mountains of ash from other pieces of property on your place, but one of these days we're going to take care of it, or?
Yes, Your Honor. He believed that they were going to restore his property and remove the ash that they had placed on there that was from other places based on that conversation.
And where is that in your summary judgment evidence?
Well, it's in the quote that Ms. Friel read from Mr. Peeler, where he said they were going to take care of it. And we attached additional quotes from Mr. Peeler talking about how they said they would take care of it. But again, Your Honor, that would be for the lease property. So it would be only with respect to the breach of contract claims. And I think it's undisputed that San Miguel filed the lawsuit against the Peelers regarding all of their rights and obligations under all of the leases, deeds, and agreements. And so interpretation of what their rights are clearly falls within the same facts and occurrences. So Texas Civil Practice Remedies Code saves those claims.
Your Honor, if I may, you ask an important question, because the Peelers also claim that this offsite ash led to their off-lease premises damage. And they complain that KMG is responsible for it. But Mr. Peeler found out about this around the year 2000, 11 years before KMG got to the property. I disagree also with Ms. Whittle about the state of the summary judgment evidence in terms of exactly what it was he believed he was told, other than I do believe the excerpt is in there that he was told, according to his testimony, that it would be taken care of, but that's sort of vague and non-specific.
I think, Your Honor, that goes to disputed facts.
Actually, goes to notice, Your Honor. I mean, he was on notice that offsite ash was being placed. And in fact, since mining stopped on the Peeler Ranch shortly after that, any ash that he saw being brought to that pile after 2004 by necessity had to be from ash off the lease premises.
Pardon me. Are we ready to move on to the next motion?
I just had a couple things to say in reply. Your Honor, I think Alonzo's Peeler's deposition testimony speaks for itself. The fact that he raised an issue with two people who aren't even at the plant anymore, Marshall Darby and Gerald Cambry, and they said, I'm working on it. That doesn't rise to fraudulent concealment. Opposing counsel wasn't able to distinguish or tell us why the BP versus Marshall case or the Exxon versus Lazy R Ranch case don't control here. We went over those cases in detail in our opening argument. They control, and they show that San Miguel should prevail. There's this idea out there that somehow we can't assert statute of limitations unless we also concede all of the claims as the Peelers asserted. That's just not right under the law. We can certainly contest that there's permanent damage, while also saying that the Peelers were on notice that what they saw with regard to the seeps and the dead vegetation triggered the notice that they had to diligently inspect, and they had a duty to investigate. And finally, Your Honor, you asked me a question earlier about, so the Peelers just flat out of luck since they didn't raise these 20 years ago. And just recall that this is a highly regulated mine, that while the peelers might not agree with how the Railroad Commission has regulated it, they have a remedy. They have the Railroad Commission, an agency that they can go to and take their problems to. They wanted to go to civil court. They should have done it a long time ago. So with that, you have my argument.
Your Honor, I just have a couple of points really quickly. The peelers have not submitted sufficient summary judgment evidence of their or sufficient to raise a fact issue on their discovery rule or their continuing tort excuses for avoidance of the statute of limitations. Thank you.
Your Honor, I'll be equally as brief if you'll indulge me. On my 2 points, Your Honor, the only issue as to 16069 that Ms. Whittle raised as to why it would apply to STEC was because STEC arguably shared a general manager with San Miguel, and therefore, and again, not to put words in her mouth, we were one and the same, so to speak, so that we should be bound by the saving statute as well. That is not what the law is, Judge. We are clearly a separate entity from San Miguel. That is why the peelers had to join STEC as a third-party defendant. And the rule is clearly that third-party claims do not fall under 16069. Last point, Judge, is Ms. Whittle made a point to mention that the STEC claims that allegedly arise, the STEC tort claims that allegedly arise out of the MSA agreement that was entered into in 2016, that there are numerous discharges and things that occurred after 2016 that are clearly within the limitations period based on the filing in 2018. As Ms. Frio showed you with her chart, I don't think there's any argument as to those discharges, but it's important to note as to STEC, the tort liability, to the extent there could be any, doesn't even begin until the MSA agreement is entered into, and that's in April of 16. So anything prior to that would be barred, and we're not arguing for the things that occurred after that on a limitations ground. We have a pending summary judgment in front of you on other grounds. So there should be no tort liability as to STEC for things before the MSA agreement in 2016, because that was the sole basis for the peeler argument as to any tort liability as to STEC. And that's all, Your Honor. Thank you.
So just, Your Honor, briefly, this is a new argument by STEC and really doesn't relate to statute of limitations. I think we can concede that STEC's liability begins when STEC has started working at under the MSA, which is 2016. So limitations could not bar claims against STEC because their liability doesn't begin until within any relevant limitations period.
And without admitting there is any tort liability, we'd welcome an order saying there's no tort liability from prior to the date of the MSA, Your Honor.
I mean, that can be a separate motion that's not before the court today, but we can probably enter a Rule 11 agreement on that, Your Honor.
That's all I've got, Judge.
And the B, statute of limitations for lease payments?
Yes, Your Honor. And this is going to build off of our previous argument. As I mentioned at the outset, this is only San Miguel's motion. And so it is separate and it's distinct. And I think as you hear my argument, you'll understand why we did it separately. I will go ahead and proceed. I want to share my screen if I can. So what this separate motion is about are what are called loss of use payments. San Miguel paid these for decades. They are outlined in amendment number 2 to the mining lease in section 6, and we'll show that to the court in a moment. And the record will show there are 0 complaints about those payments until August 14th, 2018, when the peelers filed their counterclaim. So as was brought up earlier, the court did enter an order on September 28th, 2020, and it granted South Texas Electric Cooperative, Inc.'s motion for partial summary judgment on statute of limitation grounds as to the peeler party's claims for unpaid, periodic, and/or acreage-based on fixed amount payments due under the mineral leases. Your Honor, loss of use payment fits directly into that, and we're asking for the same order as to San Miguel. So Tony, I'd like to go ahead. I'll stop sharing my screen and go ahead. If you could pull up lease amendment 2, and we'll go over exactly what these loss of use payments are. Tony, do you have that one ready?
I'm having a frozen screen issue.
Okay, well, we can go, I'll go ahead and go to my next slide. It does come directly from the, and Tony, you can just go ahead and get Shell, work on getting Shell oil ready. So it does come directly from.
I've got it now if you want it.
You got it? Okay, go ahead and share then, just to show the court what we're talking about. So this is lease amendment number 2. And if you go to section 6, start on the previous page. There we go. So if you could blow it up, in consideration of and in full settlement for the loss of use of the leased premises that are affected by excavation or mining operations, the lessee shall pay to the surface owner thereof the sum of $200 per acre within 30 days after such lands have been taken from the control of the lessors, and they are denied the use, hence loss of use of the surface thereof. And in the event that such loss of use should continue for more than 4 years past the date on which this first payment is due for the loss of the use of land, the lessee shall pay to the surface owner the sum of an additional $50 per acre, which payment shall continue thereafter on each anniversary date of the date of the first payment due hereunder, until such time as lessees have restored the surface of the land to its original state and condition, and the use of the surface thereof is restored to the lessors so the peelers can use it. Provided, however, that the maximum amount which the lessees are hereby obligated to pay the surface owner, we go to the next page. So there's a maximum amount. The maximum amount shall be the sum of $500 per acre or the reasonable market value of said land, whichever is higher. But in no event shall this maximum provision be applicable until after the lessees have made every reasonable effort to restore the surface of the land to its original state and condition, as is contemplated in the preceding portion of this paragraph. So we were talking before about what makes the mining lease different from an oil and gas lease. Well, this is one of the main provisions. Oil and gas lease, you got delay rentals, you got royalties, and then the landowners get nothing. These loss of use payments are for when reclamation is ongoing, when the landowner has loss of use of their land, then they get these payments. So it is a different situation than the oil and gas contract, and it's what we're talking about today. So just to summarize, the loss of use payments, you're talking about $200 when it first happens. When that acre is first taken away from Mr. Peeler, he can't put his cattle on it, we're going to mine it. And then if that loss goes for more than 4 years, after that $200, $50 per year with a maximum of $500 per acre or the reasonable market value of the land, whichever is higher. And then finally, the maximum is not applied until after the lessees have made every reasonable effort to restore the surface land to its original state and condition. So I want to point your honor to the case of Shell Oil Company versus Ross. This is a Texas Supreme Court case from 2011. And if we could go to page 5, essentially what this court ultimately holds is that there isn't fraudulent concealment and there isn't a discovery rule under the facts of this case. So this first highlighted language pretty much lays out what the case is about. Although the Royce lease required Shell to pay the Rosses 1/8 of the amount realized by Shell for any gas or casing head gas produced from the land, Shell did not pay the Rosses based on the third-party sales price, and instead used an arbitrary price it cannot explain for the lease wells and a weighted average calculation for the unit wells. They can't even explain the amount they paid. The prices were listed on the check stubs enclosed with the monthly royalty payments weren't the same as the price. So the price they say they paid for the gas that goes on the check stub that went to the Rosses, the family, it had the wrong price on it. All right. So they were not the same price as what Shell was being paid for the gas, which Rosses argue, they say that was fraudulent. But the court said readily accessible and publicly available information could have led the Rosses to discover that Shell was underpaid royalty before the limitations period expired. The prices listed in the El Paso Permian Basin Index, which is readily accessible to the public, would have informed the Rosses that Shell was underpaying royalty. Now, we're not talking about royalty here. We're talking about loss of use payments. But certainly, if the Permian Basin Index put them on notice, the fact that their acreage has been taken away from them to be mined certainly is notice. Mr. Peeler knows where his cattle are. Mr. Peeler would know if an acre was being mined. He certainly...
Refresh my recollection. What is the nature of this claim? Is that they paid on the correct number of acres, but not the correct number of dollars per acre? If there were more acres taken than they paid on.
I have a chart for you. I wish we knew exactly what the claims were, but they're going back to, and I'll show this in a moment, until 1989 and saying we haven't paid enough loss of use payments. And the implication we got from the witness who had that chart, Carl Killian, is that it's a combination of both, that there was acreage that they didn't get paid for, and also that they did not, of the two, $500 or fair market value, they didn't reach. They should have been paid fair market value when they got the $500. So the court looks at this and they get to the next conclusion. Tony, if we go to the next quote. There's no fraudulent concealment, even though the price was wrong on the pay stub. And this case, Wagner v. Brown, we're not showing it to the court today, but it's cited in BP Oil, it's cited in the Lazy R Ranch. In Wagner v. Brown, we held that the discovery rule did not apply to defer the accrual of royalty owners' claims for underpayments, since the injury was not inherently undiscoverable, because the royalty owners could have timely discovered the underpayments through the exercise of due diligence. And our position is due diligence would have shown that those payments were underpaid. Again, we're not conceding that they were, but certainly diligence should have shown that. Similarly, in this case, the Rosses could have timely discovered the underpayments through the exercise of due diligence. We therefore hold that their claims are barred. They reverse and render judgment for Shell. All right, Tony, we can stop sharing that. Going back to the presentation. This is sort of gets to the heart of what they're saying. Okay, this is in our brief, and it comes from Carl Killian, an expert hired by the Peelers. You'll see they are reaching back to 1989 to 2019. They agree that we paid $1.2 million in loss of use damage payments, almost 1.3, but they say we should have paid 4.9. So subtracting those two, they claim an underpayment of $3.6 million, $3.7 million. And here's the kicker, which really comes into play given how old these things are. They're also hitting us with interest of $2.4 million for a total based on these surface damage payments of $6,993,870. So in the response, and the Peelers have complained, well, we asked Dave Burris, how did you calculate how much you paid in 1990? How much did you calculate? Well, that's part of the problem here. It was so long ago, he was unable to say how they calculated them that long ago. And what's, I think, highly relevant to this inquiry, Your Honor, comes in the next slide. And this is what we're not showing the exact clips, but they are attached. This is what Alonzo Peeler had to say about them. He explained that he took the rental checks to his accountant who deposited the money. So he got the checks and the checks went to the bank. He admitted that he did not monitor the payments and he never questioned San Miguel about them. Didn't ask San Miguel in 1989. Didn't ask in 1990, didn't ask in 1991, didn't ask in 1992. Fast forward all the way up until San Miguel gets hit with a lawsuit. And that's the first time they hear, oh, what do you mean you don't think we paid you enough? This classic statute of limitations situation. The loss of use payments. Mr. Peeler certainly knows when acreage was taken away from him. And with regards to the value, whether it totaled $500 or the fair market value, that was certainly, any diligence would have showed him how much he had been paid. For many of the reasons we went over in the last argument, the discovery rule doesn't apply, fraudulent concealment doesn't apply, and 16069 doesn't apply. The discovery rule, of looking at that Shell case, the Peelers got the checks. The Peelers, it's about loss of use of their own property. They certainly know what acreage they couldn't put their cattle on. And then fraudulent concealment, there's no evidence whatsoever of fraudulent concealment. I mean, in the previous argument, counsel saying we're working on it amounts to fraud, which I think doesn't pass the sniff test. But certainly, this was all very open and obvious for my client, San Miguel. And then with regard to 16069, our lawsuit's about access. Our lawsuit is about being threatened with action by the sheriff. The Peelers didn't file a lawsuit after the summer of 2008 discharges. Instead, they just threatened criminal action against my client and threatened to lock the gates and install gaming cameras. So these loss of use payments are not the same transaction in occurrence. And certainly on the very face of these are barred by limitations. And the court has already found that with regard to STEC, and we would ask for the court to do the same. The fact that the Peelers are reaching so far back into time and hitting my client with millions of dollars in interest on things that happened so long ago, just a classic case of when the statute of limitations should apply.
Okay.
I'll stop sharing my screen. So if I can.
I can stop it.
Okay, there we go. Sorry, the button just is hidden. Thank you.
All right, anyone else on the counter defendant side, Mr. Guthrie? Mr. Kirsten's gone. You already had your motion heard on this?
Your Honor, I'm here on behalf of STEC.
Okay.
We don't have anything to add at this time.
Your Honor, neither do we. I was fumbling for the unmute button. I'm sorry.
Okay. All right, go ahead, Ms. Whittle.
Yes, Your Honor. San Miguel's motion ignores the reality of the broad and far-reaching scope of its original petition and motion for temporary restraining order. San Miguel sued Alonzo Peeler, Barbara Peeler, and the AM Peeler Ranch LLC in August 2018, asking for broad declaratory and injunctive relief pursuant to all of the agreements, deeds, and easements between the Peelers and San Miguel, and alleging breach of contract. San Miguel asked this court to declare and hold that San Miguel had unfettered and total access to the Peeler Ranch for whatever purpose and for so long as San Miguel liked. The original petition includes claims regarding the 1953 coal, lignite, and mineral lease and its amendments, specifically calling out the Second and Sixth Amendments, the November 19 water deed and easement agreement, separate easements for the dragline, haul road, and retention pond.
All right, Ms. Whittle, hold on just a moment. You're breaking up there. See if your audio recovers. All right. You want to back up about 2 sentences?
Sure. The original petition includes claims regarding the 1953 coal, lignite, and mineral lease and its amendments, specifically calling out the Second and Sixth Amendments, the November 1979 water well deed and easement agreement, separate easements for the dragline, haul road, and retention ponds, the 1993 flood agreement, the 1979 transmission line easement, and the buffer zone lease agreement. With its current motion, San Miguel attempts to cabin its claims and pretend its breach of contract provision was narrowly tailored. But that is demonstrably not true, as a quick read of the original petition and accompanying affidavit of San Miguel's general manager, Mike Kezar, will show. San Miguel claimed at paragraph 23 of its original petition that a letter I wrote to its attorneys stating that the mineral lease term had ended by way of its habendum clause somehow violated, quote, several legally effective lease, easement, surface use, and right-of-way agreements between the Peelers and San Miguel, end quote. And most important for the purposes of this motion, San Miguel's original petition cites the very provision that serves as the basis for our breach of contract counterclaim. That is, the original petition cites the loss of use provision that San Miguel is now claiming had nothing whatsoever to do with its action against the Peelers. If it was so irrelevant to San Miguel's action, then why was it called out specifically? Paragraph 15 of San Miguel's original petition quotes Section 6 of the Second Lease Amendment and says, as damages for the loss of use of excavated areas, Section 6 requires San Miguel to pay $250 per acre. And if the loss of use should continue for more than 4 years, an additional $50 per acre each year until the reclamation is complete. How is it possible that this loss of use provision had nothing to do with San Miguel's action against the Peelers if it was cited to and described in San Miguel's original petition? And I'll just quickly show that to you, Your Honor. Here it is at paragraph 15 of their original petition. This is the surface damage provision for which our counterclaim is based on. It is cited in their original petition, and clearly the counterclaim savings clause applies. As the court is aware, the Peelers filed their counterclaim lawsuit the day after San Miguel filed its lawsuit, alleging, among other things, breach of the mineral lease and its amendments. Because San Miguel sued the Peelers for wide-ranging relief under all of the agreements, deeds, and easements between them, the counterclaim savings clause in section 16.069 of the Texas Civil Practice and Remedies Code revived any of the Peelers' counterclaims that might otherwise have been barred by the relevant statute of limitations. In spite of this clear statutory provision, San Miguel asked this court to find that the 4-year statute of limitations bars the Peelers' breach of contract counterclaims for failure to make loss of use payments under the mineral lease. In spite of the fact that San Miguel quotes that precise provision at paragraph 15 of the original petition, San Miguel now argues to this court that section 16.069 does not apply here because the Peelers' breach of contract counterclaim for loss of use payments owed somehow doesn't come out of the same transaction or occurrence as San Miguel's action. But the original—
It's the same provision of the lease perhaps, or the agreement, but is it the same? Are you pleading that there's a lack of consideration, or?
Well, their argument was, their petition cited to this provision. So their petition was based on the existence of this petition and their payments. I mean, Your Honor, if you recall, they were just arguing in the San Miguel cause of action motion for summary judgment that all of these payments prove that the lease is ongoing, that the fact that the Peelers accepted these payments prove that the lease is ongoing. As opposed to having ended as a result of the habendum clause. So these payments and the facts and circumstances around them are clearly relevant to San Miguel's claims and also relevant to the Peelers' counterclaims. The original petition was very broad in scope, and the lease allows access to the Peeler, the lease that allows access to the Peeler Ranch requires those loss of use payments. And if those have not been paid properly, that's a breach of the lease, which is not only an affirmative claim, but is also a defense to any claim by San Miguel that the Peelers have breached by asserting correctly that the lease term has ended. It simply is false that compliance with the loss of use provision does not arise out of the same transaction or occurrence as San Miguel's sweeping original petition. The original petition asked this court to issue a judicial declaration determining and adjudging all of San Miguel's express and implied rights to access and use the Peeler lease premises. which of course implicates the provision to pay for that access and use. When San Miguel was seeking a temporary restraining order, it used expansive and hyperbolic language about its claims against the peelers. But now, when San Miguel seeks to limit damages against it, all of a sudden its case was really very limited and specific in scope. But the court should not fall for San Miguel's game. Because San Miguel initiated this lawsuit against the peelers, Texas statute squarely provides that it cannot assert limitations as a defense against any counterclaim that arises out of the same transaction or occurrence that is the basis of San Miguel's actions. A defendant seeking summary judgment on the affirmative defense of limitations must conclusively establish as a matter of law the date on which the plaintiff's claims accrued. And they also have to conclusively prove that they're not entitled to any of their pleaded exceptions to the statute of limitations. In addition to the resuscitation of claims pursuant to section 16.069, the peelers have pled the discovery rule and fraudulent concealment. And we disagree that San Miguel has conclusively disproved either of those exceptions, of those additional exceptions. I've already talked about section 16.069 and its application to all of the peelers' counterclaims, and specifically to the breach of contract claims for unpaid loss of use payments. And I talked in the previous argument about how their one case they rely on, Freeman versus Cherokee, actually supports our position. And San Miguel's attempt to portray its request for sweeping declaration and temporary injunction as a narrow circumscribed request is just incorrect. San Miguel's ongoing rights to the property turn on the same essential facts, including loss of use payments and whether San Miguel has complied with those legal duties. So with respect to the discovery rule, San Miguel argues that the peelers knew how much money was paid to them each year, but this is insufficient to prove that the peelers should have known this payment was incomplete. San Miguel does not provide evidence or even argument showing that the peelers had or should have had the necessary information to know how much money San Miguel was supposed to pay them each year. The amount of the payment due depends on a complex variety of factors, including how many acres remained impacted by the excavation or mining operations, and in what way, which of those specific areas had been impacted for more than 4 years, whether phase 3 bond release had been reached on any acreage, whether the total cumulative payment for a specific acre had reached the fair market value, and while the peelers dispute the relevance of this, whether the peelers were grazing cattle in any specific area. San Miguel's own testimony, which we cite to in our brief and append as exhibits, makes clear the company itself cannot make sense of the payments it made to the peelers. No evidence supports the theory that the peelers should have known the proper amount due in loss of use payment, which required an expert to determine when San Miguel controlled the land and operations and even sought to conceal from the peelers that San Miguel was breaching the parties' contracts. San Miguel admits it made no effort to track the payment areas or had a process in place to determine whether payments should cease or restart. San Miguel staff testified they simply continued the payments that were being made for years with no actual analysis or further determination of what payments were actually due, and that they never sought concurrence or discussed the payments with Mr. Peeler. I'll just go to the testimony of the corporate representative, Your Honor. Dave Burris testified, Your Honor, when I asked him, okay, so there's a provision in Lease Amendment 2 that describes surface damage payments that are to continue until such time as lessees have restored the surface use of the land to its original state and condition, and the use of the surface thereof restored to the lessors. Do you recall that provision? Answer, that sounds familiar. Yes, ma'am. Question, how does San Miguel determine this condition has been met and surface damage can stop? Answer, so there's another provision in the lease that speaks to a maximum of surface damage payments. I believe it's $500 or market value of the property. So that's another item to consider. So we would evaluate first all of the property. If all of the property has been restored, has been planted, and the peelers have regained use of the property for cattle grazing operations, and we would consider that complete and stop surface damage payments. We would also stop surface damage payments that we did reach the maximum amount that's in the lease, either $500 or the market value of the property, or we would reach stop surface damage payments if we achieve phase 3 bond release. So that's really all. And Mr. Schick interrupted. That's a lot of criteria that applies to that decision to stop making payments. Question. Do you keep an analysis written somewhere of how you've made a determination to stop making the surface damage payments? A, no, ma'am. And we appended other testimony, Your Honor, from the various fuels managers who both testified whose job it was to calculate the payments. And they both testified they never had any training in how to determine what was due. And they actually disagreed over what acreage required loss of use payments. When San Miguel undisputedly failed to track the payments due to the peelers under the leases and had the unique knowledge to do so, the peelers cannot be presumed to know more than San Miguel. Nellie Frisbee testified that surface damage payments were due until phase 3 bond release was achieved on that acreage, no matter whether the peelers were grazing cattle, which means the payments have been insufficient. San Miguel also failed to negate the peeler's fraudulent concealment exception to the statute of limitations. Because evaluating fraudulent concealment requires inquiry into disputed facts, as does the discovery rule, including whether San Miguel provided the necessary information to the peelers to allow them to calculate and verify the accuracy of the loss of use payment, which both the current and former fuels managers testified they did not do. San Miguel cannot meet its summary judgment burden to negate fraudulent concealment as a matter of law. San Miguel cannot conclusively prove it did not fraudulently conceal material evidence, and it has not even attempted to do so. San Miguel has provided no evidence showing that the peelers had the information necessary to calculate the proper loss of use payments, or that San Miguel provided them that information. And in fact, San Miguel can't even explain how it calculated payments and has no way to track them. Because San Miguel has failed to establish when the peelers' claims regarding unpaid loss of use payments accrued as a matter of law, and they cannot overcome the unambiguous Texas statute making limitations unavailable as a defense for a party who initiated a lawsuit, the peelers asked the court to deny the motion for summary judgment in its entirety. Thank you.
Briefly, Your Honor, if I have a moment.
Yes.
I didn't hear any discussion of Shell Oil versus Ross, the case we put up on the screen. And it's because, again, the peelers can't get around it. There's no fraudulent inducement here. Counsel's arguments about how one field manager said something, Nellie Frisbee, and Dave Burris said something else, it actually goes to my exact point. When you assert claims to 1989, you're not going to have good records of what you've done that long ago. I mean, Dave Burris was in elementary school in 1989. And with regard to the 16069 claims, Your Honor, the Freeman case, both the plaintiff and defendant were arguing over the same contract. I agree there's not a case exactly on point, but I also agree there's nothing quite like this, where the policy of 16069 is that San Miguel couldn't lie behind the log and allow the peelers' claims to expire and then file our lawsuit. But there was no lying behind the log. We got a letter saying we were going to be evicted. And certainly we weren't waiting for the 1989 through all those years to expire. On its face, this claim is ridiculous. I'll go that far to say that the fact that they are hitting my client with this much interest and this much money, $6 million for payments back from 1989, it demands action, and I would ask that the court grant the motion.
All right. Anything else from either side?
No, thank you.
Okay, and what day do we have? Oh. What day are we supposed to be back next week?
Next
we have
Tuesday,
a
Your Honor.
hearing on
Next
Tuesday
Tuesday
and
and next
Thursday.
Thursday.
Okay. And after that, do we have anything else for a while?
Not for a while, Your Honor. I think the parties have to wait until April for the next hearings.
At
We
least.
should have a mediation between then, so maybe we'll get it all fixed.
Okay.
Judge,
Yes, ma'am.
just a reminder, I will be out Tuesday. We have somebody.
Okay. All right, that's fine. Okay, I will see y'all next week then, if that's it.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.